call the meeting to order on January 25th at 8:32 a.m. Welcome, everybody. The first order of business is to review and adopt the minutes from the October 5th meeting. Do I have any questions or a motion?
Motion approved.
Second? Second. All those in favor? Aye. Opposed? Okay. Second is the office administrative update.
So the main thing we have for today is just the budget summary that Lee has prepared. And you can see, as usual, we've given you the expenditures year to date, what we're projecting and what the remaining amount is. We do have some funds that rolled over from last year. Back when we were with Sam Houston, we weren't allowed to carry funds over from one fiscal year to another. One of the benefits of having moved to Article 4 is that we have the ability to use what's called UB, unexpended balances, so that's reflected there. One limitation though, we'll get to this later in the conversation about licensing, is there are limits on how and when we can spend our licensing related revenue. We're limited to only $70,000 in this fiscal year. The Office of Court Administration is trying to get us the ability to have access to all of the funds that we collect, but we'll have to see how things go this legislative session to assess whether that's going to be possible. So anyway, that is all reflected here. Does anyone have any questions about the budget information that's in the board booklet?
Okay, the next part would be the pending complaints and self-disclosures. Mr. Daniel?
Yes, sir. Dr. Nard, the Complaint Disclosure Committee met yesterday at 3:30 here in this room. And as you know, they're the most efficient committee in the Forensic Science Committee. Probably the hardest working.
Self-proclaimed as well.
Only
Is that a motion that we can?
No, there is no motion.
No second.
Pat Johnson was here and Dr. Drake was here, and we sifted through 19 matters, and I think I can do this in less than 90 minutes. We'll certainly try. First case is a holdover from the October 5th meeting. It's case number 1839. As y'all recall, it came from DPS Garland. They had outsourced some analysis to MMS, and lo and behold, it never arrived or got there. There was some spillage in connection with the packaging. We had reviewed it in addition to the information we received back in October, and we concurred with the staff's recommendation taking no further action by additional efforts. I want to make certain that everybody knows Pat Johnson recused himself in that particular matter. So that's prepared to recommend to the commission this morning.
We did receive additional materials from both NMS and DPS Garland between the last meeting and this meeting. And James Nichols is here. He's the laboratory manager for Garland to answer any questions. I'm going to try to summarize what I think the ultimate conclusion is the best I can, and then James can help me if I get anything wrong. But essentially, at DPS and Garland, they have a particular section where they stage, essentially scan items before they're going to be physically placed in packages to go out. And there's a specific section for NMS, things that are going to NMS. And these items were put in that area and then put into the boxes. So they were scanned to the area, then placed into the FedEx boxes. They went to NMS. When they got to NMS, there was spillage in one of the boxes. So NMS had to contend with that, cleaning that up and so forth, and trying to make sure that it did not affect any of the other material, evidentiary material in the box. They had to repackage at least one item, and it was an item that was adjacent to the one that ended up, that they can't find. And so there's some questions still about what happened to the material. It could have been inadvertently thrown out. Nobody really knows what happened. There's no definitive conclusion conclusion. But both NMS and DPS and Garland have spoken extensively to try to make sure they understand each other's processes better, and that they're putting things in place to avoid this happening in the future. I think one of the issues was that NMS had not let DPS know that they were missing the items until I think about a year later or so. So NMS looked at that communication issue, and you see all of that in your materials. So I don't think we have a definitive answer about what happened, but we do know that they're talking about better understanding how things get shipped to avoid that in the future. Is there anything either from NMS or from DPS that you want to add to that?
I think that summarizes it.
Anything else?
Nothing for me.
Okay. Hi, Dr. Lipton.
Okay, so the recommendation is that no further action is needed. Is there any further discussion? Is there a motion?
So moved.
Second?
Second.
All those in favor? Opposed?
Which would bring us to our next 6 self-disclosures that have been coming to the office since October 5th. The first matter is a self-disclosure from HFSC. It involved a latent print examiner who issued an APHIS report, essentially under the wrong forensic case number. I guess the most problematic aspect of it was there was not detected or corrected in the review process. It's been reviewed by staff carefully. In our committee review yesterday, we were satisfied with staff's recommendation, no further action. In light of the corrective actions being taken, I think there were also some revisions to their operating procedures and case review. And that would be our recommendation to the commission.
Okay, is there any discussion? Okay, is there a recommendation for no further action?
So moved.
Second?
Second.
All those in favor?
Aye.
Opposed?
Which would bring us to our third matter of self-disclosure 18.48 came from DPS Lubbock, from the Hale Center Police Department toxicology section. There was a blood kit that was, lack of a better statement, simply lost. And it looked like the efforts to retrieve and locate the sample were diligent. Fault review and other attempts, it never surfaced. We believe the explanations were satisfactory. And after Pat Johnson recused himself yesterday, we come forward with a recommendation to the commission that no further action in light of the review of the attempts to retrieve missing evidence.
Can I make one comment, which is the head of quality for DPS system, who's here, Kathleen Sanchez, noted to me that they have preventative actions, additional ones in the works, both for this instance and for the Midland seized drugs issue that we're going to talk about in a few minutes. So I think the suggestion from staff would be that for both of those, no further action is required, but we'd like to receive the additional update on once those issues get worked out. Is that accurate, Catherine?
Yes, ma'am.
Okay, thank you.
So there's no need to wait for that. So the recommendation is no further action. Is there a motion?
Motion.
Second?
Second.
All those in favor?
Aye.
Opposed?
Which brings us to our fourth matters, case from 18.51. It's a self-disclosure again from DPS Lubbock. Incidents involving seized drugs. There were actually destroyed by accident, mistake, or otherwise. We had, staff had done a very good job as far as review of all the materials responses. I don't believe there's any testing done in the actual samples, so it was unknown. But we had come out of our committee with the recommendation, no further action, conditional on a report from DPS Lubbock back to the commission regarding some review of their destruction log review. And rather than just allow it to sit, we'd like to go ahead and take no further action conditionally.
All right, with that in mind, is there any further discussion?
When would the results of the destruction log review, how long do we think that'll take? Don't know.
They've actually done it. They've done it, we just got an update on that, and there were no additional discrepancies noted, is that correct, Kevin? That's correct. So they actually are done.
Well, then let's not make it conditional, let's make it a actual motion for no further action.
All right, so the motion is for no further action. Is there a motion?
So moved.
Second?
Second.
All those in favor?
Aye.
Opposed?
Which would bring us to the fifth matters, case 1852, Twin Cities Youth Forensic Science Center. It was a little bit interesting. We had a crime scene investigator who, utilizing on the light source in violation of HFSC policy, there were some other issues with her own ideas at times prevailing over the lab. She has since been terminated. We spoke at length with Dr. Stout yesterday concerning the issue and corrective action taken. We were satisfied with that. We are recommending the commission no further action, but we wanted to, I guess, qualify that with a letter of return that indicates that the commission, at least what they saw, what we found, would have constituted some form of misconduct. I would actually make that.
So HFSC disclosed this as an act of professional misconduct, the use of the individual's personal alternative light source and standards brought from home. So the recommendation, I think, is that the committee concurred with that assessment.
Was there a lack of resources or did
Dr.
they
Stout,
decided to bring this?
His question was there lack of resources is the question.
No, we provide an authorized ALS. Actually, we have multiple kits that they have available and multiple controls that are validated controls that are available.
This wasn't the exact same type of equipment. This didn't meet the same standard that you use.
No, it did not. It was a single wavelength flashlight. The sources that we provide do multiple wavelengths. And in the SOP, it states clearly that we provide ALS controls.
the other issue that I think is sort of critical is that even using the personal light source, there were items that when they went back and looked at them, fluoresced, that she had called negative. So that's significant in terms of whether the work was actually performed or not. And those are going through, is this, Peter, you had just sent an email update on this. I want to make sure I'm understanding it correctly. Those have not made it through DNA analysis at this point.
In the two cases that we had on this, there was other DNA evidence that came from sexual assault kits. So we have not processed the evidence that the CSI collected for DNA yet. That we'll still see. The cases are actively being investigated. We may get requests to do DNA testing on the evidence that the CSI collected, but there was DNA that came from the sexual assault kits in both cases. If that makes sense.
Lynn, is there the language that's proposed regarding the commission sort of affirming that it appears to be misconduct? We've never done that before. Does that present any issue for us in terms of our policies and procedures? Typically, when we make that determination, it's post-investigation, and we establish the panel. Are there any issues that we need to be aware
So
of
we
there?
did do that for an HCIFS disclosure. Is Mickey here? We did do that for one recently, where they disclosed an act by, or failure to act, I guess, by the analyst when she didn't do the microscopic exam on marijuana. So we did affirm in that case their disclosure as professional misconduct. And the significance of that now is that if that analyst were to apply for a license to work at another laboratory, that license would not be approved because there's a standing finding of professional misconduct.
But the policies and procedures don't prevent us from doing that, so
No.
that's good. Okay.
Okay, with the actions taken by the Houston Forensic Science Center, the recommendation is that no further action is needed by the commission. Is there a motion?
So moved.
Second?
Second.
All those in favor?
Aye.
Opposed?
Which would bring us to our sixth item, it's case 5-6, it's disclosure made since October 5th from the DPS Midland lab. It was in the laboratory's drug section where a sample of 0.13 grams of cocaine in the case was missing. The background was the analyst had been moved from 1, 2, 3, 4 different locations over the previous year for space, and we're pretty satisfied the lab made every effort to try to locate the sample, including somebody going into every trash can and dumpster. I'd love to meet the guy that went to the dumpster after 0.13 grams. That's not funny, but
They did that.
It's a tiny, as Dr. Drake explained to us, it's a tenth of a sugar packet, so I don't know how you go digging in the dumpster for that. They tried to find it.
But it's our understanding that the lab provided there's been relocation of the analysts to their workspace, and hopefully we keep that from happening again. So the recommendation from the committee, following Pat Johnson's recusal, was to take no further action on the disclosure given the corrective action. I make that form of motion.
Second? Is there any discussion? All right, all those in favor?
Aye.
Opposed?
Which would bring us to the seventh item, is case number 19.3. It's a self-disclosure coming out of DPS Austin. It involves our own staff. DNA evidence was excluded during the pretrial evidentiary hearing due to alleged incident of a policy violation that surfaced during the testimony. Because it involves the commission staff, Ms. Garcia made a I consider a very appropriate recommendation that perhaps we secure an outside panel to review this. Since it involves courtroom testimony and courtroom activity, it might be good if we had somebody with a law license at the table. So we had come from our committee meeting yesterday with a recommendation to the commission that you consider a outside panel consisting of Don Boswell, Tarrant County District Attorney's Office, Mike Coble from UNT Health Science Center, and Christina Kapp also from the UNT Health Science Center to review the matter, investigate the matter, and make a recommendation to the commission.
And I asked, two of them are here today, and I had asked whether that would be something that their schedules would allow, and I don't know if Sharon Wilson is watching, but thank you, District Attorney Wilson, because she said that it would be okay for Don to participate. Also, Don has been through A&AB's root cause analysis training program. I even have the certificate, which shows just how much of a nerd she is, as we pointed out yesterday. So I think that between Don and Dr. Coble, who's also here, this particular self-disclosure involves the use of StarMix, which is the probabilistic genotyping software that DPS has moved to and that other laboratories are in the process of moving to. And Dr. Coble is one of the foremost experts in the world on probabilistic genotyping and StarMix in particular. And Christina Kapp has that sort of running a laboratory that is accredited under ISO standards and so forth, and she's also very technically proficient in this area and has testified in many cases. So our thought was that that would be a good panel. They're also physically located near each other, so it would not be hard for them to meet. It wouldn't be such a burden as if we had people spread out all over the state. So, that was a
And also
suggestion.
asked them if they were willing to do it.
And they said yes, for no money. So there's that too.
You get to teach them school.
Obviously, though, we would pay for any travel expenses and so forth. But free is good. So we're grateful for them.
So that's the committee's recommendation to the commission.
So the recommendation is an outside panel, and Did you make a motion on that?
Yes, I will, and
So we
I'll
talk about
elaborate.
recusing. I'm going to recuse
Okay.
myself. Guess me, you're,
Well, I'm not going to
we
look
don't
at it
vote
at
on
all.
this either.
But with the panel, the motion will be amended to include a panel of Don Boswell, Mike Coble, Christina Capper.
Okay.
Recuse from the vote.
That's a motion.
Is there a second?
Second.
All those in favor?
Aye.
Opposed? Motion carries.
And then we have two complaints that were held over from the October 5th, 2018 meeting. The first is 18.25. It's a murder case out of Belton. Has some years behind it, but it's a complaint by Rob Keller. The defendant is Chance Keller. There was an allegation concerning DPS Austin and DNA testing on full locations not being done in terms of their particular weapon. When the staff drilled down and sought to review this further, it's fine, there's not any of the review that would have any impact on the case or the results. There were some statements and confessions in it, separate and apart from any genetic testing. So the committee reviewed the complaint yesterday, part of the staff's recommendation to possibly dismiss the complaint. If there's any quality issues identified in the case forward to DPS, fine. It doesn't appear it would have any impact on anything.
So DPS is looking into some of the issues that were raised in the review of the case folder that Bruce had looked at, and so had Jody at a certain point. And they're looking into that system-wide, but it doesn't impact the results of this particular case. And furthermore, one of the things you had asked was for Bob Wyckoff to take a look at his case list and also whether they would ask for a recalculation of the mixture based on the publicly available information. And Bob looked at that and said, no, this would not be a case where we would ask for recalculation of the mixture due to the other overwhelming inculpatory case facts. Also, Skip Reeves, who represents Mr. Keller, let us know recently that a Chapter 64 request for post-conviction testing was denied in this case, presumably for similar reasons, which is a materiality assessment, did not lead the judge to believe that additional testing would change the outcome. So that's where we're at with respect to this particular complaint. I do think Brady Mills, who's not here today because he's traveling, but he's committed to following through with the other issues that were raised at a system level. And you're familiar with that effort, right? Okay. So they are working through those issues. It's just that for this particular matter, I don't think it should just hang out on the agenda for forever. Dr. Badoli, did you have any other thoughts?
All right, so the recommendation is to dismiss the complaint.
Yes, sir, I'll make that form of motion.
Is there a second?
Second.
All those in favor?
Aye.
Opposed?
Which brings us to our ninth matter. This is the FedEx case. Tyler Flood's a full-time lawyer. He used to do a lot of flood cases, and I guess he does so many, he gets some interesting items of mail, but the summary had a reference that it was drug evidence. There's actually a legal system that opens up the FedEx package one day and there's somebody else's blood in there, which was simply misdelivered by DPS to this office. Embarrassing it is, wrong it is. We're satisfied that DPS has reviewed the circumstances, taken the corrective actions necessary. I don't know what else we can do except look at it, hope it doesn't happen again. So they reviewed it carefully and brought a recommendation to the commission to dismiss the complaint and send a letter to Mr. Flood that explains all that had been done.
They used to be able to send things to print labels at the same time, and now they have a measure that does not allow that to be done. And they also, I talked to Brady about, well, is it possible that there are other print setups in other regional labs that run the similar risk of sending two things at once and having someone pull the wrong label? And he said they've talked about that. They actually do I didn't realize this, but they do a system-wide managers meeting after every commission meeting and talk through all of the items that were discussed during the meeting. And that was one of the ones that they talked about, to make people aware that they shouldn't allow folks to send things to print at the same time because it runs the risk of someone under, time pressure to get things out the door grabbing the wrong label. So they've done some things to address, to prevent that from happening in the future.
Sounds like that was kind of fortunate in a way of occurring so that they could evaluate the process to come up with something even better. All right, so the recommendation is that we dismiss the complaint and send a letter. Is there a motion?
So moved.
Second?
Second.
All those in favor?
Aye.
Opposed?
Which will bring us to our last 10 legal complaints which we received since the October 5th meeting. The first was case number 1842, is a complaint by Tyrone Richard. And in the summary, there's a misprint. It all involved a probation matter that he's alleging his probation officer withheld some urinalysis result records of negative drug tests, possession of cocaine. The interesting thing is this wasn't the court case. This case being used as an enhancement in a subsequent case. It was actually a presumptive test that the probation office had done, for which we don't really have jurisdiction. And then the lab was provided the information that said we've never seen this sample or done anything regarding this sample, so it's a mistake. And I have sincere questions whether we even have jurisdiction on that presumptive within the probation department. But, so the recommendation of the committee was to dismiss the complaint for failure to state a clear allegation of negligent misconduct.
All right. Is there any further discussion? Is there a motion to dismiss?
I make the motion.
Second?
Second.
All those in favor? Opposed?
And just to be clear on the law, we do not have jurisdiction expressly over presumptive tests performed for the purpose of determining compliance with the term or condition of community supervision or parole and conducted either by or under contract with the Community Supervision and Corrections Department or the Parole Division of TDC or the Board of Pardons and Paroles. But that's presumptive tests. Confirmatory is a different question. But it sounds like in his case, it was a presumptive test that was used. We are going to write him to let him know all of this.
Well, our next case has a similar issue. In this case number 1843 is a complaint by Tommy Davis. It goes back to 2004 sexual assault matter. There was a sexual assault nurse examination done. There was some, I guess, dispute or credibility issue between the sexual assault nurse examiner and the complainant's mother. There was a contrast to what they say actually happened. There was an allegation that Davis was saying something happened in the sexual assault nurse exam that gave rise to the injuries. And frankly, it's really a credibility determination. There's courtrooms that do that, not forensic science commissions. I also have a serious question as to whether we have jurisdiction to make such a credibility determination. So it's the recommendation by the committee to the commission that needed to be dismissed. Number one, for failure to state a credible allegation of negligent misconduct, but also the jurisdiction issue.
Do we need to take action on 1842 before we do this one? We discussed it, but we didn't vote.
Yeah, we did.
Yeah,
We voted before Lynn started talking.
Oh, okay, I
Oh, we
apologize.
did, I'm
Yeah,
sorry.
Arlen's new.
Can I have a
Nancy
clarification
seconded.
on 1842 then? Is that dismissal because of the lack of allegation of intentional misconduct, or because of the jurisdictional issue you just brought up? Because it could be either, really.
It's really both.
Okay.
We're going to explain to him that he hasn't named a lab that has any record of having done any forensic analysis with respect to him.
So it's
And
jurisdiction.
secondly, that, because we checked with HCIFS and we checked with HFSC, and they did not do any testing with respect to what he's complaining about. And then secondly, if what he's complaining about is just a presumptive urinalysis, we don't have jurisdiction over that. If, Mark asked us to tell him, if you figure out who you're complaining against essentially, and it's someone we have jurisdiction over, then we will reconsider, but there's nothing we can do with it.
Right, I just wanted to clarify that it's jurisdiction and failure to state the allocation.
Okay, back to 1843. Recommendation is dismiss the complaint. Is there a motion?
So moved.
Second? All right, all those in favor? Opposed?
The next matter is our 12th matters case number 18.47. Jacob Mediano is the complainant. He was, Dr. Billy may want to recuse himself on this.
Yes.
Concerning UT Health Science Center, they failed to follow the protocol paternity analysis case. It's a little bit interesting. The case is pregnant his 14-year-old niece, I think it was. They had a child. The child named the baby after him. There was a review by the staff. They didn't find any indication of irregularity in the work performed by the lab. It appears to me that other evidence was overwhelming and compelling. So there's a recommendation of the committee to the commission that be dismissed. There's no indication of irregularity in the lab work.
Okay, the recommendation is dismissal. Is there a motion? Second? All those in favor? Opposed?
Which brings us to case number 18.49. George Sharman is a very fine lawyer in San Antonio, does a number of DWI cases, and he is complaining against DPS Austin. Pat Johnson recused himself for this. His complaint is he was denied requests for copies of blood alcohol control data charts, back injection data, and that data included matters for two of his clients in violation of their own self-disclosure policy. DPS responded that the data he was requesting simply didn't exist. I believe staff reviewed that carefully enough that they were satisfied that was the case. And I think part of what we're going to recommend is dismiss the complaint, but also provide Mr. Sharman with a written explanation from DPS as to the resolution of the matter.
I mean, the main issue is if we start trying to mediate disputes about discovery, then that's all we do.
It's almost out of our jurisdiction.
And we just can't. I mean, there's, as part of their accreditation requirements, there is certainly an obligation. But here, I think the memo that DPS created about what they would do, when and why, and some changes in the policy, I think we should forward to the attorney, for sure. Do you have anything you want to add?
No.
All right, the recommendation is dismissal with information provided with an explanation by DPS to the attorney. Is there a motion?
So moved.
Second?
Second.
All those in favor? Opposed?
Which brings us to case number 18.50. It's also another complaint brought by Mr. Sharman. It alleges blood alcohol batch results included for his client were not really done in a scientific manner. He made fairly short work of this. We decided Dr. Kerrigan does not have near enough to do. And we want to give her more to do. So we would want to refer this to her review, and maybe bring it back to the next meeting following her work and opinions.
Well, I had reviewed it.
You've already reviewed
I
it.
did. I mean, my feeling is, and it's all in the board book and material package, but I believe that they've adequately responded to the issues. I mean, essentially, it was a cracked vial, it was a blood control, which had insufficient volume. And there are a number of issues in the complaint that are opportunities for improvement, but this is not worthy of an investigative panel or further work on the part of the commission. The response from DPS addresses why they couldn't do what was suggested during the hearing, which would have been inappropriate. The results were within, I think, 2% of each other. They were within the uncertainty of the measurement. So I don't think that there's anything for us to deal with here.
Should we send this email to Mr. Sherman so we can see? explanation.
Yeah, that would be appropriate. But I'm not sure that there's any more that DPS could do. Probably there's some corrective actions as a result of some of the things that were identified that weren't in our packet, but I think that might be the only thing that could be a follow-up.
So I asked Brady about QIs related to this incident, and I don't, do you have any? I don't think
We
so.
didn't do a
because-
corrective action because the control in question is not required by policy.
That's right, so the
So there was a cracked vial with a different control, which resulted in a third run, which would normally only have 2 runs. In the third one, we had a problem with the blood control. And we reran it under the same calibration on the next day. And I think the judge wanted us to run it under a new calibration, which would have been scientifically invalid.
Yeah, so there's probably some lack of understanding during the hearing. Somebody didn't explain to the judge why that couldn't happen, but the SOP does not require the whole blood. They do that, and that's considered best practice, but it's not required. So the failure of the whole blood control did not invalidate the run. So I don't think that there's anything for the commission to deal with here, other than probably DPS providing some more guidance to their examiners on what to do when there's insufficient control, then not run it and not include it. And obviously it wouldn't get logged in the control log, which was one of the other issues that the attorney brought up.
So what response would we provide to him for that?
Well, they've
I mean, not the
provided-
motion, I'm talking about, you're saying provide him some further information.
Well, in our packets, we've got the response from DPS, so. I
And
think-
just provide that on
I
the-
think so,
okay.
yeah. I mean, that resolved things for me satisfactorily.
Okay, so initially this was deferred to Dr. Kerrigan, who's already reviewed it, and her opinion was that there's nothing further for the commission to do. So is there a recommendation is there a motion based on her response
I'll make the motion,
to,
dismiss the complaint and provide the DPS response.
is there a second?
Second.
All those in favor? Opposed? Okay.
Which would bring us to 15th matter, case number 18.53 is a complaint brought by DNA consultant Michael Spence. His allegation is that there's a forensic biology test in a case involving Sam Spencer, which is a fast forward will appear in our 19th item. We'll talk about that when we get there. That certain results were not obtained by Westlaco DPS analyst Vanessa Nelson pursuant to policy, and that her professional integrity should be called into question based on a prior incident when she was employed at the police department. So I think the committee had thought because of the analysis necessary, might refer that to Dr. Badoli. I think you agree to do that, yes, sir?
I volunteer. I'm going to be more efficient than your committee, though.
I don't know how that's possible.
No, I looked at the case, and the case sort of, there's a lot of superfluous stuff that has nothing to do with forensic science and his allegations, so I didn't address any of that stuff, kind of forensic science, and it breaks down to basically 2 issues. One about presence of sperm, the other is contamination. So the allegation is in the reports, and DPS does multiple reports. So if they do serology, they issue a report on serology. Then they follow up with DNA, they issue a report on DNA, and if there's more samples to compare, another report. So there's 4 or 5 reports in this chain. And in the first report, the item of interest is the one that cannot exclude Mr. Benson as a contributor. And on the report, it says no detection of sperm. And the subsequent report says no detection of sperm, and so forth. So according to Mr. Spence, this is the imaginary sperm sample that would tie him to the case. In the case notes, there is detection of sperm. So it's listed in the analyst from the beginning. So I think what's happened here is this is the problem of having boilerplate formats. People do that, they put it in, and then you lose sight of what's going on, it just gets followed through. And the tech review process failed to detect it. So my recommendation is DPS should look into the tech review process But there is evidence that sperm is there. The type of analysis showing up in the sperm fraction, epithelial fraction, supports that sperm was there. So I don't think there's a basis to suggest that somehow there was no sperm and some malfeasance or some other sample mix-up occurred to create the sperm. The second allegation is that there could be contamination. Now, saying there could be, there's no evidence for it, is based only on the fact that the known reference sample was extracted before the evidence sample and then through the process. Typically, most of the time, we like to do the evidence first. No. Besides the SWGDAM recommendations, who are silent on whether it should be done first or second, just separate. And the way it's set up in the lab at EPS is 2 different analysts did the work. One analyzed the known sample, one analyzed the evidence sample of interest on different benches at different times. So the known was extracted on, let's say, October 15, 2014, while the evidence was extracted 2 days later. So there's a time frame there. Then the quantitation starts on the 17th, the day that the one is starting an extraction. So really getting the contamination from 2 different benches, and that doesn't seem likely. And his allegation is it's also in the process of one amplification where you can create a lot of copies. And that application starts on the 20th for the known and the 22nd for the evidence. They have robots, and one robot right next to another does the extraction, and one robot sets up the amplification. The amplification then is sent to another room before it's opened up. So the amplified product can't get the contamination in the original space, where the alleged allegation would be that there's an overlap for contamination. So although they're in a similar time frame, they're not really in the same space, but the amplification product is in another space. So it doesn't support that this is a likely scenario that the evidence sample somehow sat out, maintained its integrity for several days on different benches, somehow got back into the same tubes, and those 2 wells and no other wells and that. So, it's not really a reasonable explanation, so it doesn't support that there may be contamination. I mean, generally I would recommend doing knowns after the evidence, but I don't think it's an absolute if you have a good workflow. So I don't see that there's any evidence for his allegation, both for the sperm or that. We just would recommend DPS to look into their protocols for how to handle knowns and evidence generally, or document better this, but tech review, I think, does need to be looked at a little in this case.
So, Dr. Fadoli, the red flags that you would look for in a carryover contamination case are not present.
No, I don't see any evidence for that.
So was the first report, or the first topic you talked about, was that do you know if that's a drop down and they clicked the wrong drop down for a report, or?
I can't say for sure what it is, and all I can say is that the notes have it in there and the report doesn't have it. And I'm guessing on the 2nd, 3rd, 4th reports, no one actually looked back at those, because you're now in the 2nd, 3rd, 4th, you're focusing on whatever was the issue that generated the 2nd report. So whatever happened in the first one where it got missed, probably a drop-down menu or something, just carried over after that because no one would be looking for it.
And have they issued an amended report on that?
No, just finally when it went to trial, that's where everything was brought out. And I read all the transcripts. All this that was discussed was brought out at trial. All sides were open about it. It was presented to the jury, so everybody was aware of all the issues.
Is there anybody here that can talk about whether there's a drop down?
Do y'all know how those reports get generated?
No, I don't think anybody here is familiar with the current report.
Because I think the
It kind of depends
question
on how
is
you build
what-
your LIM system as to
Right.
what you can and can't put in there or do.
whether there's a risk of missing things because of a sort of an automated process that.
It is automated where you enter your result and it pre-fills the report. I don't know the specifics of it, but like Dr. Badoli suggested, it's an automated type system. So you enter it incorrectly in the worksheet, it would go to the report. It should go to the report from the worksheet. So maybe the 10 isn't a
2014? I don't know.
I don't know about 2014. That was before I was reintroduced those reports.
The DPS haven't done the RCA on this. We don't have a quality incident report or anything to review on that. I mean, I see the response, but it doesn't look like the standard. It doesn't look as if DPS have finished their official review.
I don't have a QI on this
Yeah,
fence.
I don't think so.
So I think they're still looking into it. So I think on the tech review point
Yeah.
in particular, they need to do a quality.
This would definitely register as something to do again. It's probably not completed yet, or like Catherine suggested, but it definitely registers to be sufficient for one.
Yeah, so before we take action on this one, I think we need that documentation from DPS. So we may need to defer this one to the next meeting.
Or if you want to break it up into the two components of it and make a ruling on the second component and hold over, but I guess we can just wait for all of it at one time. So there's there's a discussion, is there a recommendation about carrying this over until we get a response back from DPS?
I'll make a motion to table it.
Table it. Is there a second? All right. All those in favor? Opposed?
To bring us to 16th case, it's 18.5 for claim brought by Brandon Morgan. He's alleging Harris County Institute of Forensic Science toxicologist delayed testing to secure some probable cause that led to his arrest and conviction for murder. Staff had reviewed it carefully, as did our committee. We're not real sure he stated an allegation of negligence or misconduct in reference to forensic analysis. It's actually a probable cause issue, so I don't know what we can do except dismiss the complaint.
So is there any further discussion? Is there a motion?
As a point of clarification as well, I think there may have been some misunderstanding on his part about when the test was actually done as opposed to when the report went out.
True.
So there wasn't in fact a delay, a significant delay between the time of the test. There was a delay in the issuance of the report because of, an administrative issue.
Okay. With that in mind, is there a motion?
I'll make a motion to dismiss.
Second?
Second.
All those in favor?
Aye.
Opposed?
17th item is from George O'Brien, alleges Houston PD withheld some fingerprint evidence that would have exonerated him and authorized use of motor vehicle case. We didn't see anything that would actually constitute an allegation, failure to state allegation of negligence or misconduct with respect to some forensic analysis. So the committee would offer a recommendation to the commission to dismiss that also.
You can't even really tell where the lanes will work. That's the problem, I think.
Mm-hmm.
Right, Dr. Stepp, I mean, ultimately, we don't really even know where those lanes were.
So we've gone back and we found a packet of latent left cards that are associated with this case that match the name. But that's all I know. We've not been able to find the original case report. I mean, this goes back into HPD records that are, shall we say, less than ideal. So that's what I know. There are, I think there were like 24 latent lift cards in that packet. No idea the quality of it, no idea. They could be
No report,
revisited,
though.
but that's it.
No report.
No report.
All right, so the recommendation was dismissal.
Yes, sir. I'll make that a motion.
Second? All in favor? Opposed?
And Dr. Menard, this next matter actually has a tangential to Swifts in it.
I'll review this, so just
19.01 brought by Robert Waterfield as law enforcement used fabricated evidence to obtain a DNA search warrant in his case involving probable cause. There's actually a legal procedure for that under Franks if there's some fabrication in the recitation that affidavit supporting the warrant. We reviewed it carefully. We did not really see an allegation of negligence or misconduct concerning forensic analysis. The committee's recommendation to the commission will be dismissed for the same reasons.
all right, any discussion?
So the Dallas County DA's office has said that, in terms of the case facts, that Mr. Waterfield was a serial rapist of the North Tech Dallas rapist when he was being searched for. He preyed on little girls. And someone was exonerated who was wrongfully convicted for a sexual assault that should have been attributed to Mr. Waterfield. So he's complaining about DNA that was taken in 2010 that was taken that showed that he was the true perpetrator and not someone named Mr. Brody, who had been incarcerated, Stephen Brody, for this offense. So, just to let you know, the Dallas County Days Office is confident that they have the right.
All right, so the recommendation is dismissal. There's no further discussion. Is there a motion?
I'll make that form of motion.
Is there a second?
I'll say.
All those in favor? Opposed?
Which brings us to 19th case, 19.02, complaint by Samuel Benson involving an HVA system in the Westonville DPS lab. It said it had been out of function for some period of time. Brady Mills has responded to things. Has had some issues with the heating and cooling, but there wasn't any contamination noted. And also they did place some coils in the previous year, which also had an impact on the testing. And I'm not sure the Forensic Science Commission needs to be reviewing heating and cooling systems. That's not funny. But if we want to expand our horizons with that, look into that. So
Probably some of the things will get expanded besides heating and cooling.
there's nothing else we don't address, okay? But, so the committee has come forward with a recommendation of the commission to dismiss that complaint for failure to state allegation impacting the results of forensic analysis, and that's primarily based on the response from DPS and Barry Mills that no contamination resulting from the HVA system.
All right, so the recommendation is dismissal. Is there any further discussion? Is there a motion? Second? All those in favor? Opposed?
And at our, we had 3 other matters that come in since October 5th, 2018. There were 2 complaints that were dismissed by staff and refer to the Commission's DNA mixture retroactive case review project. There's another complaint that was dismissed because it had absolutely no allegation of negligence or misconduct. We couldn't even ascertain who the laboratory was, and didn't really allude any complaint against, actually the complaint against an attorney in Sherwood, Texas. And we are a little absent jurisdiction on that, so that's simply a summary, and that would conclude the complaints and disclosures item.
All right, well, excellent job and excellent timing there, Mr. Mannion.
Thanks, sir.
His old business.
Yeah.
Could we take one item out of order, Dr. Bernard, which is Texas Association of Crime Lab Directors update, which usually gets stuck at the end, but
Okay.
I think Dr. Stout would like to give it earlier.
Yeah, I appreciate that. I've got, my wife's out of town, I've got kids we gotta deal with.
You sure you don't want to stay longer?
I don't know, 3 teenage boys, I kind of need to go rescue
You
the
might
house.
want to. If you want a house to come back to,
Yeah, I do.
probably should.
Texas Association of Crime Lab Directors met yesterday, as we do twice a year before, in conjunction with this meeting. Lynn provided a good update to the group. Mike was supposed to get there, but his flight was delayed, so one thing I did want to ask Mike about was, can we arrange, schedule with you a web presentation so that we can get that up there? I think it'll be important to the group. Thank you. I'll get with you to arrange that. Discussed with the legislative session coming up, there are about a dozen different bills that we've seen that have some implications for the laboratories, so I will continue to try and get input from the laboratories and work with legislators to help them understand what the potential implications are. We discussed some of that. We also discussed, and I will work on this over the next 6 months, actually forming TACLAD as a 501c3 or other appropriate actual entity. We discussed it for a while about getting a website for the organization, and that means we need some funds to be able to support that. Well, that means we need to run some dues. Well, then we need a bank account to put it in. So in order to do that, we actually need something more than 12 nerds in a room that call themselves a club. So we'll be working on formalizing TACLAD as more of an organization. Elise was elected as the new secretary, so Sue Howell will get that transitioned over, but Elise will be the new main contact point for a lot of communications and things like that. Yes?
Did you talk about rapid DNA at all?
Yeah, we did talk about Rapid. Rapid came up with the New York Times article that was out earlier this week. And again, there's an NPR media report that's going today. Same kind of concerns as we've discussed. Actually, this came up with the legislative aspects. We have seen one bill that was filed day before yesterday, I think, that looks like it's one of the legislative. So there's legislative changes that would have to happen for Rapid to be used for offender profiles to be collected at booking stations, like it's part of the federal Rapid DNA Act, and where FBI is working on the CODIS changes and the infrastructure that would be needed for that. There's also legislative changes that would have to happen. I forget the bill number for it. I fully expect there to be multiple bills this legislative session laying the groundwork for that. So when we were talking about that, we certainly were talking about Rapid, that I continue to be quite concerned about the use of Rapid for crime scene cases. Don and I have chatted about this. This still seems to be a driver out there of using Rapid. I think all of us are very concerned about the issues of the box itself and the software, certainly, but it's the handling of the evidence all the way up to the box and the potential for destruction, contamination, and loss of evidence that coming from a crime scene. There is no way to reproduce that or remedy evidence that gets destroyed there. So the potential for abuse and the potential for problems with that is large. So
There's several problems with concept and application are way apart on this.
Yeah, HPD has an Andy unit. Not one of the places where HPD and we agree on how this should be going about it, and I'll keep working with them. I'm actually meeting with Kim Ogg and the bureau chiefs next week to update them. And again, this was inspired by the New York Times article, discussed with Harris County DAs about my concerns. Because, I mean, I view this that even if they were running this, not with any intention of putting stuff into CODIS, it still is a forensic analysis for the purposes of the criminal investigation. That's got to be accredited, and the person need to be licensed. Otherwise, it could be excluded in court.
Do you have any information about the 18 swabs that they submitted from the sexual assault program at Harris Health to the PD using Andy?
Really?
Yeah, they
That's
had a
the
little
first
pilot
time?
project going.
I
That was
have-
a pilot, we didn't,
Yeah.
never got anywhere.
We never, so we
They
had,
said there's 18 samples, but they don't know, the forensic nurses don't know any results.
so I need to talk with you about that because, yeah, we had, I know Andy was not terribly keen on the 25-page agreement that I made them sign about our participation with that, particularly when it came to those sexual assault, but they never told me about those.
Okay. They have an IRB approved project, Harris Health, to do that, to test it out. They've done 18 samples. I will
Look at
just
my
say
face
from,
probably tells you, I'm not,
Okay.
this is not.
from my perspective as a sexual assault nurse examiner, and looking at the kit backlog issue, it's something that comes up. I just had a forensic scientist approach me at Texas A&M again about this. Why can't we use rapid DNA at the bedside? Because one of the biggest questions that patients have when they come in is, did anything happen to me? They think that we have magic DNA vision or something, and we can't tell them, and then we tell them it'll be a year and a half, maybe, until we get results, blah, blah, blah.
Right.
It might help them make legal decisions and healthcare decisions at the bedside, and so people are asking, why aren't we doing this? So I have to go back and tell
Can be
them
introduced
the
in
reasons.
court.
Yeah, well, I mean,
It's
it'd
inadmissible at this
screening
point.
tool.
Right.
be inadmissible.
But as a screening tool, as a healthcare
Right.
decision maker, as a legal decision maker, and the kit backlog,
So-
Yeah, but-
preventative, I don't know.
But I have a question. I mean,
Yeah.
in this study, I don't know anything about this, but are they taking swabs just as swabs and sticking them directly into the machine?
That's right. So what we had discussed with Andy was the collection of an additional swab and swabs that they were collecting. And that swab would be used on the Andy instrument.
Yeah.
And we would run the rest of the swabs so that we could compare the actual
And
results.
that's swabs collected after the,
As collected
Yes.
after all the rest of it. And I'm still amazed that they could get IRB clearance on that because you're basically asking a traumatized human for an additional sample.
They
And
would- they
I don't
would-
know what informed consent would actually mean at that
that
point.
wouldn't be a big deal. But I don't know what
Oh.
the consent.
But I'm just asking more from just a practical science point of view is, usually you get a vaginal swab, that's a lot of the female victim's DNA on it, and a small amount, in many of the cases, of the potential perpetrator's
Yep.
DNA. If they don't do any processing, the overwhelming female DNA should be that's all that's seen, so you'd be consuming evidence on something that...
And you would be consuming it because the instrument consumes that entire swab. So,
I'm just wondering how would they overcome that to make it useful in that situation?
I talked to Andy about that, and they told me that they were actually doing fractions. They were, the entry in the machine was supposed to be the sperm fraction.
yeah, that's what I had understood from them, is somehow they're fractionating.
I don't know how that's happening, but that's what they said
Some
was
sort of Y
happening.
quant.
So Dr. Downing, are you saying that in that pilot, they're taking the evidentiary
They're
sample?
taking evidentiary samples first, going into the kit, and then they'll take a third swab for the
I didn't know they
Andy.
could do that.
So the swab that they take is like a known, like a buckle, or they're taking?
Vaginal swab.
I gotta say, I'm more than just a tad disturbed that they've gone ahead with this.
I did not know you did that.
Thank you for raising it.
Yes, thank you.
Anything else?
Oh, I'm gonna have to go chew on that one.
Anything else, Dr. Stout, on the tactic front?
I think those are the things.
I know it's something that I think we're gonna discuss later, regarding our legislative committee, but is there value, considering the number of bills that are coming up, maybe having somebody from the TACLID as a liaison on that committee so that we can coordinate and speak with sort of a unified voice on some of these really important issues?
Sure. Dr. Stout, who's in charge of tracking legislation for you guys? Is that you?
Tracking legislation?
For the TACLID.
I'm sorry?
For TACLID, is somebody taking the lead on tracking legislation that affects? You are, okay. So will you be on our committee then?
Oh, I guess,
Or a
yes.
liaison?
Yeah, I mean, will you work with the,
Yeah.
okay.
Okay. So, back to number 4, which is discussion of the crime laboratory accreditation program.
So we had quite a bit of accreditation activity this quarter, so I won't go through each and every one of these. You have the documents in your materials, so if anybody has any follow-up questions, please just get directly with me, or we can help answer any questions there.
It's long. There were a lot of reaccreditations, an excruciating number. We did our best to summarize it in the memo, but just tracking DPS alone was a huge task. So any follow-up questions we're happy to entertain.
Any further discussion or questions? Is it ready to be clear?
Well, we need to go to little b.
Okay.
Okay,
I thought you
so,
were jumping the whole thing. I thought, wow, well,
no.
Mr. Daniel would be very happy about that.
So one of the rules that Lee has drafted would actually, for the first time, remove a discipline from the accreditation requirement, and that discipline is question document examination. And the reason for this is because if you look at our list of accredited laboratories, both those that are physically in Texas and those that are located outside of Texas, the only accredited entity that has question document examination is DPS. And DPS does not do work for defense, they only do work for the state. Which means that a defense attorney trying to get someone to physically examine question documents and issue a report cannot comply with 38.35 of the Code of Criminal Procedure. And that raises concerns about, foundational constitutional fairness concerns and questions about whether a defendant can actually properly represent himself in his own defense. If they can't comply with the law, then I think the only reasonable course of action for the commission is to remove the accreditation requirement for now, give them an exemption, and work with that community to determine whether it might be appropriate to create an in-house type, not ISO accreditation, but some sort of Texas-based accreditation checklist that those examiners could comply with. They could also be put on the list for voluntary licensure. That's another thing that we have the authority to do under our enabling statutes. There are things that we can do to bring that community into the fold, but I think requiring accreditation by a national body right now has put the defense bar in quite a pickle, because they can't comply. Yes, Pat?
I have spoken to legitimate document examiners, and they have huge concerns about private practitioner document examiners that don't know what the heck they're talking about.
Yes.
And so I would have great concerns about this proposal. I understand why you're proposing it, but I think it would be a dangerous thing to do.
I've heard from document examiners who've expressed grave concerns as well, because this is a discipline where there is a massive range between people who are competent and follow developed standards and people who are just kind of winging it. And I think that's an accurate assessment of what's going on, but I don't think we can overcome the constitutional obligation that a defendant be able to mount a defense, and we don't have a way, literally, for them to do that, because Article 38.35 of the Texas Code of Criminal Procedure is an exclusionary rule. It means if you cannot meet that rule, your evidence doesn't come in. And we already have an order from a court in Hidalgo County that allowed the defense witness to testify because of constitutional concerns. I completely understand where the concern is, and ideally we would not be in this position, but I don't even think it's an option.
Well, can a private practitioner document examiner not get accredited by ANAB?
It is possible, but they don't exist right now. And
You mean the document examiner doesn't exist, or they don't?
there's not a single accredited question document examiner that we know of that is not part of the DPS system right now, that is on our list. Now, I guess we could go out trying to recruit accredited document examiners and put them on the list, but I honestly don't even know how to go about doing that. And I think there's a real risk in the meantime that defendants don't have anywhere to go. And can the lawyers help me out with this? There is no place.
So they can get accredited, they just haven't got accredited?
So it is not easy. It is possible for a one-person outfit, which is what a lot of these document examiners are, to get accredited, it is just quite burdensome. The process is not really set up very well for one man or one woman operations. And frankly, that's one of the reasons why we moved to do a Texas-based type of accreditation for crime scene reconstruction and bloodstain pattern analysis for similar concerns.
Because none of the larger private labs perform document examination.
I mean, we've asked,
Are
like,
accredited in that discipline.
the ones that we know about, that we interact with, that do trace or other similar types of things, Microtrace doesn't do it. I mean, we've asked, and we're just not seeing options, and as it exists right now, there are none.
Are there places out of state that do question document?
Yeah, there are, but we don't have any who have sought to be accredited by our commission that are also accredited by one of the national bodies that we recognize. I mean, that's just the reality.
Any idea of volume?
I don't think it's a huge volume, but there are debates over wills, there are debates over, things, fraudulent checks, things like that come up from time to time. I don't know if you've had very many, Mark, but it's probably not frequent.
No, and I respect what Pat's saying. I don't think we should lose sight of the judicial role. They have the Kelly opinion. Has to be a valid area of science or analysis. The person doing it has to be qualified. It's had to have been done properly at that time. So I agree. There are probably people that may not know what they're doing. That becomes the court's role as far as filtering that and excluding that.
Wouldn't that advocate our role in any of these things, though? I mean, if they have to be accredited everywhere else, and they say, well, look, when we've had these debates on other sciences before, we've always said, we're under 3835, it has to be in an accredited body. We can make that argument about any of these sciences that we talked about.
But not really. I mean, you can make the argument that we don't need 38.35 and that the rules of evidence are the only thing we need. I mean, you can make the argument, but the difference between this discipline and all of the other disciplines that are subject to accreditation under 38.35 is that if the defense wanted to hire somebody to do work in any of the other disciplines, there are options for them, accredited entities that they can go to. The only discipline where that is not true is question documents. That's the problem. That's the crux of the matter.
But this just sounds bad, this recommendation, regardless of the legal side, because you're going to relax the standards on the government side because the defense can't get an option. There's got to be some way you can have the requirements for the government to still be held and maybe talk about some dispensation or something that the defense can reach out to. Anybody can go through whatever is the voir dire on the individual. I think that'd be a better option than this. I mean, I understand there's some legal thing, but this is reducing quality, that you still want to uphold the government at a higher quality in general, just through how they perform.
Or hold the defense to a higher quality, because you could send junk science into the courtroom on the basis that you're saying you don't have, well, there's nobody that's going to get accreditation.
So I think what we're proposing to do is a temporary accreditation exemption while we create a program that they can take advantage of, that we administer in-house, where they can achieve that accreditation, and then the requirement will kick in again. But I'm just gonna be really blunt, I don't think y'all have an option unless you want the statute to be overruled as unconstitutional.
How would it be, being that the defense doesn't have, but they can go the out-of-state labs or out-of-state examiners can apply for an accreditation. It may be burdensome, but they can apply for accreditation.
But a defendant right now who wants to hire an expert to examine a question document cannot do so and be in compliance with 38.35 of the Code of Criminal Procedure, which is an exclusionary rule, which means that even if they hire somebody who doesn't happen to be accredited, a judge under that statute has no option but to kick that out right now.
Clearly what you're saying is that in certain counties, they are somehow admitting that evidence.
Oh, it's being admitted, there's no question.
And then the question is whether it would be kicked out at the appellate court level.
Well-
Meaning that it's a no, the judge is wrong, that was,
What's happening is that it was getting admitted all the time because nobody was raising 38.35. And now they're raising it, the state is. And then the judge has to make a decision, and the defense's argument is, well, what am I supposed to do? I can't hire anybody because DPS is the only game in town and they won't work for me. They can't.
Are you saying that there are no accredited labs in the US accredited to do QD? Like ANAB doesn't have any labs that are accredited to do QD. DPS is accredited under them for QD, correct? Right, currently.
Yes.
So have we looked to see how many other QD labs in the US are accredited? So
We
there
did.
are options?
There really aren't. If there are options, the last time we looked, there weren't any or many. We can take a look at the break, but I mean, we can go out and try to recruit accredited labs to submit their certificates and do casework in Texas.
Yeah, because I mean, if there are some organizations that are currently accredited in QD, even if there are 3 or 4, it's fairly easy for us to recognize their accreditation, which would allow them to do defense work in QD in Texas.
Right, but the challenge is that for a lot of the people that are wanting to hire those labs, I don't even know if, I mean, they have not done any Texas casework yet. So we would be basically saying, you're gonna be available to do Texas casework tomorrow, advertise here. I mean, it just seems like a bit of a, we have never gone out and recruited labs to submit their certificates to come do casework here. This would be the first time that we are sort of trying to force that issue. I don't think that there are a ton of, I mean, you can take a look on their website.
Yeah, I mean, I'm not sure that, I think we really need to look and see how many accredited QD labs there are. I don't know what the answer is.
I mean, the last time we looked, there weren't very many at all, that aren't state, that would be able to do defense work.
I just don't think there are that many cases. We shut ours down years ago because there wasn't enough work to even generate the salary of the analyst.
Yeah, I'd say at DPS, it's declined over the years. I mean, you think now, mostly it was forged checks and forged legal documents, but, you know, nobody signs anything anymore. Everything's electronic. So that business has just taken off. Most of it was civil business anyway.
Yeah.
But
And the law doesn't apply in that context. It's
now,
just for
occasionally, we
criminal
would get a
cases.
threatening letter to a judge or to a governor or something like that, and that may still happen.
So ANAB has 35 labs that are accredited under QD, but a lot of these are like the Arizona DPS, the Bureau of Alcohol, Tobacco, and Firearms, Puerto Rico Bureau of Forensic Science, Toronto Center of Forensic Science. There are a lot of public organizations that,
Do you see any
just like
private-
DPS.
Right. Are
Texas
there any on that
DPS?
list that are private? Because I think if there aren't,
Quantico.
then
Florida,
you got Florida DLE.
Health Sciences Authority, Applied Sciences Group, perhaps maybe a
Health Sciences
non-governmental.
Authority
It's in
sounds-
Singapore though. Homeland Security, Honolulu. These
And
are
none
all
of them
public
will-
entities for the most part. I mean, I'm just scrolling through the list pretty fast, but they're all.
And so none of the public entities will evaluate for defense. So
We're just saying there's no private options available for the defense.
When some of the public labs take on this, if they're out of state, I think that's an option. I really don't like this idea of relaxing the quality standards for a discipline regardless of what the outcome is. That just doesn't Just really is,
Well,
But it may not feel good, but I just don't think we have a choice where it's a constitutional issue of whether the defendant can defend himself in a criminal action.
well,
We can
Is there-
temporarily relax it and then give
Yeah.
them, bring them into the fold by creating a program that they can
I just don't know
participate in.
relaxing is the right, I'd either say you don't do it until you solve the problem.
You merely suspend that.
I think we have no
Suspend
choice
it.
but to remove it from our list right now because of the constitutional issues.
well, what about
I think that
if we?
if you were to go to an out-of-state, to ask any of these labs and says, can you take on defense casework if it's sent to you and your lab can look at it, while we develop an accreditation program? You don't have to relax the standard. We're not here to we're not here to be the constitutional arbiter of that. The court can make that call. In the interim, if they are to say yes to that, we can keep our standard the same and develop a program. We can let TCDLA know so they can send it out to their members. If you have a question documents issue, you can send it to this lab. That way you have actual certified, not junk science people looking at the documents. Then they can also prepare a defense, and we can build up our accreditation to where we can have something robust, so these Texas examiners can then bring them into their fold.
So Lee and I could call all 30, what did you say, it was 35?
Yeah.
Entities on that list.
There's a lot of federal ones.
But if it's the federal government, if it's Arizona DPS, if it's, the ones that she's reading off, I can tell you without even calling them, the answer is gonna be no. That's not what they do.
Let
If
me
you
throw
call
out
Texas.
another alternative,
Mhm.
and I might get shot at for doing this. Mark's representing somebody on a criminal case, Jarvis is the prosecutor. If Jarvis is interested in that document examination being conducted by an accredited lab, Jarvis could ask the DPS to do this.
And he might, but the defense may not wanna rely on,
Well, then that's Mark's issue, and he can go find an alternative.
but he can't.
There isn't an
There is no
alternative.
alternative.
There's no alternative.
But we don't know if
They'll
there's,
testify to the
but
instructions.
to be fair, we don't know if the other out-of-state ones, like, we could make the argument that predictably, that they all will say no, but to me, it's a different argument. If we called the labs, they all said they wouldn't do it in the United States of America, as opposed to there's none in the state of Texas that will do it, and we don't think that the ones out of state will do it.
But if they are state or federally funded laboratories, I don't know of any that do work for the defense. They all have backlogs. Now, we just talked to Arizona DPS. They've got backlogs that they have to contend with. They're doing work for their own citizens.
Is
We
there-
can call them all,
Of
but
documents, have backlogs of documents?
no, but they typically, I don't know of any publicly funded, state-funded agency that will do work for the defense. Usually, that's not the way it works.
Especially for an out-of-state request, somebody.
I mean, it's just, would Texas DPS, if Oklahoma called you, a defendant, and said, will you work this because we don't have anybody? You wouldn't be able to do it. You don't even have a mechanism to accept the money.
Right.
Can Texas DPS massage their policy at all? If the defense says, I want you to look at a certain,
I think QD might actually have done work for the defense in the past with DPS.
Now, you're throwing in a wrench, Anna.
yeah. Because I know if there's drug
I'm not
testing,
sure, and I
that
don't
if
know
the
if the
defense wants
request
something
was filtered through
tested,
the
they can send it, they
prosecution.
can call
And
DPS
I could-
and have that tested.
Can a judge order?
And I don't know if it was
Yes,
10 years
a
ago or
judge
5 years ago.
100%.
DPS has done work for the.
100%, a judge can
Go
order.
to the judge.
Yes.
Yeah.
But Dawn, if the state is already getting the document examined,
Right.
they can't do it they're conflicted out. They can't do it for both.
I mean, it just depends on
Especially
whether
since
you
our-
had it examined there, or if you've used someone else.
Right,
And there are public labs that do work for the, I mean, I'm not saying DPS does, But for example, like, the medical examiner's office, they do work for the defense and for the state.
Right, but they
We may
don't-
not have sent it to the same place. They don't do that.
There aren't any QD. They have all phased out their QD sections. This is the problem.
So then if we suspended it, how long would it take you to put together a program?
I mean, it takes time. It's not something that you pop up overnight. You know? I mean, we could recognize a temporary license for them if they are not from an accredited entity. That's one thing we could do and have them start applying for that. But
We could do a voluntary license pretty
Yeah, I mean,
quickly.
that we could do, but, I mean, it takes probably 6 months to a year minimum. I mean, even a basic thing.
Well, what if we suspended it until you could confirm that no one will accept it? And then that then kind of forces the issue of having to do something in state. But there are no options.
Could you get
I mean, I understand what you're saying about state ones, but of the 35, are there any that are not state or federal government?
My concern is that right now, today, if a defendant goes to trial tomorrow, he cannot comply with the law.
But the other
But yeah,
option
if it's
is,
suspended right now, they would still be able to do what they're doing
Yes, sir.
currently.
We would
Right.
have to post the rule, and as soon as that took effect, then they would be okay. But right now, they cannot comply with what is an exclusionary rule. I don't know if I'm articulating
but
this.
the opposite of that is you are essentially lowering the standard for a defendant to put in something into court and essentially avoid justice on the basis of, well, there's nowhere I don't have to have any standard on it. I know if the state did it, they had to be accredited and go through this, that, and the other. But as a defendant, there you go. And I just don't know if that is the
The law would
option.
change for both the state and the defense. It doesn't apply differently. We would make an exception for the discipline, not just for defense experts. I'm not saying I like it, Jarvis. I don't. This is, the first thing I said was this is the first time we will have ever have done this, but I don't. And we have legal experts in the room who know what I'm saying. Like, we can't, the constitutional issues are real. We're not making them up. They're not hyperbole. They
And the
are-
check's still gonna happen at the gatekeeper level.
Yeah, but that was the same thing they said about blood spatter.
You know,
And we know what happens
Well, we
with
know
that.
that
I mean, we
it's not
can
ideal.
make that argument and say, let Katie bar the door on that. My argument would be, I would say keep it in place, and then let's make the phone calls to see if there's any other outside agencies, any other place would be willing to do that, or talk to DPS to say, is there a way or a mechanism where we can allow defense to use, to send their stuff to DPS or one of these outside agencies to be able to testify? We know that they're already accredited. Let's look and see and exhaust all the options first before we lower the standard, as opposed to lowering the standard because we think we've exhausted all the options,
And there's still a third option.
which is,
If the Texas, what do you call your defense bar?
Texas Professional Association.
Yeah, if they've got their favorite document examiners, 2 or 3 or 4 or whatever, those guys can go get accredited. If there's enough money in the business, they can spend the money, they can prep up and get accredited by ENAC. So that is, I understand you're saying nobody's done that yet. If I was gonna hang up my shingle and be a document examiner and I wanted all this Texas defense business, I'd do that in a minute. So that is a third option, even though, I understand, nobody's done it.
But until that exists, I'm not sure that we have much of an option here. And although I agree, it looks bad, lowering the standard, it doesn't look as if there are options based on the constitutional element. And I would suggest that even though we would be lowering the standard, I don't think DPS are going to say, oh, well, now we don't have to be accredited in QD. They still will retain their accreditation, let's hope. And so I think that will obviously go to the weight of the evidence in trial. So I think those are important things to consider. It's not as if the existing accredited, publicly funded lab is now going to say, oh, look, now we're exempt, we don't need this.
I
they
think
still
I
are
can-
going to retain their accreditation.
I can assure you DPS won't
Yeah.
drop their accreditation based on any decision today.
Are the document
It's not
examiners,
DPS, it's not DPS who work on it, it's anybody else who put out a
Right,
short.
but
And anybody else
meanwhile-
after this in any other discipline who says, well, yeah, there's nobody else doing it here, so why do I have to be accredited?
But we know they're gonna get in anyway, because they're gonna make the constitutional argument for
And
the
I don't know if that
judge.
constitutional argument is going to be ruled on, because I don't think, their argument is that this cannot be,
There's no access.
that there's no access to this, the judge says there's no access to this, and I don't know if the judge is doing the research or what the appellate court's going to say. So we're essentially trying to predict what an appellate court is going to do and what the Court of Criminal Appeals is going to do on that case. So they have to rule the statute unconstitutional.
I can predict that is a distinct possibility.
And I would love to see them go in and do that and rule the statute
Well,
unconstitutional.
I'm glad you would love
As
to. I would
opposed,
love to
as
see
opposed
that.
to then lowering the standard on the thought that they would. Because I don't know if they would.
I'm
It's a
more
real
favor.
Do we need an
risk.
AG's opinion on this? I mean, I hate
No.
for the commission to pass them
There's
up,
no,
but
we know
don't
what
need
the
it.
law is. We don't need an AG's opinion.
does DPS Lab have only one site that they do them, or they have?
One
It's-
side.
Okay.
I do have the policy, requests for defense attorneys will not be considered without a court order. Such requests will be directed to the prosecuting attorney who in turn should work with the submitting agency. So I
they
think
can
the
work
only
with
time
us
that
to send
anything would
to
come into
the
play would be
DPS.
if
But if
we'd
you-
already worked it.
If you've already worked it, then the defense
That's
is
when the problem
still,
would come in.
We're
Out of
entitled
luck.
to independent consultating experts.
Yes, but you can get, we are working in a world where we have not exhausted the options out of state. We have, and you can get an accreditation, you just haven't gotten it if you are one of these independent examiners. So the argument about constitutionality for us as two lawyers who do not argue that much in front of the Court of Criminal Appeals is to me a little bit premature when you can get accreditation, you just choose not to. If you choose not to do that, that is not unconstitutional. That is, you choose not to do something. And you can work with us in terms of DPS, trying to get a defense examiner, or we can try to exhaust the out-of-state options. But are you going to say that the 3835 is unconstitutional? I don't know how the statute is going to be unconstitutional because they chose not to try to submit
No,
to
but-
accreditation.
the constitutionality determination, the defendant does not have the obligation to force private examiners to get the accreditation. The defendant is saying, I cannot comply with the law. I try, I
Right.
look at these recognized entities, and there is not one that is available to me.
Have we checked outside the state to see that? We haven't done that yet. I know that you're saying that you don't think that's going to happen, and I think that you're an expert in the field, and you don't think it's gonna happen, but I think you have to say, we've exhausted all these options beforehand.
We will happily call all of the folks on the list that aren't in Singapore. I think
Fair enough.
Singapore
But
wants
you also
to-
just looked at ANAP. There may be other accrediting bodies that deal with documents I'm not aware of.
International Grant Hall.
Yeah.
Grant
So-
Knowledge Society.
So I mean,
No,
we
but
have
that's
to
not
really
an
look.
accrediting body. It would have to be either A2LA or ANAB. Those are the only ones that count in this context. We will happily call all entities that have QD and see if they are available to the defense. But I would just submit to you that for those public entities, the DPS's type entities, the feds are off. There's no way they do work for the defense. And plus, so we'll do our best to make all those calls, but my concern is, in the interim, what is the right course of action if you consider the fact that a defendant trying to mount a defense tomorrow has no options? I don't, I would be the last person to want to relax rules around quality. I just don't know what else we can do at this point.
I'm still here to let the courts work it out instead of us.
Because the case in Hidalgo County, if the judge let that in,
Should let it in.
then the defendant was it not guilty or convicted?
I don't know.
We don't know. So if it's convicted, then the argument would be a cross appeal, I guess by the state, saying that that should never have come in. Normally, if he's convicted, then the state only takes, the court takes up the defense's arguments that I was convicted wrongly for X, Y, and Z reason. So if in the interim that there's a case that comes up and the judge lets it in, it's 9 times out of 10, correct me if I'm wrong, Mark, it's moot in terms of if the case is affirmed, they don't take up the state cross appeal argument that the evidence was let in improperly under 3835. Am I correct? No, I mean, the only way this gets to an appellate court, to a constitutionality issue, is if the court kicks out the defense's expert. So Hidalgo County's case would not come up and not be ruled unconstitutional, except on a motion on the state's appeal, which is normally rendered moot because the case has been affirmed by the appellate court. Correct?
No, sir, I disagree.
Okay.
The evidence is disallowed, that it cannot put on, it's not able, it's not
If the
capable,
appellate- if
it has
the-
no access to.
If it has been allowed in. That's
Yeah.
in the world that it has been allowed in, like
Right,
the
right.
example that they used. It's in evidence, right?
Right.
It doesn't go to the appellate court unless the defendant's been convicted.
Correct.
At the appellate court, the arguments that the court takes up, or the defendant saying that the trial court erred by doing X, Y, and Z, right? The state has a right to cross appeal, rarely does. So the court, if it affirms the conviction and says that, yes, we're affirming the conviction, rarely takes up the state's motion for cross appeal. Meaning that the motion that the 3835, the judge made a wrong decision by allowing this evidence in. If it's affirmed. So this is it. When is this gonna be, I'm trying to figure out, is there any case that's in the,
She was convicted, actually, I looked it up. and-
What
Okay.
they're telling us is, the defendant has a due process right to mount a defense, defend against an accusation. In question document cases, that's often a core issue in the case. Is that his writing or is that not his writing? It's very central to the case. And so here comes DPS expert that says, well, I tie that to Bedoli. I've looked at his handwriting and I do that. And the defendant's sitting there right now, not able to defend against that, without access to experts. That's the due process problem that Lynn's trying to tell us about.
right?
That we cannot tolerate that. And so we're asking for a temporary suspension until such time as you can put together a program. It may take 6 months, it may take a year, but during all the course of that time, have exactly the vehicle in place to address what Pat started this with. There are some people who are not very qualified, that's what you said.
Right.
That's why we have trial judges. That's their job. No, this person's not qualified to do it. I'm not gonna allow him to testify. You have a 705B hearing, test that outside the jury presence, see if he's qualified. Both sides are entitled to that. So,
Can a trial judge do that now, even though there's statutes
Yes.
separated and say,
Yes.
the defense has no other access to any expert?
your license does not make
we-
that admissibility.
You
No.
can let in this person to testify because there are no accredited defense bodies that make that argument. They checked all these other labs, and the judge says, he can testify. Can they do that now? So why do we have to change it?
Not in the face of 3835.
He had, the only way that the
So he's
judge can
bound
make.
by 3835.
Right, the
Yes,
only
right.
way,
Yeah.
3835 trumps the rules of evidence. So first you do a statutory analysis and then you look at the rules. And what the judge has to do in order to let Mark's defense expert in is say that he's letting that person in because 38.35 is unconstitutional. And that gives me lots of pause. And I think if that were to go up to the CCA, they would say yes.
It doesn't get to the CCA. Because if he lets it in, the defendant isn't harmed at that point in time.
He denies it.
Right, the only is that
That's
he
where
denies
it's
it. Have there been
going.
any evidence that he denies it? And I would think the judge would say, have you exhausted all opportunities to see if there's anybody that does this type of work?
And they say, yes, you know how we exhausted it?
And they would say, hey, we looked up question document examiners, they have these 35 that are out of state, did you look at any of these?
But
And they would say,
But that's not
probably
the
not.
way the code works. The way it works and the way our rules work is we publish a list of recognized laboratories in the state of Texas. If the defense pulls up that list, the PDF for out-of-state and in-state, scrolls all the way down through it, sees the only option is DPS, and they have no option. They are not obligated to go hunting. They're operating under the law as it exists, which is that the only recognized labs are the ones that we have published.
But would it be our obligation not to worry about the constitutionality, because that's a separate body, but to do the hunting, to see if there are other people who do this? Our obligation, I don't know if our obligation should be to lower the standard. It was to see, we should find people who can meet the standard. That is what we do in this body. It is an appellate court. It are lawyers like me and Mark that handle that separate aspect of it. To me, we should try to see if everything is exhausted, then come back and say, there is no possible way that this can happen, as opposed to doing it in the face of not exhausting those options. I think that's the difference. I think the body now, talking about constitutionality, that is outside of 85 to 90% of the body's expertise. And frankly, we are trial lawyers, and so we don't handle those all the time. That's my only concern about this. I think we see the problem and we're trying to fix it, but to me, the first issue is, let's exhaust the options first, and then come back and say, no, there's nobody in the United States that is willing to do it or apply for a license. We've gone out, we've recruited it, they need an option now. There's absolutely no other way. So I think that's kind of where I am.
To that point, in terms of exhausting the options, for the commissioners that aren't willing to grant an exception and vote that way today, would your position change if we were to propose a motion that allowed the commission to follow through with the 35 ANAB accredited QD labs, follow up on the A2LA QD labs, and would your vote be different if we verified that none of them would be willing to take defense work? Would that change your vote? Because we can propose a motion that directs them to do that and grant the exception in the event that not a single one of the existing accredited QD labs could perform the work.
That gets to
Would
kind of
that
my
change
issue.
anyone's vote?
Yeah, I'd say, I'd like to go beyond just I know ANAB, I just don't know I don't know the field out there, but maybe somebody go to the academy meetings and go to the QD section and see what's there.
Well,
or
I think
something.
there
just
needs to
don't-
be outreach as well to
Yeah,
the
we've got to
community
find out what the
to advance
opportunities
it.
are
But
before we
I'll be there in
react.
February, so we can hit up the QD section and see.
That would work for me. That gets to my root concern.
Okay, so
Yeah.
can I make a motion? So we can get to the next agenda item.
Yes.
So I'll make the motion that we direct commission staff to follow through with all of the existing QD entities that are accredited under QD, determine if they will be willing to do defense casework, and in the event that not a single one can provide that service, that this commission votes to provide the exemption.
That works for me.
All right, is there a second?
Second.
All those in favor?
Aye.
Opposed? Okay. Yeah, why don't we take a break for about 10, 15 minutes?
We're going to be
Is that somebody who actually does have the background to be able to do
I will argue with that. Some trim like a
giving others not that you've been able to vet and determine are legit.
I'm not complaining.
And it specifically says they were doing it. That we're not going to do Right, and then we don't want to do it. So they have an extra.
PBS may not want to get involved. No, I never voted.
I guess we exactly. I'm their wife and I I swear I was thinking that's like two introduction like this.
No, because it's like, are you going to
That's where we
We need to have
I didn't think
So that's one thing that we probably talk to Cal.
Again, it's another one of these.
What is that? Why is it everyone just not?
Yes, absolutely.
Things don't change. I know technology does, but
I do a lot of they're not
In a lot of cases, I'm surprised he
You ready?
Really?
No one got the rejections. But he knew what he Well, I could do That's a pretty good.
I got you ahead of schedule. Tell Charles. We're doing good. Anyway, we can remove him.
There's no provision. I'll work on it. So, yeah.
He almost knew he was his dog.
Nobody.
Yes, I saw it.
Oh, that's fine. That's a good job.
No, but actually saw it.
They see him walking down the hall.
Very lucky. Third term. I've never experienced it.
We had the same, so much kind of demonstration.
Just takes a lot for
So I live in the corner and I thought I
We've been emailing this out.
Thank you. I knew that. I know. Yeah, I know.
Get everybody seated.
We can't just go without
They don't want us to see this.
But you didn't laugh. That's right, nudging him, yeah.
Let's get started. We're going to continue on with number 4.
Let me give you this, just in case anything.
That will resolve.
Hey, I'm here as the buffer between these two guys.
You're the reason I can't like that. Okay, so we're going to continue on with number 4. Letter C. Discussion and consideration of laboratory request for CLIA certification.
And PGLA accreditation. So maybe we should start with PGLA, because I feel like that's sort of the easier one. In a sense, PGLA is an accreditation body that accredits to ISO standard 17025. They're a member of the national or international accreditation bodies consortium, or I forget the exact name of it, but they are focused not on forensic service providers. They're focused on environmental testing and testing in industrial settings. And so we had a laboratory, Stoke Labs, that currently does the type of testing that PGLA typically has accredited for, and they are considering bringing online some forensic casework. And so in that context, they asked whether we would consider PGLA accreditation to add to our list of accrediting bodies. And so in beginning that discussion, we started to look at the various accrediting bodies on the list and talk about why they're there. And we're very blessed to have Pat Johnson here because he was there in the beginning when the legislature created the accreditation requirement in 38.35 of the code. And so the issue, I think, with PGLA, just to boil it down, is that they do not have a record or experience of having accredited forensic science service providers in particular. Their administrative staff has expressed to us that they would like to learn about what that would entail, and so I think there is some desire on their part to expand their program to cover forensic science service providers, but they don't have that at this time. And I think in conversations with Pat and Dr. Kerrigan and Lee, you know, we're a little bit concerned about opening up that list to an entity that has, so there's 0 supplemental standards for forensic application. None of the stuff that ANAB and A2LA and others have are present with this accrediting body at this time. That may change in the future, but right now, they do not focus their work in the forensic area.
And if they decided to develop supplemental standards that would address chain of custody and those types of forensic issues, we could consider the request at that time.
Right, so I think what I would recommend is going back to them and explaining what it is that we're looking for, and then sort of give them the option of approaching us again once they've considered whether that's something they would want to do. You know, it's one thing to say, yes, we're interested, but it's another thing to say, yes, we're interested, and here's how we're going to move forward to expand our offerings to cover all these other things.
And if I recall from the earlier conversation, they do accredit to 17025,
Right.
and then PGLA are accredited to 17011
Yes.
as an accrediting body. So those other elements are there. Really what they're missing are the supplemental standards that would make the accreditation forensic in nature, because 17025 is very generic for testing and calibration. There's nothing in there about, you know, evidence handling, forensic science. So we could certainly consider that request later on when they've developed those standards.
And I think in addition to developing the standards, they need to sort of beta test. They need to go inspect some labs under those new standards and get a bit of a history before this commission considers them.
Because right now, their assessors would not be SMEs, like the ones that ANAB sends out and stuff. I mean, they would not have that perspective. So I think we can emphasize that, from an ISO perspective, you have everything that is needed. It's just those supplementals that are really important to what forensic labs do that we would need to see. Plus, you have to go out there and do it.
And a track record
Yeah.
of showing that you can actually accredit to those standards. So I don't think it's something we can entertain at the moment.
Having said that, there is a monopoly, or I guess it's kind of a monopoly. It's not even a duopoly right now. So it would be nice to see other players enter the market. It's just, whether they're willing to do it.
So I'd make a motion to deny the request to recognize PJLA as an accrediting body in Texas.
And we'll try to work with them to see what they're willing to do.
Second.
All in favor?
Aye.
Opposed?
And then we move on to CLIA. And Redwood Toxicology has submitted documents, and we do have someone here representing them. And these documents are meant to show, right now, the laboratory has certain sections that are not accredited by CAP or one of the other recognized accrediting bodies that the commission recognizes, but they do have a recognition from CLIA, which primarily is the Clinical Laboratory Improvement Amendments, which offers those programs, and it's primarily for what I think they would refer to as a healthcare endeavor, testing people who are on probation primarily to determine whether they've used controlled substances. And so the request has come in, and you can see in the materials, there's a letter about why the laboratory would like the commission to recognize CLIA. I do think that Dr. Kerrigan knows quite a bit about this area, and it's a sort of a 2-page letter that we have in here from actually 3 pages. And it's not really an accreditation body, CLIA. So we can have Redwood talk to us about their perspective if you all want.
We appreciate the opportunity to come before the board. I want to just introduce the team here. I'm Dr. David Green. I've been doing drug testing for probably a long time, let's say 30 plus years. I'm sit on the Drug Testing Advisory Board for SAMHSA. I have Dr. Suman Rana. She sits on a lot of national committees setting standards for drug testing. I've got Jeff King as counsel for us. I think we would like to expand the scope of this a little bit more. What we do is we offer, as an outside laboratory, to entities within the state drug testing at a cost-effective, I think that's one of the key elements, level for probation and parole, pre-trial, drug court, those sorts of things. Most of those actually go through as a presumptive type of result. It's reported out as a presumptive result, which I understand is beyond the scope of this board. Occasionally they will call us back a week later and say, well, we want to confirm that. Many of these cases are actually going into a situation where they're going to refer them into treatment, they're going to do other sorts of things. In fact, the deterrent court specifies treatment. So we would say in these sorts of situations that actually a CLIA lab is required under CMS regulations because it is for a health type of benefit, a controlling the use of drugs. The program is really very similar to the workplace program. It's a deterrent program, a monitoring program. It's a program to keep people from using drugs. It's not typically something where We do have an ABFT laboratory where we go through and we scan for a wide range of drugs so that we would know in this evidentiary case what kind of drug is there. Typically, this is a very small panel of drugs, 5 classes of drugs where we will go through and test them, screening sometimes with a confirmation, and then they would go through and make some determinations. Occasionally, they go through an administrative hearing. Rarely, no more often than I have had in my experience, for a workplace type of test, which is outside of the scope of this board. They can go to a criminal hearing occasionally. And those criminal cases, again, would be, I've lost my job, that sort of thing. And the same situation with a CJ type of originating test. They can be sued over everything. So the type of testing we believe actually fits the CLIA model. Dr. Rana has some documents that you can just show those where she's tabbed where the various elements for a test under CLIA are similar to CAP. In fact, CAP and CLIA are actually essentially synonymous. If you have CAP, you essentially the CLIA inspectors don't come in. Give you a little bit more background. I have done over 30 different inspections where I go to other labs for SAMHSA. Then for big cap, I see you're considering little cap. We'll call it big cap and little cap just to keep them distinguished. But I've done over 30 different inspections for those types of groups. And there's really, for the quality of the result that you're getting, there's very little difference between those sorts of things. It's synonymous. I mean, again, it's really dependent upon the type of lab, not the certifying agency. So we would propose that CLIA would be equivalent to CAP, but further we would propose that the criminal justice types of samples that Abbott receives are really outside of the scope. They're really clinical tests, they're monitoring, they do go to the administrative hearings occasionally, but rarely would it get into a criminal trial where there's evidentiary types of things that happen. And again, these are the two smart ones in the group. I just have a big mouth, and so they had me stand up. And so you guys fill in where I've actually left out a lot of things.
Yeah, I'd just like to clarify the situation, to give you some background. So the way the Redwood Toxicology Laboratory is situated, we have 3 different sections in the laboratory. So when we receive workplace specimens, then they go to our SAMHSA laboratory, because under the Department of Health and Human Services SAMHSA program, it is a federal requirement to process the workplace testing specimens through the SAMHSA laboratory. When we receive the true crime investigation or postmortem or human performance type of testing, we triage it out to our laboratory that is under the ABFT accreditation. But when we receive specimens from community supervision programs, which is corrections institutions or probation, parole, or drug courts, we process them through our laboratory that is under CLIA licensure. And the reason for that is, as you may already be aware of, that the federal regulation requires any drug or alcohol testing that's performed, and if the results are going to be used to refer or make treatment available to the test subject, then there is a requirement that that type of testing be performed under CLIA laboratory. With the letter, I submitted a CMS, basically clarification that was issued specifically to drug and alcohol testing laboratories that clearly says that any entity or facility performing drug or alcohol testing and or screening where the test results are used for the purpose of referring, offering, or making available to the test subject treatment must either obtain appropriate CLIA certificate and meet the acceptable CLIA standards or cease testing. So for that reason, we have to perform this type of testing under the CLIA laboratory. In fact, the Texas DeWitt Court uses treatment as one of the terms in their mission statement. So, we would be in violation of federal regulations if we didn't perform this type of testing in a CLIA laboratory. So what we're asking from the commission is to consider the situation, because the implications of drug testing for probation, parole, or the drug court type of situations is very different from an actual crime scene kind of casework. We completely agree with the commission that the postmortem forensic toxicology or the human performance forensic toxicology should not be allowed under the CLIA umbrella. CLIA is not the right umbrella for that type of testing, and that should be done with ABFT or some of the other acceptable accrediting bodies. However, I would say that that type of testing should also not be allowed under the SAMHSA umbrella. For example, SAMHSA is only meant for workplace drug testing. Similarly, CLIA is only meant for situations like probation, parole, or drug court, where the test subjects are referred out to treatment on a routine basis. So that's kind of what our dilemma is. And so what we're asking from the Commission for consideration is one of the two things. Either exclude the community supervision program or the court-ordered drug testing type of programs from the jurisdiction, or allow CLIA only for a narrow area of community supervision testing for drug and alcohol testing purposes. I think either of those two situations would allow us to stay within the federal guidelines as well as, be able to provide the testing services for the state of Texas, and we have over 500 clients from the state of Texas for both the workforce, the criminal justice situations, and the similar type of settings. So it would make it very difficult to comply with the current Texas legislation to perform this type of testing in an ABFT or SAMHSA umbrella, because we would be not in compliance with the federal regulations then. So I did, in addition, I would like to point out, I actually printed copies of the Federal Register that specifically pertains to CLIA and demonstrate how CLIA certification is actually equivalent, if not better, to any of the accrediting bodies that the Texas Commission is currently recognizing, which is ABFT, as well as SAMHSA. It goes into details of listing all the essential elements of good laboratory practices, as well as the other accreditations, for example, the rules and regulations regarding proficiency testing program, the rules and regulations regarding facilities, the quality system program requirements, the federal requirements for the quality system in the CLIA laboratories, federal requirements for the validations in the CLIA laboratories, the personnel requirements and their competency assessment requirements. In fact, I'd like to point out to the Commission that none of the other accrediting bodies on the Commission list have as intense personnel competency assessment requirements as are provided by CLIA. Generally, in ABFT and SAMHSA, the personnel in the laboratory are proficiency testing because are considered qualified because the laboratory is providing proficiency testing. CLIA says, okay, that is acceptability of the laboratory processes, but it's not really an indication of each individual person who is involved in the process, their competency in performing their specific jobs. So they actually have a very big 6-point list that the CLIA personnel have to be competency assessed on. That goes in detail that they have to be direct observed doing the specific tasks that they are required to do. They have, just bear with me, I'm trying to get to the page there. In the competency assessment. So this. So, can't find the page right now. So they require you basically to observe, direct observation by a competent person. They require the monitoring and recording of test results. They require review of the intermediate test results, worksheets, any quality control data, proficiency testing records, preventive maintenance records. They require direct observation of the performance of instrument maintenance functions. They require the assessment of test performance through the testing previously analyzed specimens, internal and external blind samples, just like ABFT or SAMHSA would require, and the assessment of problem-solving skills. They go into all the corrective actions, documentation of those. So the regulations, they're all in the Federal Register. You can go through them and see that they are equivalent to any of the other accrediting bodies that the Commission is currently considering acceptable. So that's, I'm happy to leave this package here. I apologize, I did not make copies, but I'm happy to leave the package of the federal regs here for the commission to kind of go through them.
Just a question.
Mhm.
I mean, I think in terms of some of those quality issues, we can make the comparisons and see that, there are good points there in terms of what CLIA does. But what CLIA doesn't do is concern itself with the types of issues that courts are concerned with that put people in prison. So things like custody and control, all that kind of stuff. Can you point to a place where, do you do chain of custody in your CLIA lab? You do all that?
Absolutely.
Yes.
And actually, CLIA does require, and let me point that to you, they don't specifically, they do require proper integrity of the sample throughout the testing process. And the integrity of the sample has to be maintained from the time of collection, in fact, from the time of patient in their language preparation. So the integrity of the sample has to be maintained from collection through the testing to the, throughout the laboratory, and documentation of the receipt and the time of testing, at the documentation of the date and time of receipt of the sample, where it came from, and what actually happened. All those records have to be maintained. So we do maintain a proper chain of custody throughout both external as well as internal chain of custodies throughout the testing process. And that's required because, even though we're doing testing for drug courts, the court would require a chain of custody documentation, because otherwise, the result could be disputed, that it could end up.
So why not just have that section accredited both, or recognized by CLIA, and extend your other accreditation? Why not just have the ABFT accreditation as well?
ABFT does not have any jurisdiction over clinical testing, and clinical testing does not have any jurisdiction over ABFT. Like if I wanted to get my ABFT section of the lab accredited by CLIA, they would not do that, because it's excluded from the scope of their work.
But the other way around, we have labs that do the type of testing that you're talking about, that are accredited not just by CLIA, but by multiple accrediting bodies. Is that?
Theoretically, is it possible? Yes, but it is absolutely a big financial burden on the laboratory, and it would increase the cost of testing. If we have to maintain multiple accreditations, then it would essentially increase the cost of testing for the Texas clients. We have to, because we already maintain ABFT accreditation for all the crime scene work, where, for all the postmortem or human performance work, where you actually need that accreditation. So I don't know if you want to have.
I totally agree. What happens is you start to expand this accreditation. The ABFT accredited portion of the laboratory really focuses on a large panel of possible analytes that might be involved in a crime scene type of a situation. Again, we're talking about a very narrow scope, typically 5 different classes of drugs. Is this person not taking the drugs because he was originally caught taking drugs, and we'll make sure he's not taking them anymore? Does he need to be referred to a drug court, a rehab type of program? One thing I did want to point out is the big cap, which is allowed under the program, is equivalent to CLIA. They essentially are. The difference between little cap and big cap is essentially goes more into the chain of custody sorts of things, but basically the quality of the result in a cap or CLIA lab has to do with life and death. Is the quality of this result going to help this person survive, to live? The FUDT portion of it is, will he be defensible in court? Will he go to jail? Will he have a revocation? Those sorts of things. So life and death, going to jail. It really is, the quality is essentially the essence of it. Again, I personally have gone and done a lot of inspections. The labs that I have oversight over in the United States, we actually have over 100 inspector days per year in those laboratories combined. So it's equivalent of one inspector being there for 100 days, 100 inspectors there for 1 day. Typically, it's spread out. But those laboratories are essentially having defensible types of testing before.
Yeah, and I think it's another important point that Dr. Green pointed out, that CAP actually has deemed status with CLIA. Yeah, and if the accreditations or certifications were not equivalent, then, you know, CLIA would not allow a deemed status for CAP.
So I think this request is a much bigger question for the commission than just this request from Redwood, because it's clear that the CLIA certification is a requirement for the medical part, which is the referral for treatment. There's no question that's federally required. Our challenge is that what happens when it becomes the criminal investigation in, for example, the revocation hearing or whatever. Our options would be to recognize that CLIA would be equivalent to one of our existing accrediting bodies, which we've heard a little bit of information about the elements that are similar, but that wasn't provided in the initial request. And I think the critical part would be looking at evidence control, the custody and control type issues that are of interest to the court, which we haven't had the chance to do. But the bigger problem is whether or not we really want to start recognizing an accrediting body for community supervision and probation and parole. And my personal feeling is that that opens a complete can of worms for the commission. But there are some legal issues we have to be concerned with, because as soon as it's confirmed, it becomes the forensic analysis. So if it's just a screen, it's already exempt.
What's the can of worms? I don't understand. I mean, I review CLIA stuff and that we're interested in it. It's quite demanding, rigorous, and comparable in a lot of ways to what we do already. So what's the can of worms if it's just another accrediting body recognizing the performance?
Well, the can of worms might be the issue. The sticking point might be the commission then making a decision that has implications for other labs in Texas that do probation and parole, when those are already exempt, correct? When they're just screen onlys. So, yeah, when they're presumptive.
The way that they
they're
wrote the
exempt.
law a long time ago was presumptives are exempt. But the way I read it is that confirmatories are not.
Because then it actually falls under 3835 forensic analysis. So if probation and parole was already given an exemption when it was presumptive, the question is, should we really disallow that exemption just because now the result has been confirmed, which is what we would want in every probation and parole case, but rarely happens, and is probably not feasible, and certainly isn't the standard throughout the United States. So I'm really nervous about opening it up or making a decision regarding accrediting bodies for entities that are doing probation and parole. I think that's beyond their jurisdiction.
So we have to figure out, we have the ability to recognize whatever you all want to recognize as accreditation. It says the commission by rules shall establish an accreditation process for crime laboratories and other entities conducting forensic analyses of physical evidence for use in criminal proceedings. And up until now, the way that's been done is by recognizing these national bodies, ANAB, A2LA, etc. But we're in the process of developing a program that is Texas state-based, so we know that we can do that. The question becomes, for these types of situations where I appreciate the argument that this is similar to the workplace drug testing, where the samples are taken for purposes of one thing and then used in a criminal action. But I think they would have a harder time arguing in their context that the principal purpose of what they're doing is truly medical and health related. The federal government may say that in these memos, but I'm not sure if you're sitting in front of a judge who all day long, all they do is revocation of parole hearings that they're gonna see it that way. So that's why I think the rulemaking would allow us to provide some clarity. And the question just becomes, would you feel comfortable writing a narrow rule that says something to the effect of, samples that are taken with the primary purpose of, and then quoting what CLIA says their primary purpose, but are subsequently used in a hearing for revocation of probation or parole, either, are exempt from the accreditation requirement as long as they're being done in a CLIA lab. You could do that. That would provide clarity.
And I think writing the rule narrowly like that solves the problem and keeps us out of accreditation of community supervision drug testing, which I don't think anybody thinks is a great idea for us to bite off.
But under that, just make sure I got that right. If it's being used, let's say, to send someone to prison, it's a confirmatory test, and it still would come.
No, I mean, we'd all like it to be, but it isn't everywhere, right? That's probably got the best sort of historical knowledge of this.
And what's the question?
Presumptive, or are they, will they put somebody back into prison on a presumptive and not a confirmatory? Just depends on the jurisdiction.
Well, I would ask the prosecutor that.
We confirm in our
A lot of
jurisdiction.
times, we get it retested.
We get it retested.
So that's the problem. It's actually nice because if we can be in a situation where if they, as long as it truly meets the same standards, which it sounds like it does, then it means we don't have to go get it retested to use it.
But the problem is, every jurisdiction is different,
Yeah, I
and
know.
it's great that you're getting them confirmed, but that's not
Yes.
happening everywhere.
That's
Yeah.
definitely true.
And
It's true.
Yeah.
And that lack of uniformity is throughout the country also, just because of the jurisdictional issues and the authoritative bodies that oversee that type of testing varies from state to state. Sometimes it's overseen by corrections, sometimes it might be the health department. I mean, it's all over the shop. So I think the narrow rule that you propose is a really good solution.
I think we'd have to write it to be quite clear that, because workplace drug testing is easier, I think, for a judge to understand that this was taken for a different purpose and now is being used in a criminal setting. But for these types of tests, I think they would look, I'm not sure they would, you basically end up where the Travis County ME's office ended up on postmortem toxicology, which is not good. So I think that would be, if, I don't know enough, I'm not a subject matter expert on CLIA or anything else that's being said about what CLIA does to ensure the quality of the work that is done in the laboratory. But if people do feel like, and by people I mean Dr. Kerrigan, Pat, people with expertise, if you, Dr. Drake, if you all feel like CLIA is as robust as it needs to be for someone to be put back in prison, I mean, let's remember what we're talking about here, based on the results of those tests, then I think we can move forward.
Well, I don't think we have that information today to make that decision, but I think we could move forward on directing council to draft some language to provide a narrow exception.
Do we need council to review what they brought in today before we?
I think we could review both, but
I'm not going to be able to make judgment calls on whether the things that are in the Federal Register are just as good or not as the things that are currently being done. I mean, the best I can do is talk to other laboratories with experience with both programs, but I've done that already and gotten some feedback.
And I think that the other problem, going that route and recognizing CLIA for this narrow purpose as a recognized AB, doesn't solve that problem, that then we also are creating a bit of a double standard in 3835 where we say if it's not confirmed, it's exempt, but if it is confirmed, it has to be accredited, and that just doesn't pass the common sense rule. So I think for me, there's compelling, compelling argument to grant a narrow exception.
And you're saying the reason it doesn't pass the common sense rule is because we know that presumptive testing is being also used to put people back into
Because it would
prison.
almost discourage people from doing a confirmation,
Right.
which we'll think would be best
Better
practice,
than
but is not
presumptive, yeah.
universally employed. And we certainly wouldn't want to do that.
I see.
And it's required, as I understand it, for the medical part, it's required for it to be confirmed. That's part of CLIA. That's a good thing because it's the higher standard that we talked about before. So it's it is truly a dilemma. But I think the narrow rulemaking is the cleaner option rather than going back and looking at the CLIA standards. The other problem with that approach is that I'm sure I don't think Pat or I have sort of the requisite understanding of the CLIA certification program itself, but I'm sure like most of the others, those are revised and republished in the Federal Register on an ongoing basis. And if we do that, we would have to re-review those standards every time there's a revision. So I don't think that's a clean way.
So instead of considering recognizing CLIA as an accrediting body, which it is not, we should write a narrow rule that tries to close the gap and encourage confirmatory testing as opposed to just using presumptives to put people back in prison. By writing a rule that says, if the primary purpose is, and we'll quote the language from the documents we have, but then the specimen is used subsequently in a revocation of probation or parole, it is not required to come from a laboratory, from an accreditation body, as long as it's CLIA, essentially is what we'll say. I mean, in more legalese than that. Yeah.
Let me ask a question. You mentioned some of the samples that go through your lab. You basically do the emit test or some sort of screening test for the 7 or 8 different classes of drugs, and then you stop right there. But other samples, you take further and do some sort of confirmation testing.
And sometimes after the fact, sometimes we get a call 2 weeks later, please confirm the sample.
Okay, so you would get a subsequent request?
For me, just about every variation you can think on that topic, we receive.
So you retain those samples long term?
We retain non-negative samples.
How long?
Depending on the term of the contract that we have or the request by the agency that sent it to us.
Okay, so with the sample, I suppose you refrigerate them or something for that 90 days or a year or however long you're keeping them. So the sample is still good to do the confirmation testing on how much later?
Well, essentially, I mean, that's a wide open question because each drug has different stability, those sorts of things. Typically, I pull things out of our freezer for years and it's been fine, but really depends on that storage, and we do maintain as appropriate storage as possible.
Okay, so CLIA doesn't require confirmation testing.
CLIA requires, what CLIA says is that if any testing is done, whether it be screened or confirmed, if any drug or alcohol testing is done, where the test results are used for the purpose of referring, offering, or making available to the test subject's treatment, then that must be done under a CLIA laboratory, or unless the laboratory doesn't have CLIA license, then they must cease to exist. So since the drug court, and the Texas DeWitt Drug Court as well is a good example, their whole purpose of a drug court is an alternate to punishment. Those people are routinely referred to treatment programs. Similarly, probation parole courts, cases of those nature, they come in and people are routinely referred out to treatment basis on that program. The corrections facilities are doing the same thing. So what CLIA says is federal law says that it doesn't matter, even if you did the test for forensic purposes, but in the end, if it got used for the purpose of referring somebody to treatment or making available treatment to the test subject, then it is under the jurisdiction of CLIA, and the laboratory must have a CLIA license and follow all CLIA regulations.
Well, if that's the case, I mean, generally when we look at accreditation, we're looking at labs that are doing some sort of confirmation testing. I mean, if we're gonna report cocaine out, we're gonna be sure it's cocaine. It's not just a preliminary test. So I guess I don't see how your proposed rule, that if it meets CLIA, then it's gonna satisfy the courts if it's not a confirmation test. Under
Well,
CLIA,
it's-
you don't
But it's
have-
already exempt. There's already an existing exemption if it's not confirmed for probation and parole. So it's only these ones that involve a confirmatory test, I think, for which there's a problem. Is that right?
It's the narrow group, and I understand it's quite narrow, where instead of them doing the confirmatory test and it going through some sort of administrative process and being resolved, whatever the results are, trigger a prosecutor to take action. And that's when it goes in front of a judge and that judge says, well, what's your accreditation status? That's the issue. And right now, their solution, they mean the prosecutors, is to retest. But some of them aren't doing that. Some of them are just going with the presumptive and saying, we're going to take action just on that. Dawn and Jarvis would retest, but I think the policy concern is that if it's easier to just go with the presumptive because the law exempts that from accreditation, then it kind of provides a twisted incentive. Does that make sense?
Yeah, I was talking with Don just a second ago. I mean, when we do presumptive tests and we use a presumptive, it would only be essentially, they would take the presumptive, confront the probationer, and if they admit, then they don't do the confirmatory test. That's how we do it, and I know that's how they do it. We would never use the presumptive test in court. My only question is, when you talk about drug court, you're doing the test supposedly for treatment, but part of drug court treatment is jail time.
Correct.
So,
It's the whole dual aspect.
are we using the presumptive test
Yeah.
for jail time? So do you know, or that would be outside your?
Yeah, we don't, to be honest with you, we don't know what the actual results are being used for until we are contacted about how we can prepare a litigation packet for the admission of evidence or prepare for trial through testimony of one of the toxicologists. So we have no knowledge of how they're being used. What we can tell you is the contracts that we have typically will identify that the purpose of the contract is drug treatment, referrals, things like that. Or in some cases, we have contracts that identify that those samples will be collected, let's say, for a county that doesn't identify what the purpose of that is going to be used for. But throughout the conversations that you have with the contracting individual, you determine that this may be used in a criminal justice environment. And in those cases, then we have to really evaluate what the long-term solution is for that client and how best we can help them. And that's why we brought the issue up here, is we're trying to help, but at the same time, if we have additional testing that we have to do, it brings up additional issues. For example, quantity not sufficient of that sample. If we've done a confirmation on it of a sample that's leaked in transit, and we're able to run through our CLIA laboratory a sample, and we've done the presumptive screen, we've done the confirmatory analysis, and if there's not a quantity sufficient to run through our ABFT laboratory to ensure the forensic admissibility into a Texas trial, then we run into a position where we've fulfilled our contractual obligation, but we have failed to fulfill our contractual obligation. And so that puts us in a position where we have to defend ourselves, not just to the Texas criminal court, but also to our client. It's a conundrum for us.
One of the things I'd like to just also, I need a t-shirt to say old guys rule, but to kind of give you a little bit of experience. The labs that I have oversight over, we do almost 10 million drug screen patients, our donors, per year. And so those rare things that you see do pop up. Over the years, I've seen a lot of people go to jail. Again, I probably am consulted on developing litigation packages, consulting my defense attorneys, prosecutors, probably 100 cases a year, mostly by phone, so happily I don't have to travel. But there are a lot of folks that put people in jail on a presumptive test. I mean, It happens. I mean, I'm going across the country, and I'm outside of Texas too. I'm not sure what all the Texas jurisdictions do, but it happens. But just to kind of give you an idea.
So,
Okay, so the exemption, so Pat's bringing up that the exemption right now for when it's presumptive only is
It's in the statute.
statute.
It's part of the
It's not a
definition of
rule.
forensic analysis.
Right, but couldn't we, in our withdrawal making authority, just,
Add it to the
yeah,
exemption.
we can still fix that.
because it
Without
says
changing the
that
statute.
anything that we by rule, under 38.01, exempt, would also be exempt.
I still,
Which is.
we have the ability
Oh,
to do
yeah,
it.
I mean, we have a long list of exempted things.
You know, what would the rule state?
So it would state something like, forensic analysis of a sample that was principally obtained for purposes of, and we can go through the CLIA language, but is subsequently used in a revocation of probation or parole proceeding, is not subject to the accreditation requirements of, and then we would refer to the provision that requires those national accrediting bodies. And we can say in there, we would cite CLIA, I mean, we would say that this has to be done under CLIA. We can't, but that's already federal law anyway, so I don't know that we have to repeat it, but we can say.
I've got just one clarification. Because we as a laboratory and many of the other laboratories that service the state of Texas, even outside of the state, because we don't know what that test report will be used for, and at the same time, maybe we don't know why that sample was collected. Would it be better just to identify community supervision, probation, and parole for purposes of treatment, rather identify it broadly? But we already have for exempt the presumptive screening for probation, parole. It's already codified. At this point, if we add that additional layer, if a presumptive screen that's been exempt under this statute also is confirmed under, for these purposes, must be confirmed in a CLIA laboratory.
So our statute doesn't quite work that way. I mean, I'll write it in a way that language, there's no place for us to put what you're suggesting, but what we would say is that forensic analysis performed for the purposes of treatment, et cetera, et cetera, et cetera. I'm going to take the language out of the CLIA. I mean, there's language that they use that is subsequently used.
Community supervision, probation, parole.
Revocation is not subject to the other, to the accreditation requirement as long as it is performed in a laboratory that is recognized by CLIA. That's essentially it.
So, just real quick, so if it was a presumptive that's used in a revocation and it is performed in a CLIA lab, is it admissible?
So the presumptive is already taken out. I mean, the presumptive, the legislature exempted presumptive tests. The question is, what happens with confirmatory tests that are taken for the purposes that were described here today, but that are subsequently used in a revocation of probation or confirmatory forensic analysis used primarily for treatment and subsequently for revocation of parole or probation. That's what we're talking about, right, Don?
We need to make a decision on this.
So I would make a motion to direct Lynn to draft that language as she's described. The question, I guess, this is not a motion then. Do we need to discuss, do the commissioners feel that we need to see that language before we vote on it? Or are we comfortable allowing Lynn to draft the language that expresses that sentiment? And I would go with the latter.
We can always pull the rule down. I mean, we can start the
Yeah,
process.
it'll go out for public
Yeah.
comment anyway.
Right, so I'd make a motion that Lynn draft that language, begin that process based on the discussions that we've had.
Second.
All right, so motion's been made. There's a second. All those in favor?
Aye.
Opposed? Okay. The last part is the,
Little d is easy. When we were going through this conversation about, why historically we recognize certain accrediting bodies, Dr. Kerrigan pointed out that in terms of what CAP does, really the only program that we would want to recognize would be the forensic drug testing accreditation. So we wanted to specify that in the rules. It had not specifically said that before, and so we did that. But Lee also confirmed that none of the labs that we recognize that have CAP accreditation are missing that component. They all have it, so it's more to provide clarity. So we have that rule.
you need a motion on this?
I'll make a motion to adopt the new language that's been provided.
Second.
All right, all those in favor?
Aye.
Opposed? Okay. We're gonna take one thing out of order here. We have a speaker. Is Mr. Sam Benson here?
Oh, no, he isn't.
He's not.
He's coming back.
Okay.
Back for lunch.
All right.
He asked
We'll
me,
move
and I
on
felt
forward.
bad. I said, well, it's the last thing on the agenda, so it might be a while. And I guess he could
Yeah, I
do
was
that.
just gonna let him speak now so he didn't have to wait all day, but that's fine.
Okay.
That's fine. Okay.
Okay, can we get the PowerPoint with the licensing update, C, please? So we have a couple of slides that show the licensing date. I'm just waiting for them to.
We also have more materials.
Yeah, I mean, I guess if we're having issues with the PowerPoint, let's just start talking. It would be nice to have it for people who are watching on the feed. But this is the PowerPoint here that has the information. Let me just poke back there and see.
Here we go.
Okay. Yeah, can you just put it in the play? Back at the beginning.
Getting Snickers out there. Yes.
We got it. All right, so, we have licensed 1,154 people.
You deserve a round of applause.
No, not me, these guys. The staff killed themselves, Christmas Eve, just constantly until the end of the year. Really huge lift. Catherine, Jody, Lee, and Rodney did an amazing job. So we have 672 forensic analysts, 23 people who are provisionally licensed for a year because they are needing to fulfill certain requirements. They might be in training now, or we had a couple people who weren't able to pass the exam in 3 tries. So they're provisionally licensed. We have 25 technicians, 38 forensic biology screeners, and then our favorite subject, the blanket license. We have out-of-state laboratories that have been licensed under the blanket licensing rule that we're going to talk about in a bit. Those labs are half DNA and half toxicology. So we expect by the time we're done, a total of 460 people will be on those blanket licenses. And this is the income from the program. We had some money in FY18, the sort of eager beaver folks that applied right away. And then the lion's share of what we collected was in FY19, but we're only able to access 70,000 of that revenue under the guidelines that the LBB gave us. The rest of the money we'll be able to access the following year in FY20. So that's a summary of where we stand. Everybody got a card and a certificate. I don't know, Bruce, if you have yours. Bruce is licensed.
I'm licensed, but I'm not qualified.
Well, I hope you're qualified, because otherwise we're in trouble. All right, so that's the summary data on licensing. Does anybody have any questions about that before we get into the meat of some rule type issues?
So this issue related to only being able to access some of the income, that's not going to create a problem for you in the office in terms of the IT support and the software part of this, because I know that was quite expensive, but that's not going to be
So we have phenomenal support from the Office of Court Administration, which is our parent agency now. And David Slayton, who's the executive director, has told us that they will find a way to make sure that we get everything done that we need to get done. They have asked for...
Are you suggesting that Sam Houston State University would have done? Don't answer that question.
I'm not saying anything. Sam is great. In some ways, Sam, things are more streamlined at Sam. And in other...
In general, but it's not going to be a problem.
No, it's not. And actually, our CFO has asked for something called estimated appropriation authority going forward, which Sam had not thought to ask for when we did our LAR, the last one that we did with Sam. And so in requesting that, we would have the ability to spend with more flexibility. But right now, the reason LBB puts restrictions around these things is because they don't want income to become like a slush fund where an agency can just sort of willy-nilly spend it. So they put parameters statutorily around it, and then they will put some hard numbers. And right now, what they have suggested for us in the upcoming session is that they bumped that number up to 120 in the first year and 150 in the second year. So it's not like they are watching our revenue and they are making adjustments accordingly. So I'm not worried about it, I'm really not.
And there's almost no way we'll ever even get to 120 in the subsequent years, because it'll just mostly be renewal.
Tsunami. Yeah.
Right, there's a tsunami and then there's nothing, and then there's a tsunami and then there's nothing, because we're on a 2-year cycle. So I think it's all gonna work out. But that's sort of what I always say about everything, so we'll just hope that it does. And if it doesn't, we'll certainly let you know. The next thing, we published the forensic education, continuing forensic education rules, the next step that we are making there. And Greg Hilbig can talk about this, but we're gonna make a big push in the next upcoming weeks to create the list of recognized conferences that people can go to, the journal publications that they can use to satisfy the CE requirements, and create forms that people can apply and describe what they're doing in the form of CE so that we can recognize those activities. So that's a way high on our list of things to do, because people who just got licensed at the beginning of this month are already asking, how can I report my continuing education? And we're like, just give us a second and we'll get you set up. So anything else on that, Greg?
Just that we're like you said, we're working on developing a method for them to apply to get a pre-approved list. We already know these are good. And there's a lot of work to still be done on it, but we ought to be able to get it going pretty quickly.
The other thing that I should have said that I didn't is that, the licensing advisory committee met a lot to get this done. And they had to take time out of their work and their laboratories to come here to Austin. And that was a big, big part of why we're able to get things done by the statutory deadline. So thank you, Greg.
We'll agree.
Lee has here, she has harmonized accreditation and licensing rules, and what that just means is that there were some places where we've made changes in the licensing rules and not in the accreditation rules, so we just went through and fixed that. You voted to remove those knowledge-based competency requirements, and we went ahead and did that. We effectuated the vote to remove a licensing fee for military veterans, so they don't pay. And we have about 41 veterans. So some of those folks had already paid, and Rodney is working with them to get them refunds of their payments, so that's working well. We also needed to put an exemption in for work performed before January 1st for somebody who has no reason to be licensed after January 1st, to make it clear that people don't have to get a license now just to testify on casework that was done before the licensing requirement was in place. And then we did create that blanket license for out-of-state laboratories. Now, there has been a lot of, I think the blanket license served its purpose, which was to bring the out-of-state labs into the fold. But whether or not the way the rule is written now and the way the fee structure is now is the best option going forward, I think there are lots of questions around that. And an example of that is in your materials, we had essentially a letter complaint from a private toxicology lab physically located in Texas that said, like, hey guys, why are you giving all these tox labs outside of the state this benefit that we're not getting, and we're competing against them and we're here? And so we want to be responsive to some of those arguments. Now, in some senses, the response is, well, those labs are not primarily doing Texas casework, and if you're physically located here, you are, so it is different, but we don't know that for a fact. They could be doing casework all over the country, and so we need to really drill down on what is it that we're trying to achieve, what are the impacts of different licensing schemes for entities that are outsourcing private entities, essentially. What's the best solution for them? Not only financially, but also what type of oversight, what level of oversight is appropriate. There are people in the licensing advisory committee that take great issue with the fact that none of those folks had to take the exam, and that all they were required to do was watch the Michael Morton Act and Brady training and sign off that they had read the code of appreciated the code of professional responsibility and read it. So there needs to be conversations about what's the best solution.
On that front, the LAC proposed there be a working group formed to pursue this area. We wanted to recommend for participation that Chris Hartzell, who's our toxicologist on the committee, be included in the working group. It was suggested, Pat, that you be on the working group. We do need a DNA expert, because most of the, about half the labs that apply to the blanket are DNA labs. So I don't know, Dr. Badoli may have already bitten off too many activities to add to another working group, but we do need to get somebody who's a DNA expert involved as well.
And Dr. Kerrigan.
And Dr. Kerrigan.
Because there's so many talks labs. So
Yes.
the question just becomes, what do we do now with that rule?
Because there's a need for something for out of state, but My personal feeling, I think most people in OAC's feeling, is we made it too broad and too easy. And there's a big loophole, and I understand why we did it under the time constraints that we had. So I really think with a year before, we approved this for a year, so we have a little bit of time, but we really need to be working on it to figure out and give these labs time to react to whatever we come up with. So it would be difficult for the OAC just meeting monthly, even monthly, to come up with all this, plus we may not have the subject matter expertise
So
to do it.
remind me, did we put a time limit on the blanket?
They have
Well,
it
their
for a year.
license expires in a year.
Ah, that's right, okay. So
As
it's not
opposed
that
to-
it was
Not the
written
limit on
into
the rule.
As opposed to 2 years for the standard license.
So we just need to start from scratch and evaluate what is the appropriate level of oversight and what is should the associated cost be, and what we need to listen, I think, a little, we need to get a little bit more detail about the original objection, which was that it's too burdensome cost-wise and otherwise for the level of casework that some of these labs were doing, and that they couldn't segregate Texas casework from the rest of their case flow process. So we need to get more information about all of that.
I think you gotta separate out, when is it that someone is doing a test that is unavailable in the state of Texas, and therefore that's pretty understandable how you can exempt something like that, versus someone is choosing to send it away from Texas where all the tests are available to another laboratory for whatever their reason may be. And everyone in Texas has to go through all this, and then those that are out of state do not. And I think it's a valid question. It's a valid complaint.
And I think the reason why you see the complaint from the lab in Texas in toxicology is because toxicology, according to the most recent census from BJS, is the most outsourced discipline of all the disciplines. And it used to be DNA, but now it's toxicology. And some of the reason for that, not exclusively, is just that we don't have capacity. So it's a difficult issue. If the publicly funded labs had the appropriate level of support from the legislature, we would not be outsourcing as much as we currently do. I mean, some of it is driven by economic factors, there's no question. But a lot of it is driven by the fact that the labs are capacity limited. And if it's going to take 8 months to get toxicology done, then it may be outsourced. So,
In the state, you have to get competitive bids too, so there may only be one private tox lab in Texas from home.
Well, some of it, I agree, some of it is support, some of it I think is choice. And I mean, we, at one point, our toxicology turnaround was exorbitant, and now it's less than 30 days. So our county, we got support. And so I think it has to be evaluated, but again, choosing to send something elsewhere and then those people kind of get a pass is, it's not fair in my opinion.
I think
Yeah, but can I add comment about I've talked to a lot of people from both DNA and tox private labs since the last discussion on this topic, and I don't want to speak for them, but so that letter that was sent, that's just one angle. A lot of other individual analysts were saying that they feel it's just a broader picture now with the last conversations. If someone can just voice and say, well, it's too burdensome, I can't, they're going to see that as a loophole with the commission and think that's all I need to do, and the commission's now going to make an exemption or make a new program. And I just would hate to see that as a pattern and then go into what we see with question documents. And I just think people are saying that now. And yeah, it is I'm not saying that's your reality and truth, but that's how the perception is, that because of course the public labs, it is burdensome to us as well.
Yep, absolutely it is.
And we do it anyways because we want to and we need to. And even though some of the private labs can threaten, well, we just won't offer that testing. Well, first of all, maybe they will do it if you still make the rule. Or if they don't, that's their choice. So yeah, there is a lot of kind of external comments about people just need a voice burden and then it'll be accepted, so.
It's
Worry about
more
that.
complex, I agree with what you said, but, like take the sexual assault scenario, there's a mandate now that all sexual assault kits have to be done, yet there's not a capacity within the state to meet that demand. So it's almost forced to be outsourced, not a decision. If they have to do it, and there's a time frame on it, that even exacerbates it. So I don't have an answer, I'm just saying it's complex, and that, but there are obviously things with choice, and there may be some where there is no choice.
And also, some of the arguments about burden, I think were general in nature, but others were literally like, we did 110 cases and we have 120 people that would need to be licensed here. And you just do the math and you see that they're not sort of frivolous arguments. They are things that we need to follow up on for sure, because I'm not sure that that's true in all the entities that we gave blanket license to. But at the same time, once you write the rule, if they are eligible, they're eligible. And so that's why we need to reevaluate what that rule does, what it requires, what it doesn't. I think for the financial piece of it, to me, that's a little bit easier to adjust than the oversight, which is what the LAC is more worried about. Like, what is it that they have to understand before doing Texas casework versus what the publicly funded labs are required to understand. And I think they feel like a fairness issue there. On the other hand, if you're in a laboratory where you're just one part of a big production chain and you don't even know what state cases you work on, and you're not physically anywhere close to Texas, it's hard to articulate why you need to know all this stuff about Texas law. There's two sides.
Well, it's a valid discussion, but the commission's already abdicated with the FBI, which I still think was the wrong decision, but nonetheless. So do we keep just, whenever someone says, it's a problem, and we just keep going? I think it really has to be addressed, and a fairly hard and fast rule. We have to come up with a decision and live with it, but.
Just one other thing the LAC noted, and it was on Lynn's slide, is over a third of the licensed individuals are under a blanket. So it's not some narrow group of people that this is hardly affecting us. It's over a third of the individuals. So it's pretty widespread. There's a big group of people out there that have not met the requirements that the FSC set for licenses. I know they got an exception to their license, but they didn't meet all the criteria that were developed. And from an LAC standpoint, that's problematic.
Because some of them may or may not be doing Texas cases.
May or
right?
may not.
Right.
May or may
So
not.
that's why the number is artificially large, because, for example, those numbers that you provided earlier, and I'm sure they were correct, but
They may or may not.
large number of people, small number of cases.
But
Therefore,
this just becomes the cost of doing business.
Yeah.
If you said every one of them had to be licensed, that cost then is going to be put back on Texas to pay for those cases. So then it comes a balance, is that may be a better tipping point than anything else. What can you bear and what can be, and you can use that as a formulation to move forward. But it may be that Texas has to pay more to do a case.
I also think Dr. Bernard's point that separating the two, we can only do, we're the only people that can do this test, I get that. And that's where the 110, 120 numbers come from, is if you're only doing 110 cases for the state, you're probably doing cases nobody else can do. Because the labs that are doing things everybody else can do are doing high numbers. So I think that 110, 120 number argument, if we decide let's proceed with the narrow exception of you're the only people that can do it, it's going to address that.
but policing that or administering that is a can of worms. Because how would you determine, you'd have to literally compare the panel of tests that the lab in Texas would be doing and the panel from the
Well,
outside of
I think that if you talk to laboratories, there are certain tests that, in, say, I'm just picking forensic toxicology, that almost zero laboratories do. They send it out. It's not cost effective, it's difficult, it's hard to have people trained in it. I don't see that as a problem versus routine toxicology that you're sending out because you're just choosing to send it out. But there are other laboratories in Texas that you could send it to.
So could you do a blanket license fee? Limit number of cases, you pay this much, you do this many cases, you pay this much, you do this many, and that way it's based on that.
The volume.
You could do it based on volume, and it would be for a certain recorded period, because the other thing that the labs, I think the private labs face is fluctuation in volumes of testing. Because contracts get renewed, then they don't, then they get renewed again, then they get increased, and, you could do something like that. And that would help with I think, to some extent with the fairness issue. I think the challenge is biggest in those laboratories that do not do anything even close to cradle-to-grave type analysis, where it's so segmented that at any point anyone can touch a case. Then you have a vast number of people for what could sometimes be a large number of cases, or sometimes not, or sometimes be zero. That's the challenge when we're talking about Texas cases.
So what's the proposal here?
That we need
establish a
to
task
work on
group?
it, yeah.
Okay. And that would involve members of the commission and members of the LAC?
Yep, and I think we don't have to decide that today.
You need a motion on this, or
I can
It's
send out an
unofficial.
email asking who has the time to
All right.
participate. But I do think we should set up the group then.
Okay, all right.
A backup question on, I think it's number 3 here, removal of knowledge-based competency requirements. What is that?
Do you remember we had that outline of training subject areas that all the labs needed to cover, and we decided to at least temporarily remove that while we figured out what was the best thing to do with those?
So we're not removing, like if you had a DNA analyst in Garland that's going to get licensed, they still go through the training of
Yes,
DNA
yes.
and get signed off on it.
Yes.
So we're not removing that.
We're just not duplicating it by saying, and you also have to tell us that you did that in order to get a license. We're removing you have to certify that your people did what accreditation requires, which was going to be too much of an administrative nightmare to manage.
And there's just at this point, not enough consistency across labs in the state, in the training programs to really coordinate to get something that's agreeable to everybody, to say this is required.
So we need a motion to set up a committee to evaluate and work with council on looking at the out-of-state laboratories. Is there a motion? Second?
Second.
All those in favor? Opposed?
Do we have some representation from the private labs on the LAC currently? Do we still have that? I know
we do.
Rob Middleberg was one of those reps, but is
We
not
have
on.
somebody from Microtrace. Now,
Okay.
they don't do the volume of work that, like a big tox or DNA lab.
But we've got somebody who's representing the.
We
private
do, we
sector.
are gonna have to do quite a bit of outreach though to the, I mean, one of the nice things is now we know exactly who this affects. And we can reach out to each and every one of them and ask them to come and present to us. The next one, Lee, do you wanna talk about that?
Yeah, sure. So these are the draft licensing rules that we have outstanding for approval today, and they come from things we discussed at the last meeting, at the licensing meeting yesterday. The first one here is just an expansion of that pre-January 1 exemption that we talked about in little b above, where we consider when we add a new discipline such as bloodstain pattern analysis, which we anticipate doing later this year, just making them not subject to the requirements until the date that they are subject to the requirements. So in other words, if they did an analysis prior to the date they were subject to the licensing requirement, it would be admissible later on. And so that rule just makes that clarification and expands what we already had as an exemption. Little two, does anybody have any questions? Just stop me if you do. Otherwise, I'll just roll through these. Number 2 is something we talked about at the last meeting, a request to allow university students to be eligible for the exam. And we talked about yesterday having to be eligible for the exam only for one try, because you don't want to get an employee that comes to your lab and then says, well, I've already failed it 3 times, so I'm on my 4th attempt. So I'm going to revise the rule that you have in your materials to limit them to 1 try. And then we also talked about not restricting it, the number of attempts to 4, but to giving the committee the discretion to make that determination on a case-by-case basis upon request from someone who's asking to take it a 4th or even a 5th time.
They did want to make clarification though. The LAC is recommending a rule that will, once you've failed the 3rd time and you've received notice, that triggers some obligations on the part of the candidate. So within 30 days, they must seek special dispensation to take it a 4th time. And then within 90 days, they have to have successfully passed it. Because the concern is that they could just sort of hang around on a provisional license for a really long time. And so we want to set some parameters around what's reasonable for that. So that's what was proposed. Did I miss anything, Greg, on that?
That's correct.
For little 3 here, Lynn, do you want to talk about the director's authority?
Oh, yeah, so we do criminal history reviews, and for the vast majority of them, you know, you look at it, it's an old DUI, and you know that that's not going to impact their ability to continue to proceed with the license application. And I would just like the authority for things that are old, to be able to not hold that person's application up and delay them from proceeding while we wait for the LAC to meet and everything. Right now, we're putting everything in front of the LAC for criminal histories. And the way it works at our sister agency at JBCC is that the director has the ability to make those calls. It's always appealable, but at least the initial calls, because people, when they have anything on their history, they get really worried about what's going to happen from there. And it'd be nice to be able to expedite things for folks and not have them held up.
So what constitutes old?
Greater than 5 years?
The way the law separates offenses when it comes to occupational licenses is that if you want to reject a license for anything above a Class C misdemeanor, and it's older than 5 years from the time of application, you have to perform an analytical review, an assessment of the case to determine whether the offense impacts their ability to do that job. If it is within 5 years of the application, then you can reject it. Reject that person's license, period, if it's an offense that's a conviction above a Class C misdemeanor. We only look at convictions and deferred. We never look at dismissals or pretrial diversion. That's the way the law works.
When you say a conviction that would impact, do you have a hypothetical?
So the guidelines that are in your materials talk about guidelines for criminal, we're going to be going over this later, but you know, common examples that are used are if you have an offense involving theft and the occupation is that somebody is a locksmith and they're licensed to be a locksmith, you would deny their license because that gives them an opportunity to commit that offense again. So the question is really to what extent their job gives them the opportunity to reoffend. That's a big component of the analysis. Now, for forensic analysts, it becomes a little more complex because these are expert testifying witnesses, and one of their key jobs is to testify on the stand and they can be impeached, and so questions about impeachment come into play, and it gets a little more complicated than your air conditioner repair guy, but you really have to create the nexus between the offense and the job if it's older than 5 years. The more recent ones, that is not required. Does that help, that breakdown?
Can I jump in real quick? Just what the LAC recommended was along the lines of what Lynn said, basically with, if she, because the vast majority of what we see, they're just no-brainers. Okay, this is 10 years old, has nothing to do with their job. We're gonna go. So basically, what we recommended was that Lynn be authorized to approve the application to proceed, and or tell them, I have concerns, but we're gonna need to wait till the next LAC meeting to discuss that. So that she doesn't actually issue a denial on her own, but if she has concerns, it comes to the next level for deliberation.
It would be only for the ones that I look at and say, this person's fine, they can proceed.
And that's the vast majority of what we see, and, I mean, quite honestly, it's not a great use of time to go through all those, because it's pretty clear.
And usually what I've done is I'll get Bill Hines, who's our defense representative on the LEC and knows this stuff inside and out because it's what he does, and Tommy Ashworth, who also knows this stuff inside and out. He's the prosecutor, and we get on the phone and I say, let's look at this together. Can you help me make sure I'm understanding what I'm seeing? And they've been tremendously helpful. So it's really, in most of them, it's just not a hard call. And the nice thing about the licensees who we're dealing with is the vast majority of them work for publicly funded entities that are in some way or another affiliated with law enforcement. Not all, I mean, but a lot of them are, so they're kind of come pre-vetted. Those criminal checks have been run already for most of them. We're basically seeing DWI type offenses, most of which are quite old. So we would need a rulemaking in order to allow me to do that for offenses beyond a certain date. And I would be, totally fine if it were, if it's even 10 years, that would be fine, if you want to give that buffer. Just those old ones, to be able to get rid of them would be good.
I'd really recommend 5 years. Because that's what the law states. If it's more than 5 years, it's got to be tangent to their, I don't know the word, but it's got to be related to their job function and their ability to do it. And so few of these cases do. I don't see any reason to push it back to 10, but whatever y'all are comfortable, of course.
So we need a motion.
Okay, I was wondering if we're gonna have to do motions on these other parts, or that's all, doesn't require.
We could take a motion on all the ones I've already drafted
Yeah.
in your materials,
Yeah.
and then, but this one in particular, I have not drafted.
Okay, so is there a motion to accept the previous two rules, 1 and 2, under D, that have been previously discussed?
With the revision.
Yes, sir.
With revision. Yes? Second?
Second.
All those in favor? Opposed? All right, now we need a motion regarding the delegation of the review, the authority to either the presiding officer or the designee regarding past criminal history.
I have a quick question. When we're talking about this 5-year time period, is that 5 years after the person has finished community supervision? Or
the
it's
day
5
of the
years from the
offense,
day
I
of the
believe.
offense?
I can look at the occupation.
It's the
Because I think that, well, I think it should probably be because if you look at it in a criminal case, right, it would be the 5 years after you completed your supervision.
Or whatever.
Like, if you're technically on probation, 10 for 5 or 10 for 7, and then you're asking to come back and get a license, technically while you're still on supervision, like, how does that work?
It's the date it was committed. An offense that does not directly relate to the duties and responsibilities of licensed occupation and that was committed less than 5 years before the date the person applies for the license.
define.
the date that they were, the date of the offense.
The date it happened.
Yeah, that's problematic for me.
Yeah, I
We
think so.
can move it back more. I just want to get rid of the ones where it's like, this guy's 53 and when he was 19, the TAMU cop arrested him. I mean, we can get rid of
But all
them.
we're saying is, you're gonna review and make a
Yeah.
decision. You may still say,
Not me.
you're not gonna give this person a
Absolutely.
license. So-
Yeah.
So it's still an option based on
Yeah.
what the event was in time. You shouldn't say, maybe you need 6 years in this case.
We've already moved from 10 to 5, so 5 years after release from custody or supervision.
Supervision, I think that's.
I like that.
I think that's the best way to do that.
Yeah.
I mean, heck, you can't even have a gun in your house for, if you're placed on probation until 5 years after you're off community supervision. So I think that.
I guess the question is, I've never had a DUI, so I don't know what happens. So when you get a DUI, what's the custody and?
Well, it depends on what it is, and if you have a
Yeah,
class
so-
A, it could be up to 2 years probation.
So it's gonna vary. everything's
So it would be
going-
5 years after you get off of your probation.
But it could be 3 or 4 years before you go on probation. That's some of the ones we've seen, there's.
Time lag.
Yeah, it could be, it could be that too, and, that's, if you want to have a trial or something like that, it could go as fast or slow as you want it to go. You could plead early, or you could take it to trial and you go through the system and take a while to get there.
So here's what, I think the LAC, the only ones that they wanted to give staff the deference or discretion to dispose of are ones where we were not gonna hold up the application due to the date of the offense. And so what you're suggesting is that, so anyone that I say, I think we should hold this up, that goes to the LAC. That's automatic. Like, I'm never gonna deny an applicant the ability to proceed on my own. So there's that. These are only for the ones where we say, okay, this thing that has come up on your background, don't worry, you can keep applying. And I think it would be totally fine to make the parameters around that. Anything that is older than 5 years from the date of
Completion of sentence or completion
It's
of
just,
supervision.
that language says committed.
It does
That's
say.
offense committed. I'm thinking completion of your sentence, whether that be confinement or.
So you're talking about
community.
limiting Lynn's discretion so that she doesn't have the authority, basically, or the deference to approve a license if it's within the 5 years from not the date that it was committed, but the date that the community supervision is over, right?
I think that would,
I'm trying
I
to
think
think,
what
because
the
that's
argument would be.
confusing okay, so we get a hit and the person committed the offense in 2010,
Those are on,
goes on in 2011 and is finished in 2013.
It's gonna make it hard to make.
That's gonna be
determinations.
outside of the 5-year windows, so I could make that call. But if their community supervision continues into the 5-year window, those are the ones that you wanna take a look at, right?
I think so.
Yeah, okay, that's fine.
So.
If we can figure out when their community supervision.
All right, how much work is that gonna be?
Why don't we just make it 10 years, and then that way,
From
10
the-
years from the date of the offense. Would that be okay?
So if they're 10 years
I
old.
guess here's the question. If it's a felony case, and I guess, I may be, correct me where I'm wrong, if it's a felony case, you could be on probation for 10 years.
If it's a felony,
Then we're out.
it's coming in front of you guys. There's no
Okay.
way I'm gonna get a felony and be like,
I just don't, we're
Oh,
talking
sure,
about
go ahead.
a license
Keep rolling.
application for a person that's going to be impeached on the stand.
no, if it's a felony,
You have a pending
no.
case right now. Sorry, you have to go report to your probation officer at lunch, come back after and testify.
So let's say,
That's
no,
probably-
misdemeanors,
Well, yeah,
so let's see,
license
let's say
anyway.
Well, I'm just making sure.
misdemeanor offenses that are committed fewer than 10 years from the date of application, you want to see them. Whether the recommendation is continue or deny. But misdemeanors older than 10 years from the date of the application, staff can make decisions about.
And just to be clear, we're talking
That's
about the
fair.
LAC, looking at
Yeah,
it
we
right
should
now.
handle it, Chair.
Okay, that's fine.
We're still okay with giving them the designation to do that.
All right, that's a long time, so, but that's what, is that what the motion is going to be, 10 years from date of commission?
Yep.
Okay, so, do we have a motion on that?
So moved.
Okay, second?
Second.
All those in favor?
Aye.
Opposed?
And then the tech reviewers rule, that's super simple. We just made clarification in the rule that this does not apply to someone who strictly does technical review in a laboratory. This is for a person who would not otherwise be available or ineligible, or is ineligible for the license. And we created this rule particularly, the best example is for bloodstain pattern analysts. They don't have anyone to tech review their work, so when they later become subject to these accreditation requirements, this is the avenue that that person is going to get a license in. And so the laboratory will apply to us to approve that person for a tech reviewer's license in that very narrow circumstance. And so we just wanted to make the rule more clear than it was prior.
And the State Farm Marshal's Office had also asked for one, but now they don't need it because they've enrolled into DPS. And so DPS has tech reviewers. So it's really gonna be a tiny group.
Okay, so do we have a motion on accepting the revision, providing clarification with regard to the applicability of the technical reviewer's license?
So moved.
Second?
Second.
All in favor? Opposed?
And then 5 here, that we addressed this a little bit in 2, but I think there was an issue with provisional licensees basically having a license when they're no longer eligible for the license because they failed the exam 3 times or 4 times even, for example. So should we continue their licensure through the year that the provisional license was issued? But we talked about making them ineligible or no longer licensed at the point where they failed the 3rd time. So we're going to revise the rule to make it say that, right? Isn't that what we talked about, Greg?
So it's a
yesterday?
30-day window that they have to apply for special dispensation, and then they have to have passed the exam for which they were granted special dispensation within 90 days, or the license automatically extinguishes. And the idea behind that is for people who are ineligible for the license, and this is a tiny minuscule number of people, because of an inability to pass the test, that they get a window to transition to other responsibilities, but that window is not too long, that it, 90 days seems reasonable.
Yeah. Basically, yes, as it's written right now, they would keep the provisional license for a full year, having already exhausted their test, and that's problematic.
All right, so is there a motion? Second? All right, all those in favor?
Aye.
And that brings us to criminal history.
So it's just be long. We need motions to- All right, so
Okay,
why don't we,
I have one small clarification on 2. Before we do the next big one, could I address that?
we're going to break
or
for
should we-
lunch as soon as,
Okay. So I went back and looked at the language under 2, which was the permit for the university students to take the exam. And so I understand that the LAC made a modification yesterday to allow the money to take it once, but I wanted to point out a couple things to make sure these were intentional. So the first thing is, right now, the way that it's written, we've got 1, 2, and 3. Was it meant to be that it's 1 and 2 and 3? And appears between 2 and 3, but not between 1 and 2? So 1 is currently enrolled in an accredited college level university or program. 2 has completed so that, I think that should be and 2 and 3, okay. The next thing is currently enrolled in an accredited college level university or program. Was it the intent that they were bachelor's, master's, PhD? Because enrollment in a college level program could be a certificate program online.
No, we're gonna change that to match the language that we have elsewhere in the licensing rules that references education. I don't know where that language came from. I think that's a typo, the college level. That's not from there.
It's probably just my made-up language.
I'm just gonna pull it from what already exists in that regard with respect to.
Okay, so we didn't vote on that then? Because I thought
These are all
voted.
rules that were drafted from the last meeting.
Because I've just got a concern there that we need to be very clear about what we're talking about with accredited. I'm assuming just an accredited university, not an accredited program.
Yeah, we have a definition of what an accredited university is in the rules, and so we
Right.
just need to state that wording in
And
the rule.
I would clarify whether or not you really mean a program, because the academic programs can be all kinds of things. Are we talking about an online certificate program that could be offered anywhere? Or was the recommendation that it was more, a bachelor's, master's, doctoral type program? And then also, the way it's written currently, it doesn't say that they have to be enrolled in a forensic program. So they could be enrolled in business and take this exam. So,
Forensic related program.
yeah, so.
Well,
I think
well,
part
what
of
if they're
that,
in a chemistry?
Yeah, chemistry, biology.
Right, well, but right now, there's no clarification. It doesn't say natural science, forensic
Okay,
science
so
are related.
what we could do is track the language that we have elsewhere in the rules
And
about.
incorporate it in.
Yes, that's how it should be. It should be consistent with where everything else, and we'll send it to you before we publish it.
All right, let's take a lunch break.
How long?
20 minutes? 20
Yeah,
minutes?
20 minutes.
20 minutes.
I don't know, I never, I hated that.
It is a stellar day. And even we nobody's upset. That's the difference. I just think in this case, is he sitting on this side of it? And the other side was silent. Hey, I want to know, I'm the only one up here, I just was. I'm special.
I don't get emergency.
I'm gonna suspend the license.
About 30, 35.
Well, yes. So, because it's always clear, because we always have to set that, because it's treatment, direct rules and stuff. And so, once I just come out, this doesn't get us past the chain of custody on the out-of-state, and if they're clear. And they're doing it, then at least we can file a forensic analysis certificate. And then if the state, if the defense doesn't reject it. Yeah, they should, because they should. And then we'll have because right now, it's clear lab, it's not an ANAB lab that did the original testing, so I think they would let us do that too. They would let us use that same.
Do we have to do that?
There's just.
Oh, because they're not safe.
Or even if there's a test, but the same testing is done, and it's done by the CLIA lab, which now is permitted in Connecticut. I think. Did you get
Some damn thing that doesn't have.
to stop the chain issue and stuff? Maybe.
Yeah.
It's worth a shot,
I'm okay.
because that's so expensive.
Yeah, you don't.
We just don't do it.
Nothing, we get to, you got admission? No.
Yeah, all right.
Somebody's
Sorry,
going to go
can't do it.
probation revocation? No. Okay, you're extended.
We're hoping that we will
Then they-
all be out of here by then.
That's reverse incentive.
Exactly.
But we can move you up.
Yeah.
We'll do the
Yeah.
next thing and
Test
then
me.
I don't know, I mean, I think that could be helpful.
You're right,
you
you're
can go
right.
in the space where the NIST.
All right.
I just cut a deal off of that.
That's true.
I really don't think that, honestly,
Well,
those
if it's
things
not-
are gonna go fast.
If they're gonna, then we can just stick to
Well,
some things.
I thought that before, but 2 or 3 things blew up, so.
Thanks.
Did you order anything?
I did,
from Jimmy
yeah.
John's? Yeah, you should go grab it.
Things going. I just saw a picture she put on.
Did you bring something home?
I didn't order something this time.
You know, one of the kids ASD and it's just a
Yep.
no big deal.
Right. Yes.
Another kid gets it and it shuts down their own. Like you see on.
Those don't come to us unless they die from it. Because if they're in the hospital.
They know what it
qualifies. Well, it's not reportable to us.
Yes.
What do you? I don't know. I'm thinking about it. That's why I'm just. I usually get cafeteria, or I'll get flat white, or
Well, it's called soda.
just less milk than a latte. I
And
like it.
unfortunately, it's not to get drink all the soda.
So, yeah, so, I mean, that's the, you know,
But
I was
it's,
gonna call him and
it's
see,
basically
because that's checked
low
out
carb,
anyway, so.
low calorie.
And I didn't bring lunch.
And I just decided I had.
Do you want something else?
Just
Because I asked him, I said, hey, is there a chance
My
you can
God, too big.
a coffee and
So,
some almonds or something? So,
Did you get some carbs?
I did. I just did that. I just,
Well, they don't have
you know,
interim
fine,
meals,
whatever. I
which is
just
a little
If he
harder. I've
goes,
done the
I would
Nutrisystem
take
where
a,
you eat the snacks in between. I can do that.
Grande, Venti.
Well, they've got one back there. But my wife, the biggest problem was my wife said, well, what am I supposed to do in the evening? It's your problem,
Actually,
not my problem, because you gotta buy the meals.
Oh, okay.
She talks about being expensive. This is more expensive. So I'm like, okay. So she started out, she was gonna do it, and then she called up and said, yeah, I'm not doing it. So
you just basically have a big piece of iceberg
there's
that is.
turkey.
Is there mayonnaise? No mayonnaise.
What do you got?
Now you could,
Huh?
well, that's blue cheese. Yeah. But
Is there anything you need me to stick around for the rest of the agenda, or because we moved through licensing today?
Well, we have the criminal case evaluations.
That's up next, right? I'll stay for that. Once those are done, I'll.
Yeah.
that's it. Okay, no problem.
Thanks. Did you order a lunch?
I didn't, because I usually grab something on the way out.
Yeah.
Usually, we wrap up around lunchtime with my father, so I.
Right. Well, I'm sorry that it's taken a little bit longer.
Oh, it's not a problem. I'm not, like, dying to get out. It's just one of those that
Be
if I
nice
was
to-
through, I'd
You-
go
yeah.
and I'd listen to y'all on my phone on the way back.
Oh, that's not what you do?
It
You
is.
poor soul.
there are better things that you can get than that.
That's true, but I figure I might as well, since, I'm driving down here on all that, I might as well listen to the whole thing, so.
Yeah.
I know it got me to listen to these podcasts.
Absolutely.
Well, my wife and I came down I guess it was last week. We listened to Bagman. Well, that's actually interesting because that's about the investigation of Spiro Agnew.
Oh.
And it was done by Rachel Maddow. If you listen to her.
I know Rachel Maddow.
Yeah, she's like way past liberal, but she's really smart.
She's a roast.
I believe it, listening to her. I mean, I don't agree with some of her ideas, but it was well done because it's awfully comparable to now. But it was fascinating about, because I was not born, but I was in high school when all that was going on, and all you kind of remember something about that. That was just what he agreed to walk out, to not serve time was his big deal. But all the stuff they had on him, they were just worried whether he could actually, if they tried to prosecute him, he could get immunity. And that was why they wanted him out before. What's on Jarvis on the way over here? The AG who had been appointed by Nixon was having to investigate Nixon and was having to investigate Agnew. And it came from these guys in Maryland where he had been. And they thought they might get some representatives and they had no idea what they were walking into. And it was it's fascinating, the whole thing's fascinating. So listen to that, but I listened to one that's a lot of fun called King Falls, that's entertaining as hell. About a fictional little town and all the ghosts, this and that, it's hilarious.
The Tenenbaum building is right to now.
They cut off the break before they went.
Communicate on that. Very ideal. What was the Texas?
Mike, you can come up and sit with us if you'd like. You don't have to sit over there and eat on your lap.
County chair.
You doing the task?
I just, no, I'm just, no, I usually don't because I spend all the time.
Take a religious topic and decided to fast over.
No, thank you. I'm really, I'm okay. I promise. Yeah, I'll get something on.
Yeah, I never miss a moment. I never miss a moment.
Yeah.
I'm starving.
Yeah.
Donna's gonna get me her husband's a minister, but I'm at the end of the meeting like.
Her husband is just rock.
He's hilarious. Is he?
He's completely different than Ron.
That's hilarious.
He's really funny.
He is hilarious.
Very dry sense of humor.
Jump the gun, maybe?
Did Megan talk to you at all?
Yeah. No, there's,
Yeah.
there's.
So, it's okay, I can turn the camera.
Do whatever you want.
Okay.
Yeah, you can take all the pictures you want.
Okay, I'll have to wait till Casey gets back, so I'll just want to make sure that if anyone's coming here, start taking pictures.
I'm in the healthy phase, that's like.
I think some of the like firefighters.
I'm not sure I want to look to be 150.
Possibly, and some of their scenes.
Lynn, if you have some to eat.
I went out. No, I'm okay.
Everybody's bothered.
He has eyes over here.
He looks so pathetic over there.
No, he's done it.
We finally had some little controversy in our meetings, I think we need energized.
Set it on fire. Which one? And then put out a fire.
Which one, the one we were talking about,
They
with
went back
the,
and retrieved.
get more information before we
And they
make a
had to
decision.
Oh, right.
Singapore.
And then all kinds
I'm
of
out here, I'm out here to go to Singapore.
Wow. And then my dad's gonna visit and
But don't we going to
retrieved it, and so
Utah
then they
sometime?
wanted, he's already been.
Oh, see, he went there, so I can go see.
Yeah, I just never.
I do.
Go to Utah?
Yeah, I had to ask the person.
For someone without me?
Well, then on the street, so we waited for you.
They just wanted to see.
Sorry about
They just lowered their
that.
driving limit.
They were like, you talked about it.
Wait, 05. Why not 5? That went into effect in January. We're no longer a .08 country.
I can see that.
I'll see some time. Okay, I don't want your. Are
there a lot of drunk drivers in
Your opinion.
Only thing I've got is stump the director. which means
Average
it's-
Joe. I'm gonna text her next.
What was the motivation?
Yeah, it's like, hey, what's the woman at the box say?
Yeah. I mean, was there a single case and somebody got
But I
fired?
find that
The
the
American Medical
coordinator here as
Association
well.
been advocating for a long
She hadn't
time,
heard
National
anything about
Safety
the
Council, we wrote a position
Collected
statement on it 3 years ago.
Same, 5 is the right way to go.
Yeah, I mean, and that's what it will be in the future across the US, and say, oh my God, can you believe it?
So there are studies that say at 0.05, you're
Oh, yeah.
this
That you're
incapacitated.
I've heard of some.
We're not incapacitated, but you're still impaired at a point
Yeah,
in time.
that's what I'm saying.
Well, the problem is, it's not like Europe where you can just walk.
This goes into.
You gotta, they gotta have enough, call up somebody to come take them home.
That's why they have Uber.
Right, but they gotta do
It's
it.
funny, I was always of the impression that .08 was like 2 beers.
But ultimately, the self-driving cars, if they get to that, then you just, all you gotta do is be able to get in your car.
All you need to do is go to a prosecutor convention, you get up a prosecutor's lodge, and an investigator will come out with a portable breath test. It's
start blowing just to see where you're at.
Most people who are at the
All the
point of weight would never, they feel, you feel pretty intoxicated.
We're seeing driving, of course. There's one guy that was 24, and he was on a motorcycle.
0.4? How would you?
He's on a motorcycle? Yeah, he was arrested. Now, he had a wreck, but he wasn't driving well.
24. We had a .45 in a DWI in Mexico once, but they one was a motorcycle.
Let me tell you, I did a case, the woman was .9. Now, she died from it.
No.
And her vitreous was 1. That's the highest I've ever seen, ever.
.9? What does that mean? How?
She died from alcohol poisoning?
She would chug a bottle. I'm sure she passed out and she just kept absorbing. I thought about writing on that just as a kind of a technical paper. That's how high, that's the highest I think we've ever had.
Doctor, we had one when I was just intern in Portland, 0.37. So I entered in the DA's office. So the guy walked into the police station wanting to apply to be a police officer, and they can tell he is an Irish guy. That's important to the story. Not because he's Irish. That's important to the story because
I'm half Irish because
I know,
I have no idea how it's going.
because they say, look, you can't just come in and apply. You have to like think that, you know, kind of like a form and.
It's right there.
And I think that you're intoxicated, and he started yelling at them, telling them that he fought the Irish Republican Army, and this is a bunch of bull. And so he's yelling and screaming at them. He walks back out to his car. The guy tells the sergeant, and he said, I think he's drunk. He's like, you can't just let him go out to his car.
That's.
So she said.
Let's get going. Let's finish up number 5 and then move on through.
Okay, so the next one is with respect to evaluations of applications and criminal offenses. If you take a look at the matrix that we just passed out and it was in your materials, this shows all of the offense types that came up during criminal hits, when the offenses were committed, and what the LAC decided with respect to all of them. Besides this last one that we want to talk to you about, every single one of these offenses were greater than 5 years old. And so the thinking on the part of the LAC was that you would have to make a connection for those greater than 5 years between the offense and the person's ability to do their job. And they did not see that connection in any of those particular cases. So the recommendation was to continue and allow those people to apply for the license, in part in consultation with the lawyers who said that for cases that are older, a judge would not even allow a discussion about those offenses in a criminal proceeding. But we do have one applicant who had a DWI with a .19 in March of 2015 and served 18 days in county jail, and then about 2.5 weeks later was arrested again, and ultimately that was pled down to obstructing a highway passageway. This individual is currently under community supervision and will be under community supervision until March of 2020. And in talking to my counterpart at the JBCC, which licenses guardians, court interpreters, and court reporters, and process servers, they do not license people who are currently on probation. And they will deny the license and then have them reapply or suggest to them that they can reapply upon successful completion of probation. And in keeping with that, as well as what we were able to ascertain, and you can see it in your materials, between the pleadings that were submitted by the applicant and the Office of Inspector General of Texas DPS looked into both offenses and wrote reports on both of them. Taking that into consideration, taking the letters of recommendation that were submitted on her behalf into consideration, the LAC's recommendation was to deny the license and let the candidate know that she can reapply upon successful completion of community supervision.
At which time she'd go back under being evaluated by the licensing committee.
Yes.
Because she'd be less than the 10 years.
Right.
So she's got 2 DWIs in the past 3 years.
Well, the second one was reduced to an obstructing, but it was reduced because it was charged as a second DWI, but there's something called, I guess, the Schmerber magistrate warrant, where they list who can take the blood, and her attorney was able to argue that because the individual who took the blood was not one of those listed individuals in the magistrate's warrant, that it should be excluded, and it was excluded. And so it went down to an obstructing, but with a 2-year probation and so forth. She does have 3 letters of recommendation, as well as a letter from her probation officer, who is not allowed to give a recommendation letter, but just provides sort of the status of the person's lives. And the recommendation from the LAC was unanimous on this. And if if the commission were to decide to deny, then that would trigger her ability to appeal through the SOA and so forth. Or she can wait it out until she's done and reapply.
So the recommendation was denial and let her apply when she's through with her probation.
That was the recommendation.
Okay.
Is that correct, Greg?
Yes.
All right.
Just to let you know, I can't really talk about any of the details of the case because I had to recuse myself. But I can confirm that was a recommendation.
The applicant originally worked for DPS in Austin and now is employed by a private laboratory also in Austin.
So is there any further discussion on that?
So the options in front of us are to deny and while she's on probation, and then she can reapply,
And make her
or
case.
and then are there any other options in front of the panel?
Yeah, you can grant the license.
Yeah.
You can grant the license, you can deny the license, you can deny the license and say that you may reapply, once you've finished your probation. You can do you can grant for sure. I'm just letting you know what the recommendation is.
It goes counter to what we just got through talking about earlier.
No, I just didn't know whether I didn't know exactly what was in front of us.
You can do whatever
I know
you
where I
want.
am, I don't know.
The LAC recommended what it recommended, but you can look at those letters and decide that you think that she should be granted the license.
If we have somebody who is licensed and they get arrested for a second DWI and it's reduced to obstruction, we're not going to be suspending that license. It's not a criminal turpitude, it's not a felony.
Under the, what you call it here, it says that it is, hold on, I'm sorry. The
what?
Supported guidelines.
Then in
multiple
here's my
DUI
nursing, I've
crimes.
done plenty of nursing board representation. Y'all are not too upset about the first DWI. The second, there's going to be some rehabilitation efforts made before you let them continue to practice. So I just, I always like crimes of moral turpitude and felonies as prohibitions. I don't know the details of the DWI. I know you said the blood was excluded. Okay, that's why it got reduced. You have plenty on your plate, Lynn, trust me, but since we're going to be licensing people, maybe we need to examine people like that to see are they a risk in the analysis field. Is this an alcohol problem that affects their capabilities, or is it something that can be patched up by it? But, I mean, we're not going to suspend the license for somebody in the same situation. Where Bar am right now.
Why not?
What?
Why not?
Well,
You have 2 DWIs, 2015.
Then we need to put that in place.
And 2018. And the only reason we're not talking about a second DWI is because there was a question about the warrant. I mean, that is, do we not have an alcohol problem? I mean, one of the things that is here, it says that offenses that apply to category 1 above, because they directly relate to the duties and responsibilities associated with an analyst license, may include but not limited to multiple DWI and DUI crimes. I mean, we are, what is this that we are talking about if not one of those?
Well, my comment was requiring licensure, but if someone is already licensed and is in the same circumstance, we don't have authority to suspend that basis. If you were denied,
Would that have been a renewal though?
Yeah,
Check the criminal history again, and then we'd go through the other.
So we
And it's a Brady disclosure from the office, you have to disclose that, so, I mean, if they get non-sponsored by the DA's office, they're out of a job anyway.
No, they are, yeah.
So I do think that if we were at, let's say that somebody reapplies, on when they when they renew their license, when we run the criminal check, if somebody had 2 back-to-back DWIs, that could be grounds for not I mean, 2 back-to-back. And I think what the law says is that if the offense is closer in time than 5 years to the application, so younger than 5 years old, then you don't even have to do the analysis that asks whether it relates to their job or not. You can deny if it's above a class C misdemeanor outright. But, you know, I don't know if you had an opportunity to review the Office of Inspector General's report, but they looked into it quite thoroughly, and there are some, I think, aggravating factors. The first offense was a very high blood alcohol of 0.19, and the second, there were some issues about the interaction with the officer that I think raised questions.
When we already voted on 10 years earlier, so I mean, in trying to maintain the continuity of what we've already decided, this would certainly go against what we already decided if you approved it.
So if you have a DUI while you're licensed, this wouldn't come up to us till the renewal time. Would there be an obligation to provide to the commission that you have a DUI and you can revoke the license beforehand?
So right,
What's your renewal form look like, Lee?
There.
What's your renewal form application look like?
So they give permission to run the background check. And right now we have pending a bill that will allow us to do it automatically like all the other licensing programs in the judiciary. If that passes, then it will be, we'll be notified if somebody is arrested, and then we ask them, you know, provide us, we understand you've been arrested, provide us the disposition once it's disposed of. If it's dismissed or is pretrial diversion, that's the end of it. If there's a conviction, then that's when you start this analysis. And I think a single DUI offense would not be a problem, but multiple back-to-back DUIs is a different story. That's
And we've got a recommendation from the committee. And so, is there further discussion on this, or is there a motion? The recommendation was denial and a letter letting the individual know that they could reapply as soon as probation is over.
I thought you needed 5 years.
We just voted on that right there.
I thought we had, or 10 years is the case of needed.
That was just to allow Lynn.
That's allow
just
Lynn.
about my decision-making abilities. That's not.
If it's past 10 years, then it doesn't come before the committee at all.
So then any other thing, we will evaluate on a case-by-case basis.
Right.
Motion, is there a second?
Second.
But the motion is to.
This is to deny, send a letter allowing them to reapply when their probation is over. And then it comes before evaluation. Okay, all those in favor?
Aye.
Opposed? Okay.
I think this is part of a bigger question as well about the background checks that are being done in some of those labs.
And the Brady disclosures, I mean, I don't know if they are contracting out. I mean, we use DPS, but I don't know if the private labs have the same
But it may
sort
have
of
been
Brady
disclosed.
disclosures.
We don't know.
Yeah, I just don't
And the
know.
lab just said we accept it. So then, we just don't have that information.
No, I'm just talking about the Brady disclosures when that person is doing casework and is gonna be on the stand
I agree with
later
that.
on, like, like we contract with, I mean, we were DPS, but for people who contract with private agencies, I don't know what that's like.
The attorneys asked that question of the lab where she's employed yesterday, and the answer was, I'm not sure, I will check. So we don't know whether those disclosures have been made to the entity, the client entities in this, for lack of a better way to refer to them.
She did state that this individual's work was, I don't know if she said exclusively or almost exclusively outside the state of Texas.
Right now, it's all outside because she can't do forensic analysis for
But that may
Texas.
be irrelevant. I mean, if it's Brady, it's Brady, right?
Well, it's
But I don't know if that's Brady.
under Michael Morton
It's Morton.
here,
Still requires
as opposed to.
Because I'm not sure this
state.
is Brady material.
I mean, Brett just
Sense
goes
that
like
it has nothing to do
everything.
with science.
No.
So she may not have to
That
disclose
clearly
it
is-
anywhere else.
We don't know, I mean, what the rules are that apply to non-Texas casework, I think is sort of, it depends on the jurisdiction. And that's kind of for them to figure out with their clients.
Right. So do you want to move to 13, or do you want to do update?
I think we could do updates. So
Okay, all right.
we have received an update from NMS about work that they've done in the follow-up on the Torney matter, and we just got very recently the final report from Charlotte Ward, who was the consultant that was hired, and I have not had a chance to really review that, and I would like a little bit more of an opportunity to look at it and talk to Charlotte about the report before we do anything else. But they continue to do a lot of work to address the issues that were identified there. So, did you want to add anything, Dr. Logan?
I don't think so. We did just receive Charlotte's final report on Thursday this week, or Wednesday this week, so I did forward that since I had it. I think it speaks for itself. I'm certainly happy for you to take a little time and review that with Charlotte herself. Certainly in the aftermath of that specific investigation, we identified some other issues that we kept the commission abreast of. I'm satisfied at least that this report kind of bookends specific issues that were raised by the commission on Torney, and we'd certainly like to get that resolved and be able to move on with the other things.
I sent Charlotte's report to Jack Valentine and Tim Slider to look at too, so I'm gonna give them a little bit of time to take a look at it. And then if we have any questions, we can follow up with those or observations.
Thank you.
So we should be able to wrap this up.
We should be able to be done with it the next time, yeah, for sure.
Okay, I think 7 we will not have.
Our friends from NIST would really like to be here, but they're not here, not by choice, as we all know. So we'll try to reschedule them for next time.
All right, move on to, do you want to be updated, or do you want to move any other numbers?
It would be great if we could go to 13 and let Dr. Coble talk about some ideas that are in work. And then we'll ask, and then Bob Wyckoff, and then we'll come back. You ready?
Yes, so good afternoon. Thank you for the invitation to speak. So I wanted to give the commission an update. We had, in November 14th and 15th, we had a symposium on a software program, StarMix, which is a probabilistic genotyping program that all the labs in Texas are either using at the moment or at some point in validating the software. So it's a very important software program that's being used, will be used. And so as part of this symposium, we had a day and a half of talks. The first day was devoted to the science, and the second day was half day was devoted for legal issues. And so as one of the questions that was submitted during the symposium was from someone, there were 17 labs that were represented, at least 2 people from these 17 public labs in Texas that do CODIS, at least submit profiles to CODIS, were present. And we also had representation from 3 private labs that do work in Texas. And one of the questions that was submitted was, would the Forensic Science Commission be willing to, A, review all of the probabilistic genotyping validations, B, create standards for Texas on things like report verbiage, whether to use a verbal scale, what does inconclusive, what should that mean, and so forth, and C, to provide testimony training for bench analysts. And so after the meeting was completed, and a week or so later, we had a sort of update phone call between Lynn, Bruce, and myself, and Jody, and we were talking about, this question, and we thought this was an excellent proposition, an excellent idea. So we discussed about the possibility of forming a probabilistic genotyping review committee. And so we felt like what we could do is potentially have a steering committee that would be, individuals from the commission, from UNT, and from other Texas stakeholders would be a part of this, legal included. And we would have then subcommittees that would focus on particular questions of interest, like, for example, the training for court presentation and so forth, and the use of a verbal scale, whether or not we, as the state of Texas, want to use that or not. And so what I had sent out an email to those that came to the symposium and asked, would anyone be willing to serve as a volunteer on one of these subcommittees? And I had some very positive feedback. So what we were thinking is, if we were to create this type of a review committee, we would be able to do much of this work virtually, having webinars and so forth, that would reduce the need for face-to-face subcommittee meetings, and we could break this down and tackle several of these questions that labs are dealing with at the moment. The benefits of, I think, having this type of a review committee is that it would help to provide quality review and support for the labs. I think it would also help with consistency and practices, not just within the lab, but across the entire state of Texas. And it would also provide guidance. And I think this guidance would not only be helpful within Texas, but could also potentially be a model for the rest of the U.S. In other words, this probabilistic genotyping, I would say we're actually a little bit over half of the U.S. is using this type of a software program at the moment. So there are a lot of questions out there, a lot of guidance that the community is looking for.
So, certainly a change in the interpretation.
It's a huge paradigm shift.
Yeah. Yeah, I think giving some uniform way of looking at how you testify, how you interpret, is a benefit to the overall community gigantically.
The labs really need support. That much was clear when we got out of that symposium.
I'm going to suggest if we don't do it, we could be revisiting the same thing with the mixture problem 2 to 3, 4 years down the line, because people may not understand and appreciate the issues well enough to evaluate the data.
So I have a couple of questions. So when you're talking about having this group review the validations, is that as a resource that's available? It's not as to provide an approval of the validation. Is it a resource or an approval?
I think people want more of a resource.
Okay.
I think that the guidance that they are receiving as to how to validate, especially guidance they're receiving from ESR, the company that is providing the software. I think they have very good, steps of what you should do to validate the software. But then some things that labs may have questions on, I think they're looking for more guidance rather than a sign-off on their.
And to add to that, all the labs are generating data. The combined data may be able to give us better answers, larger sampling, on specific issues that have not been addressed, is number one. And they can gain from that as well, and I think that would help. And what we're finding is a lot of labs are still just punching in the data and getting out a result, but they may not be assessing it well. So, and the last is, one of the problems that came into one of the cases where StarMix was found, well, the data from StarMix was not allowed, was that the lab itself that generated the original data had not validated StarMix, so they took StarMix validation data from lab A but applied it to lab B. If you have all this data, you might be able to demonstrate that you can do that. And that could save a lot of resources in being able to go back to old cases. But no one's done that kind of work at any real comprehensive level. Texas could.
Right, I just wanted to clarify if it was advisory or an official approval. So does that mean, are there real gaps then in terms of some of the standards that are coming out right now? Like there was a new, I think it's ASB 18, which was the validation of probabilistic genotyping. Are there still some big gaps, and that's why we need Texas to, like, as you said, sort of take the lead there? Because I'm not a subject matter expert in this, but I know that there was this particular standard that talked about validation standards for probabilistic genotyping systems. To me, that sounds as if there's already a standard that exists. So what's the problem there? Is it the people?
I don't know if these are standard. There may be a guideline.
So there's the Academy Standard Book Document 18 is the validation standards for probabilistic genotyping systems.
Didn't they just adopt the SWGAM guidelines?
Yeah, so I was on that OSAC subcommittee that developed those standards. And I will say, those standards came from the SWGAM document, which is 4 or 5 years ago. And so a lot has happened in the last 4 or 5 years that those standards are, basic standards. You should run this, you should do that, you should do that. They're not really addressing a lot of the questions that people are having. So there's a gap.
So could you just give just a very brief explanation, because not everyone does this. After Dr. Slater was trying to explain it to me, I was like, oh God. About what is the basis of the movement to this software for interpreting, just so everybody gets a general understanding.
So if I had to pick one word, that would be the reason why. It has to do with dropout, which is when you have missing data, when you have a low-level contributor in the mixture where there may be missing information. The current approaches, or approaches that historically we've taken, oftentimes will just ignore that. Or maybe say this is just too complex, we're not going to interpret. The software will allow us to be able to use that information, and it will do modeling to take into account things like dropout or degradation or some of these other things that are going on. So it helps to, I think, improve our interpretation because it's doing so, the computer is doing so without a sort of biased look. Now, some programs have their own biases built into the programming and so forth, but I think for the most part, we see the definite advantage moving toward this probabilistic approach of interpretation.
Let me add a little, maybe help. So under the traditional system, you would have a DNA signal. And if it hit a certain number of units, say 200, whatever that means, you'd said at 200, that's your cutoff. It's reliable, it's there, there's nothing missing. If you went to 199, you say, now it has a 100% chance of missing data. And we know from one small increment that that's not true. It should have a small diminish, but not drop all the way down. So this system allows you to take it in its signal, and as the signal decreases, increases the probability of those options, where beforehand it was yes or no.
I got the way I saw it is, when is it background and it's just noise, and when is there something really valuable there by taking that threshold away?
Probably not, because some of the software I've actually seen is actually calling noise as true signal, and that's a problem. And so you need to know when that's happening to make sure you're not going down the line, because as you go lower and lower, there's always a balance between true and false signal. The lower you go, you start playing this out. This is more about you have something there that is meaningful, and you can actually use it as opposed to just throwing it out.
And so can I actually answer the question that Dr. Kerrigan's asking a little differently? I'm not so sure that the labs want just advice. I think some of them want initials on the thing that says, we looked at your validation, we being the foremost experts in this country that we can pull together, and you are good to go. I think they get really, they don't want to go back to having to reanalyze mixtures again. They want that check.
I know since that symposium, there have been discussions They want someone to stamp and approve. There is uncertainty, it's not an easy thing to understand, and most of the people out there don't have the knowledge base of the developers. And so they're concerned that they're gonna go down a path, and then someone's gonna come back and say that path wasn't good, and they're gonna have to write all these reports again, and do all the stuff. They want somebody to basically bless them.
They want the blessing of the commission on their validation data, on their validation studies for Star Mix. There is, I don't think, I mean,
Do we have the
yes,
ability to do that?
there's no question statutorily we do. The question is whether or not we have the resources to do it. So Lee and I were looking at the budget, and we built in some money for this to the tune of about $27,000 that we think can help support the effort. I don't know that we'll need all of that because the plan hasn't fully been fleshed out yet, but it would give us the opportunity to bring people together a couple more times, to bring Joe Bright again if we need to bring Buckleton again. The advantage of Texas all having gone with one software system is that we're not sort of having to juggle between various systems. Everybody made that decision. And that means they're able to share data a lot more readily. I think that's the primary reason why people made that call. But I do think that probably one of the greatest services that we could give to the DNA sections of our laboratories is really getting hands-on with this transition. I mean,
I can tell you that many are afraid of the testimony phase. They don't know how to explain it, and they're struggling. And we just did a training yesterday to help people understand and give them ways to explain it, because it's not an easy thing if you don't understand how to translate it from a bunch of science words to something that a layperson may be able to understand. And they want training on how to testify.
the communicating a likelihood ratio is not the world's most intuitive thing.
Well, providing training, but then actually having the commission being the authoritative body to sign up on a validation, I don't know, that's very different from anything we've done before.
We talked about it, she read the language that says.
Where do you draw the line?
Oh, we can do it. The question is just whether we believe we have the technical resources and the time and the money to be able to do what it takes now. And who would do it? I mean, you know, Bruce and Mike basically is, I mean, I don't know who else is gonna do it.
Yeah.
So that's, the question is just whether and to what extent you guys are comfortable doing that. And I think the hope is that by creating
I never said that, I was.
a group that looks at it, that the knowledge of how to validate and the suggestions about how to shore up validations will be transmitted through these groups that work on these particular issues. Some people in the state have stronger validation exposure than others. I mean, but we had a meeting in the other building when I forget if it was Roger Kahn or Tim Sawyer that stood up and said, basically in a nutshell, there are only 2 people that I would hand a validation to, or 3 people in the whole state to look at who would really understand what's going on there. And we need to increase that capacity. That's really how I feel about it. And this effort is to both help the labs know that they're on the right track and to increase the capacity of people who understand what really needs to happen in a proper validation of this kind. It's gonna be Jarvis.
You said Jarvis, one of the 3.
Can I object to my own?
You had a license to take it.
Yes, voluntarily, voluntarily.
So, I mean, it's definitely not what we typically do. But if you think about, like, how can we help, really help, we gotta get involved because they are asking for help. And that StarMix Symposium raised as many questions as it answered, I would venture to say. The good news is that the StarMix creators are very invested in the success of this state. for many different reasons, and they are willing to do whatever we need to help make it successful. I think that's fair.
Yeah, we don't want to go back to issues we had to deal with several years ago. We can avoid it by doing something upfront.
So Mike, with this create standards for Texas on report verbiage and interpretations, is that not something that's also progressing through OSAP or?
Not at the moment, not that the subcommittee that I'm familiar with. There's some, there has been a document on basically building propositions for like the good ratios and so forth. The problem that at least I'm observing is just sort of looking at it, it's taking so long for those documents coming out of OSAC to ever make them to become a standard. Like I said, I was on that very first subcommittee on probabilistic genotyping validation, and it's just now coming out. That's 4 or 5 years of sort of waiting for standards.
Right, but I mean, that's part of the consensus-based approach, which the SWIGs weren't really doing. They weren't, it wasn't sort of balanced or whatever. So there's no question it's taking much longer for the standards to come out, but.
I think there's another issue though. A lot of these guidelines that now become these de facto standards that are sort of antiquated by the time they become standards are people making decisions who don't have a lot of experience. In the past, it would be you took the experienced labs, they got together, and they made recommendations based on the knowledge that they had. So like this probabilistic genotyping, next generation sequencing, the recommendations really are not there because they don't have that. So I think you have to take people who have done the work in the state, get together and start sending some examples of what maybe eventually becomes a standard. We're getting a standard out before people have gotten together to really figure out what's the best way to do it. We have the opportunity to get the best way to do it, and then hopefully the standards people do it. I think it's premature to set a standard at this point. And if one comes out, I'd be very more concerned about the standard and the process, because standards come based on knowledge and experience, not on what I wish it to be. And I think this is the problem right now with these things as they emerge.
I think, Mike, in terms of the standard itself, it's pretty general, right? And what you're saying is, it's pretty general and that's fine, and they can follow that, but it doesn't really address observations and casework that people have been making using the software and questions that they would like answered. And what should I do in this case? And what should I do in that case? And that's where they need help.
In fact, it's really about validation study. The standard's not about standards of operation. So it doesn't address that at all. So again, they don't have that knowledge that collectively the state does have.
DPS took the first jump, that's for sure. I mean, and they've got a lot of data now that I think could be put to good use.
So we would be looking to see if someone is willing to make a motion that would allow us to spend commission money to help set up a committee that would then help the laboratories in the state to implement the validation of the STAR mix and help give guidance in not only what they've done, but also in testimony and, I assume, interpretation.
Well, the verbal scale, all the questions about what SWIGDAM has done, we need to address those. The labs need to know. There are real issues that labs have with some of that stuff. So it's everything, really.
So the motion be that spending money to basically do everything needed to help the labs get functioning using probabilistic genotyping.
Yeah, and those guidelines would come, they'd develop the guidelines, they'd come to this commission, we would approve them and then have some discussion about how to implement them. Yeah.
So is that your motion?
That's my motion.
That's your motion. Is there a second?
Second.
All those in favor?
Aye.
Opposed?
Thank you.
Thank you.
All right, we can move back to number 8, which is the update on the investigative panel regarding DPS El Paso blood alcohol complaint from Culberson.
So we had a go-to meeting, kind of online meeting with the complainant and with DPS. And through the course of that, it was quite a technical conversation, but Dr. Kerrigan asked DPS for some specific follow-up items. And there's an email where you can see that in your materials. And one of those things was for them to try to essentially stand those computers up and see whether it's possible to replicate an accidental transfer of the, or accidental use of the data. And that is in process. Did you want to say anything else, Dr. Kerrigan, about that? We don't have final answer from DPS yet. They still have work to do.
Right, and I think they were the ones that volunteered to do that. They said that they had the ability to do that. We thought that was just a good idea. Amanda Culbertson also presented some data with the original and then transformed linear regression. And it was very clear from that that really the results would have probably been within the uncertainty of measurement. I think the difference in the gradient was like 1 or 2%. I mean, it was, so I mean, it was negligible. Probably, can't recall what their is for blood alcohol, but larger than 2%. So we'd also asked them to go back and reproduce what the results would have been had they been calibrated against the correct calibration curve, because basically these were unknowns that were quantified against a curve from a previous batch. But because the calibrations themselves are really relatively stable and the linear regression was so similar, we also asked them to recalculate the results, because I think when the commission comes to write the final report, having that data available will be important. The other thing that we discussed during that long call was that even if DPS can show that it is possible to accidentally reprocess the data that way, we still are not going to know whether or not that act was intentional or if it was accidental. So it's a good exercise, but we still are not going to know definitively. So we may not get the absolute resolution that we would like, but it was one step further.
We sent a letter to the attorney or the analyst asking for a meeting. We haven't heard back yet. And I talked to Dr. Spiegelman, and he did say that the recommendations he made about reviewing one case per batch was based on the assumption that this was an accidental sort of clicking the wrong thing on the drop down or checking the wrong box, but his recommendations would be different if it were either an intentional act or an act that we couldn't determine whether it was intentional or accidental. So he said he would give them a different sampling plan. So we're going to have to revisit that question as well.
The other thing during that meeting that we discovered was that essentially the total iron chromatogram, the data that comes out for each unknown sample, the way that report is actually generated at DPS looks a little different from the standard template that we saw in our commission meeting, in that it doesn't actually, the DPS report didn't really identify to the tech reviewer the calibration that it was run against, because the footer was basically illegible. And they're addressing that. I think that they're going back and initiating some more corrective actions, but they did provide us some of that information too. So the tech reviewer doesn't have the ability to verify that the examiner measured the unknown sample against the correct calibration. There's no reason to think that an examiner would do that, but at least having that ability in the future would prevent something like this from happening.
We have a projection. Will we have what we need?
Next time, I think.
Okay. All right. Anything else? All right, now update on the Sorensen lab.
Casey, or whoever's back there, can you put the PowerPoint? Thank you. Okay, so, as you know, Bruce and Jody and Vanessa Nelson from DPS, they all went to Utah in November, right? Is it November? End of November? Late November, early December, and this is a PowerPoint that summarizes what was seen. Just as a refresher recollection, back in June, the director, the chief scientific officer for APD, let me know that she had some concerns about the quantity and nature of the quality incidents that she was seeing for outsourcing work that they had been doing where at Sorensen on behalf of APD. And so we reached out to Sorensen. They ultimately did a self-report on a quality issue that was specific to something raised by the Kentucky State Police. Was it Kentucky?
Kentucky, yeah.
It was Kentucky. And so there's the Kentucky State CODIS administrator raised concerns about potential carryover contamination in casework that they had seen. This is not APD cases. These are Tennessee and Kentucky cases. And so that became known to us as well. Sorensen self-reported on that. We talked to KSP and requested various quality documents that were reviewed. The Houston Forensic Science Center also reached out to us to talk about some quality events that they had seen in prior outsourcing that they did when they were still part of HPD. And we sort of went back and forth with Sorensen. They gave us access to data. Sorensen came and gave the presentation at the last meeting, which raised some additional questions. And then at the very end of November, the team went up to Utah. And so I'm going to turn the technical piece of this over to Bruce so he can talk about.
I haven't looked at this PowerPoint in a couple of weeks or so,
Okay.
so I'm going to wing it too. But so one of the things that brought this to the attention of APD and Kentucky and all was there was a sample-to-sample contamination that resulted in a CODIS hit that could not be explained by the event itself. And sometimes that's how these contaminations alert us to their presence in that. And when they look at their contamination, they're looking at their reagent blanks. And if you don't see something in a blank, you say they don't have contamination. But because of the process that they had, which was a rapid growth and a large amount of automation and pooling a lot of samples together, they didn't adequately address the sample-to-sample contamination. And so that's still an issue they're working on, but they have downsized, they've eliminated parts of the process to get to that. They also identified that they didn't have a good mechanism to detect sample-to-sample contamination. They have software in place to say sample 1 might be in well 1 and 9, because if you saw some commonality that shouldn't be there. One other thing that they had is that they batched things from different clients on the same plate. And that complicates interpretation evaluation because that client doesn't have access to those other samples, and that becomes an issue in that. And then there were lots of typo errors and some other things in that. I will add when we'll see this on the next slide. So Lynn already mentioned the three of us who went up there and evaluated it, and I'll have to say they were very open. They provided everything. There was no resistance. They welcomed. They looked for advice, welcomed that. So they really want to, get to a better place. So I think we're very pleased, and it seems to be moving in that direction. We talked to some of the staff, and we got quite an interesting thing from the previous management was disconnected with the staff, and that was a clear problem. Staff had complained about the way the work was being done and concerns, and the management said just get more cases out. So the current management is saying quality first, numbers second. Before it was numbers first, everything else second. So we thought that was good. We went in and reviewed, some of the validation studies. They have quite a lot of good validation studies, good documentation. There are nonconformities. There's a lot of documentation on that. So the general process and quality assurance infrastructure there is more of a management driving to get the number of cases. We'll say they had a comparison tool, they just didn't realize it or didn't use it because the software that's provided to do this already has that in place. They just didn't understand. So the main thing is executive management is different, so they have different leadership and they have a different attitude. That was clear that they're going to try to change. I've already talked about all this stuff. We recognize, if we bring up morale is low. One of the reasons it's low is the previous management said if you do a lot of cases, we're going to give you a bonus. Well, that goes out the window with the third thing because you're going to reduce the cases. So people didn't get bonuses, so I guess that can have an impact on that. But they seem to be pleased with the leadership taking on a much more interactive role with them. The rest of this are just things to do to set up, so I won't go through the details of what they're doing with the software, but this is a way to flag potential contamination. And so we talked about what would be the parameters to help in that process. The way they had set first, it could be you had to see an absolute one-to-one comparison as opposed to sometimes partial comparison, and that would improve that. And then they're going to do a lot more root cause analysis process. We recommended possibly getting, sort of like what NMS did, get an outside expert to come in to have a fresh set of eyes on things to improve. And I think that's a good example to follow what NMS did. Independent of this review, I've been asked to review a case that Sorensen had that was, going to go and defend actually the work they did. They actually went to trial last week. And we found that there were some statistical calculation errors, so we talked about that. And they revamped their whole process and they issued a new report and was consistent with what the community does. So there were, little things like that. Not an overall problem with statistics, because their approach was, we were talking about before, throwing away data. Their approach was throwing away a lot of data. So instead of getting real statistical problems, it's inconclusive. So this will actually help all sides who use them to get better information in that. And then, of course, a better quality plan, so, develop a plan to reduce the chance of these issues recurring. I would say quality assurance-wise, if you have a person that's a quality assurance manager, and they raise it to management, and management says, I don't care, you have a bad system. Quality assurance manager actually should be able to override just about anybody in the process. So they're going to have more empowerment to the quality assurance people in there. At least that's my opinion of it.
She's just saying it's not the first time.
No.
we've seen it.
No, this is really.
Deja vu from El Paso
I can say in my
PD.
lab, I'd run the high my quality manager because she can override what we want. No, I mean, seriously, it's really important to have empowerment to the quality manager before things can get dismissed, especially when the cost benefit was more important than the quality. So we recommended to empower them is to better define the roles of everybody in that quality system. Because it's one thing to say, you have this job, but that's not necessarily the role. And to be able to put that authority in place so when there's a dispute, who takes it and who has the final say. We've done also is, one of the complaints of the workers in there was that the business people were the ones who were communicating with the outside clients. And they would sometimes be conveying DNA information who didn't have the expertise. So we would recommend that they would get someone who is better qualified to do that. If it's just negotiating a contract of money, that's one thing. But they would say, what's the success rate? What does this mean? What can you do? And that probably wasn't the best people to do that. I'll go to drop the last one. We also recommended that they probably should get legal counsel that's specific to the issues of forensic science. Because, they have lawyers, but they're for business. So, there's this contract about the contract. But there are other issues about disclosures and the things that we all, enjoy and believe is important here. They don't have any of that in their organization. So, we go just down the road to our DA's office and you get advice and such. They don't have any of that in their place. So, we also wanted to follow up on the disclosures and notifications because when they ramped up, the problem was big, so they need to go back to that point. So I forget what the year was, I want to say 2016, I don't know if anybody some sources here, maybe when they really started the ramp up. But there are cases before that might be ramped, so they may have to look at that a little bit more. And we found that as these disruption came, and both from the ramp up and also now that there was contamination, they didn't really explain to their staff why a change was coming or what it was. They just come in and say, do this today. So that's not a good system either. And that's, I think, part of the quality management system. Having said that, they have updated their technical administrative review forms and process. They're now looking at ways to look for contamination. They have a process in place. They do have a good second reviewer system in place now, and they're going to strengthen. I think we've seen this in the past. Tech reviews are done. Not a lot of documentation about that tech review. Check mark, it's been done, but you don't know what was discussed, where there may have been disagreement, where there may have been some other issues, things that might have been missed, so maybe to formalize that better. And then the same sort of things of processing. And they're now also taking one person through the batch to get away from this large team concept that may also have contributed to contamination as well. All dedicated to one client, so you reduce that problem of investigating contamination, so the client has access to the information. I mentioned the tool. Root cause analysis of contamination in non-discernible mixtures could also be a problem. So you have either single source or mixtures, you can have transfer from one place to another, and that. Then normalization is just a sample processing thing that the way they were doing it could actually increase the chance of contamination. I won't go into the details of it. Improving to consumable reagents that are reduced in the amount of DNA, so they've been treated to be, quote, DNA-free, whatever that means. And as I said already, the quality manager would have far more authority in dispute resolution. Oh, this is sort of the same things here. These are all just the things that we talked about to improve the process. So I've stacked the problem is sort of that same thing. They improve their statistical process, evaluating data differently, again, not to throw out useful data, and to process and analyze and calculate correctly. They acquired, I forget what, is it Bulletproof is the name of the company? I don't remember now, but that had a software tool to do this kind of searching, and so they're part of the team now as well. And as far as we know, they said they're contacting all back to 2016. I guess they're asking Charlotte Word to serve on this. I don't know if she's agreed to or not.
I haven't talked to her.
Yeah, okay. And then, as I said, the management spoke to them personally, are really sending this message of quality in the process. And so then the next step are obviously the next updates and how they're progressing.
So what do you think needs to happen?
I think we need to see how these next set of quarters, maybe for 2 or 3 quarters, to see how it's improved, because one quarter, second quarter. It takes a while to get there. So we can see that kind of process. We can assess if the actions they're taking are actually improving the process.
Okay, so we need to keep on top of it, at least through the next meeting, and we'll reevaluate.
Yeah,
But they're on the right track.
I believe so.
Any further questions or anything to discuss? Okay. Is Mr. Benson here?
He's in the hall.
Yeah. Dr. Benson?
Where should I stand?
We're
kind of informal.
Rather than you having to wait for the whole thing, if you'd like to go ahead and you can talk now.
I appreciate this. I'm going to read from a paper. I would like to thank the Commission for allowing me the opportunity to speak here today. The purpose of my visit is not to try to prove or disprove the innocence or guilt of anyone. I know this is not the reason for this. I'm here merely to support and respectfully submit documents on two separate and distinct complaints that stood before this Commission today. The first complaint that I'm referring to was submitted by a forensic scientist with several years of experience. This scientist provided expertise in his field in a criminal case. And from what the science observed and reviewed, he was ethically compelled to file his own complaint to this Commission. He chose to do this on his own since he truly believed the complaint to this Commission was warranted. The complaint focuses on the DPS lab in Weslaco, Texas, and a case analyst assigned to that lab. His particular lab and case analyst both have already had checkered tests to place it in a cordial and mild way. With the Commission's permission, I have here copies of certified transcripts and a copy of a court exhibit to help support the forensic scientist's complaint. The court exhibit is a copy of an internal affairs investigation in where the case analyst is proven to have exercised poor judgment and misconduct in her duties. However, she elected to resign to avoid facing the music. At the time, even a Texas state representative took notice of this and expressed his concerns over this analyst in a public way. In court, the DPS analyst was questioned if she realized that the allegations made against her by her very own peers and her fellow scientists was sustained against her. And the court records reflect that the case analyst simply replied, "Yes, I do, and I do realize that they are police officers that were investigating scientists, so they might not understand everything that they were doing." Honorable committee members, I stand before this Commission to humbly request that this Commission make a favorable ruling to allow scientists and appropriate government entities to properly investigate and make an official ruling on these formal complaints filed against the Weslaco DPS lab and the case analyst. In the court transcripts, the case analyst provided in her own testimony that she admits not to following the best practices. And when asked how to prove if sensitive issues were done or completed by her, she simply replies that you just have to take her word for it. And this was done in several instances. In other instances, she is unresponsive to questions, and in other instances, she offers answers to questions that are not asked of her. And based on her own testimony, she proclaims that unfortunately, her lab, for whatever reason, it takes a long time to get through a case review, and it takes several weeks to get through. This is found on page 21 of the court transcripts. Then on page 70 of the court transcript, it again reads in her testimony that it takes several weeks to go through a review process because they don't have enough. They don't have a lot of people, and everyone is trying to get work of their own lab, get their own work done, and review other people's work at the same time. So sometimes it takes a couple of weeks, if not several weeks, to make a report issued out completed, which is not unusual. I understand that their caseload is backlogged. But that testimony was on the very first day the DPS analyst testified. And yet, during the second day of testimony, at the trial, she returns from her lab after conducting another test at approximately 10 a.m. Then she is back in court the very same day at 2 p.m. to testify on the final results on the test that she had just completed in the lab, which totally is contradicting what she had testified the day before. Most importantly, we note from her own testimony that her lab manager already knew that her reliability was being questioned based on her track record, and the lab director needed someone to watch over her since her reliability was in question. If her integrity and reliability was to the point that her lab director had to assign someone to oversee her doing her work, then she should not be given to do any work at all. The caseload should have been done assigned to someone else. Then on page 49 of the court transcript, the court reflects that the analyst indicates that if contamination had occurred where DNA was placed where it should have been done, the case analyst admits that she would have never known. From where I'm standing, this case analyst has all the makings of another Jacqueline Blake. And from what I understand, the DPS lab in West Laco is currently not conducting DNA testing due to the lack of qualified trained analyst staff. And it is unclear if they have notified all the interested parties of this. And another important note to consider, that the alleged victim in which the case analyst conducted her test at the DPS lab has since withdrawn all her claims against the defendant in an open district court. The second complaint involves what I believe is a serious maintenance issue at the DPS lab in West Laco, Texas. When I first learned about this issue, I immediately contacted the appropriate staff of this commission. The issue deals with the electron building automation system. This system controls, yes, the cooling and the heating systems, but it also maintains the relative pressures in the West Laco lab. So it's all in conjunction. It not only controls the heating and the cooling, it controls the pressure and it controls everything within that system. The DPS solicited vendors to test, diagnose, and repair the failing system as it was reported by the DPS. The issue is that the failing system may have been a culprit in the lab contamination problems. From my previous communications with this commission staff, I understand the commission is constantly receiving an overwhelming number of complaints to investigate the commission, and the commission resources are limited to which complaints to investigate. And this is the primary focus of my visit before this commission, to respectfully request that the commission take appropriate actions to prevent from these issues happening again. I want to thank all of you for your attention and consideration. Thank you.
Question.
Yes, ma'am.
The legal proceeding that you're referring to where the victim essentially recanted her allegations, do you have a copy of a transcript or something that you can...
I have an order where it's a separate, there's several lawsuits involved. It's not just a criminal. In the civil, it's a civil lawsuit where she is suing several entities. In that particular, it's in a separate court. She withdrew all her claims, which was unsolicited from anyone on her own. And I believe it can be found online, or it can be gotten from the court records. I can provide a copy, so that way you can search for it.
Thank you.
Okay. Anything else? Thank you.
Thank you for your attention.
Thank you very much.
Thank you.
Am I allowed to enter the documents that I have?
Sure. You can give us everything.
It's exhibit number 44. I had the transcripts, but I heard mention the doctor that he had all the transcripts, and there was a lot to carry, so I didn't bring them. So, but if you need it, I can provide it.
We have all the transcripts, right?
Yes. So this is the Journal Affairs investigation.
Okay.
Thank you for your time and consideration, allowing me to jump out of order.
All right.
Thank you.
All right, item number 10, update on crime scene investigation.
So we have met again, and the main job that we did was to solidify the definitions between crime scene collection and investigation versus crime scene reconstruction. Shelley Rossi, who was in court testifying this morning and was fed here, is also going to update us on the BPOC, which, if you recall, we put a group together to essentially overhaul that thing when it comes to crime scene, and they worked really hard to do that and had a little bit of fun in the process, I think, but it was a ton of work. Do you want to talk to him about that and who you had helping you and everything?
Sure, it was, so here is the finished product, and who knew when we first kind of took this on that there was a lot of words and no pictures in this document. And so how we kind of broke it down is I went through the document, and by individual discipline, we identified who the subject matter expert was in that discipline, and with the help of some collaborative contacts, we assigned people to look at that section and bring it up to like state-of-the-art, what's happening right now. This document had not been updated since 2003. A lot of the stuff in it was archaic. A lot of the stuff in there was no longer practiced. Historically, through the years, is what has happened is for the folks that were required to teach out of this, they have modified it. Those agencies that teach it have modified it to on their own to bring it up to current practice. However, with the amount of training facilities in Texas that are required to teach it, if they had people that were teaching it that didn't have a knowledge, they could have been passing on either outdated, archaic, or analysis that is no longer done. We were able to put it all back in the manual. We added some helpful guides to the back of it, and this has now been submitted back to TCOL because they are finalizing their basic peace officer update also. And then with collaboration with TCOL, they have agreed that our basic peace officers, and I don't know if Lynn had addressed, but in the last meeting, basic peace officers get 8 hours of forensic training, and then they are kicked out to the street. And there is no requirement for them to ever take any updated forensic training. And so we felt like when patrol officers, anywhere around the world, patrol officers respond to 100% of any crime scene on any given day. And in Montgomery County, we respond to 2,000 calls for service. The sheriff's office responds to 2,000 calls for service a day, in which the crime lab may respond to one call, may get called out to one call. So when you look at that percentage, patrol is responding to 99.995% of every crime scene of every day, where a crime scene unit will respond to 0.005%. But the crime labs are the ones that have all the expertise, and our patrolmen potentially have 8 hours that they learned at whatever point along the way that they were in the BPOC. So with our partnership with TCOL, they heard our concerns about this, and so they have agreed to slide this outline into the BPOC. So now all of our cadets that are going through a 2019 basic peace officer class will receive 40 hours of crime scene training, which is gonna, kind of, if the cream rises to the top, then with our police officers now having a substantial more amount of training, then our crime scenes, hopefully, from here moving forward, are going to be worked, at least the forensics part of it, they'll acknowledge, the benefit of forensic evidence. So I think this is a huge step for Texas. I think it's a huge step for TCOL to trust us to get this done and back in their hands in a pretty short amount of time. I couldn't have done it without an amazing team. I mean, my teammates were incredible, and they worked really hard. We had a huge support from both the commission and DPS, as well as some, Irving PD, some folks from Montgomery County. It really came together better than I could have ever anticipated.
Anyone have questions about the BPOC? Do you know when they're going to release it into the hands of the instructors, or?
I know Susan, she was sent kind of what we thought was our copy, and then there was some things some last minute checks that needed to be addressed, and so I had zipped her another email saying, okay, now here's the latest copy, and, obviously the document had some formatting issues, and I had warned her about that. The page numbers got kind of wonky, and I also, told her about that. So I think she's still digesting it, because it's a lot, but they hadn't rolled out the BPOC yet. They are still doing their finalization. So I think it's all gonna roll out together, and I think that's coming pretty quick.
So the next thing that the working group is going to move on to will be the accreditation program. And speaking of accreditation, Montgomery County is about to get assessed for crime scene and bloodstain pattern. And they're very nervous and excited about that.
Super excited. So next Monday, not this coming Monday, but next Monday, we have our bloodstain assessment, and so hopefully, shortly after that, we'll get word when we're ready.
It's pretty amazing. You guys did a great job.
Well, and I, again, I've had a lot of discussions. I had a discussion on the way actually here. Moving forward, and none of this would have been possible without each and every one of you guys on the commission, because you guys said, look, this is what we expect. This is our expectation, and you made a believer out of me, and you made a believer out of my agency, and you articulated in a way that we realized, right, because we lived in our own little Montgomery County bubble, of why we needed to say this is no longer acceptable. And so we heard what you guys were saying, and we said, you know what, we are going to put all hands on deck and we're going to fix it. And I thought back on February 4th that there was no way that we were going to stand up a bloodstain accreditation in 15 months. And you're like, you know what, DPS is going to help you. We have, and they have been, Brady has been amazing. And you guys have been amazing, and the network that has been created. And you're right, it was possible. And anyone that would have wanted to start from scratch to assessment date could have been right there with us. So I just, this is just as much an accomplishment for y'all as it is for us.
Thank you. Not everybody has a chili, does it? All right.
Any further discussion? Okay, let's move on to the item.
Okay, so we did meet in Bryan, Texas at Jarvis's office to talk about setting up a statistical sampling set of guidelines, and I just haven't gotten to, I have a draft going, but I haven't gotten it out and returned, and the goal was to do it by this meeting, but we just fell short of that. So this is something that I'll be focusing on after this meeting, and hopefully at the next meeting we'll have a document ready for you. So I apologize for that, but we were licensed and took center stage, as did a lot of the other things. So we're going to try to get that out to everybody.
It was a highly interesting and stimulating conversation, statistical sampling.
It was full of smiley faces and non-smiley faces. It was crazy.
So Jarvis is going to tell us about statistical sampling, is that right?
Yes.
You dominated it.
You weren't there.
I wish I'd been there.
I'm sorry, I couldn't make that one.
I know it's memorable.
So we now have Mr. Daniel is volunteering for the future statistics.
We'll make sure
committee.
you're at the next one, Bob.
Yeah.
One of the things that was clear at that meeting is that it's great to have Dr. Spiegelman's help, but there needs to be sort of a bridge in the guidance that we provide to the labs that so that we write, that it's sort of dumbed down for us mere PhDs in non-statistics, right? So, yeah. Yeah, so
There has to be a translator to, yeah.
Right, so we're providing that so that there are some dumbed down versions of, you know, the differences between simple stratified clustering, systematic sampling plans that even I could understand because I wrote them. I had to sort of translate them into something that an average
Common folk lawyer would.
common folk like myself can understand. So there'll be a translation piece as well.
Right.
So, we've released the statutorily required report coming out of HB 34, which was the bill that came out of the Chemical Exoneration Review Commission. And it's in your materials. The main thing to note out of that is on the field drug testing, the problem of reliability concerns looms very large. And so at the same time that looms large, so does the backlog on drug chemistry. And the repercussions of having a 12,000 case backlog in drug chemistry and having a field test that people don't trust is that the impact on the criminal justice system is very significant, both for prosecutors' offices, for individual criminal defendants. And because we're now within the Office of Court Administration, they are working on a number of issues related to this involving bail reform and other things. But the main effort that's come out of that report is a work group on Raman spectroscopy. Pat Johnson's involved in that, Jasmine's involved in that, Patrick Busini is involved from Sam Houston, and so what we're talking about, and then it's hosted by the Texas State Bar, and there are 4 attorneys, 4 from the defense, 4 from the prosecution, and 4 judges. And we heard presentations from Arizona DPS and Phoenix PD that use Raman spectroscopy as a mechanism or a manner of reducing drug backlogs in an era where field testing is becoming less and less prominent, both for reliability concerns and for officer safety concerns, because of the things that you can come in contact with now can kill you essentially on the street with fentanyl and so forth. So that is progressing, and right now the group listened to presentations from various labs, including from Arizona and from Texas DPS. And the next step is that Texas DPS is going to buy a tabletop Raman spectrometer, and they are going to submit their validation plan for that to the group for review, and we're going to take a look at it and comment. And Dr. Busini is going to focus on that because a lot of his research has been in Raman spectroscopy. And then we are going to take, oh, Judge Hervey's here.
Can I interrupt 1 second?
Sure.
I just wanted you all to know that people from CSAFE have contacted me about coming to Texas. They haven't picked a time yet to work with the National Judicial College and the court to put on a seminar on statistics. So we'll keep you. So you always know this. And you know, if you want to attend, we'll.
Jarvis is first on the list. He can't wait.
Judge, you can turn your back because I'm going to stab a couple of people right now.
Well, that's okay. We know it was deserved.
It's deserved, yes.
Okay, but I just thought I'd let you know that, and I'll keep you informed.
Did you know we just had a conversation right before you walked into the entryway about statistics in this meeting that we had, so it was perfect timing.
Oh, I'm sorry. I know a lot about statistics. I know 100%.
So, yeah, I think, what was I talking about?
Raman.
The Raman. So we're gonna keep working on the Raman project, and we will report back in about that. But eventually, I think the goal would be a joint report between the Texas State Bar and this commission.
on the use of ramen as a potential tool to identify at a minimum coke and meth, probably not the mixtures or any other things that it has a hard time with, but there are a couple of substances that it does a great job with, and those are the ones that I think are gonna, DPS is gonna pay most attention to. And it is the lion's share of what they see, which is helpful for backlog reduction.
And I also reached out to several federal law enforcement agencies like DEA and CBP who are using it right now just to get some information on how they're using it in the field and the reliability as well.
CBP finished up an evaluation of portable devices last year.
So DPS is not contemplating the use of portable ramens right now. They want to go with the benchtop, which is a bigger investment, but from what Dr. Busini said, has many benefits. And so I think we're sort of focused in that direction, but it would be great to see the data if CBP would share it with us about how that went. It is not like the perfect solution to all problems, certainly, and in order to report out results that could be used, we would have to be very focused on the contents of that report and how it communicates results and the limits of those results. And it's great because we have defense representatives involved who, including Nick Hughes, who did these drug exonerations in Harris County, and he's got lots of opinions on what that report needs to communicate to the defense, and then they need to read it. But the hope is that if you give them some information they can use, the decisions that will be made from there will be sound decisions. So we're hopeful for the work of the committee. I think it's going well so far. Anything from Pat or Jasmine? Did you
Well, James Nichols from the DPS Garland Lab was here this morning, and he told me they've submitted the requisition for the instrument.
Quick.
So they're ready. I mean, it'll take several months to get it acquired. They're ready to go.
Sole source it, see if they can get it faster, but I doubt it. The procurement process is a big challenge for laboratories, I feel like. It's a big challenge for public health. But that's a subject for another day. Okay. Any other questions about ramen or HB 34?
Congratulations for spelling it correctly on the agenda, instead of as like the noodle.
There were a lot of noodle jokes at first, but then we got past them.
All right, number 14, update on.
Okay, Bob, sorry.
Yeah,
go for it.
Okay, well, our project's gone through about 2,700 cases. When you were talking about how to communicate probabilistic genotyping results, I've been doing that with clients, and I'm going to take you guys on a field trip to some prison units because I want you to explain it to them. But so far, the results have greatly confirmed the original DNA mixture results using CPI. So we've only had one case where it went from a could not be excluded to an exclusion, and there are provisos with that. There are explanations for that. So we've still got about, I think, 350 cases left to go through, but I'll have a lengthy report at the end of all this. So, we'll talk about it more then.
Have you seen the affidavit in the Barrett case that went to an exclusion?
By who?
Dr. Badal.
No,
I'll
I haven't.
forward that.
I'd like to.
Okay, we'll send it. Dawn?
We're still plugging along. We're finally reached the point where most of our cases are just waiting on the defense to let us know if there's something they're going to be filing. All but 20 of them, we've made decisions on what we think, barring something else that they offer that we didn't catch or some other relevance. Out of all ones that we've sent out, we really only had 2 that we thought had an impact, one of which is currently being retested at DPS. with Star Mix. And then the other one was one that actually, oddly enough, after going to the Star Mix Symposium and talking a little bit about relatedness and reading some of the things that have recently been published, the result changed in the amended report because of relatedness, but now it looks like the result would have been exactly the same if the relatedness had been done in the way that Dr. Badoli and others had put in this recent journal article. So I think we have probably only had one that really so far seems to have had a big impact.
We don't have anyone here from Capital Area Private Defender Service.
No.
Okay, John, do you want to talk about?
Yeah, so they just got a new head,
they
Stacy
did?
Lieberman,
Okay.
who has only been with them for a few weeks, and she's still kind of getting her feet under her. We've sent 56 cases.
50-some-odd
57 cases. Gotten all of them back except for 2. There was a couple of questions that were left hanging during the transition, and we're going to try to get those resolved. Of those, CAPS filed 11 writs on cases so far, and we agreed to do with them was to file a pretty generic writ and then an immediate motion to stay, and it had to do with preserving the defendant's right to file a federal writ because there's a 1-year time limit in which to file that writ, and so we worked with them to stop that clock by filing the state writ, and then once they finish their investigations, they can do an amended application for those cases. What we figured out is, even on cases where the DNA changed and it may be material, they still have, even if we agree that the case something different should happen with the case, they still have to go through a writ of habeas corpus, and because of the way that law is written, they have to raise every possible claim in the first writ or else it is waived. And so that's kind of been their delay, is they're having to not just look at, if they've determined that DNA did play a role and that they want to pursue litigation, they're having to go back and then review every other potential non-DNA related claim so that they don't waive those in filing.
Because otherwise they're not representing
The client.
the client. And in their situation, they have a full-blown representation of these clients, right?
I think the initial agreement was to do a temporary, like a limited representation for the purposes of doing the materiality reviews. I think, I'm not positive, but I think on the ones where they are determining that they think it was material, they are going back and
Doing the
full
full-blown
representation.
Did you have anything?
I'd just say that we only have 2 cases that are outstanding, and the reason for that is that the center had done some analysis or communication in that case, so it reached back. None of the samples that are being asked to look at were done by the center, but because of that situation, it might be conflicted. The DA's office has no problem, APD has no problem, but the CAPDS wanted to look into it, and then there was a transition, so we're just sort of in a holding pattern till, I guess, the management comes in.
I brought those cases up with Stacy earlier this week, and I was going to forward the emails to her to make sure she has them, and we'll try to get information back within the next week or so.
Is she local?
She actually came from Louisiana, where she was doing capital writs there.
All right. Well, hopefully we'll get to meet her. That's it.
All right, number 15, legislative update.
Okay, so the legislature's back in session, and that means that all kinds of things can happen, as everybody knows. There is a couple of things I wanted to bring to your attention. There is a bill that has been filed by Senator Hinojosa that would, if you all recall, before the licensing bill passed 2 sessions ago, at the end, that lobbyist for, it was either Houston or Harris County, I can't remember, approached Senator Hinojosa and said, look, we're fine with the licensing bill, but there has to be a process in place for people who want to appeal a licensing decision that is not within the commission. Licensees need to have somewhere to go. And so at that time, they referred they included a provision that allows people to appeal to SOA, which is an administrative process through the Attorney General's office. Not known to be the most mainstreamed, or how shall I say, streamlined or efficient way of going about handling these things. It's actually really cumbersome. From what I understand, I don't know firsthand, but that's what everybody says. So what this bill will do is allow people to appeal their licensing decisions to the primarily judge-based commission, which is the JBCC, the Judicial Branch Certification Commission. And if the licensee does not like that decision, they appeal to a panel of regional presiding judges who then make the final decision. And from what I'm being told by the executive director of OCA and my counterpart at JBCC, it is a much more streamlined and efficient way of handling appeals over licensing decisions than going through the SOA. So that's what that bill would do. There's also a bill that would create a sexual assault commission, essentially for the purposes of trying to number one, work on these standardization issues, right, Dr. Downing, that have come up with the kits, and basically do a bunch of things to better coordinate efforts around sexual assault nurse examinations statewide. I talked to representatives from the governor's office briefly about it. They are still evaluating it, but they have some concerns about, infringing on the practice of medicine, which is sort of, I think, what a lot of SANES would feel is primary in sexual assault nurse examination, but it also has this evidentiary component. So I don't know if you wanted to speak to that bill at all, Dr. Downing. We're just kind of tracking it right now.
Sure, I gave a cursory glance at it. But yes, my concern was that there should be, I think they only have room for one appointed sexual assault nurse examiner on it at the moment. So that was a concern for me. Similar sorts of attempts are being discussed at the governor's level that raise a little red flags with me about, for instance, law enforcement would help determine whether or not the nurse should collect the kit at all if it comes down to a consent issue. So that raised a little red flag with me, because I'm like, we're not going to really have that information at the time of the exam probably, and so I don't want law enforcement telling me whether I'm going to collect evidence or not. So those are my concerns, that it would be dictating medical practice by non-medical providers. So
we'll see what happens.
But I am all in support of having attention on this really salient issue of, doing something to address the kit backlog, because that's only going to get worse now that we are, as you mentioned earlier, treating every kit as though it were equal and valuable, and with the tracking coming online September 1st, that will be exacerbated, because now the victims will be able to track their kits and they're all going to be valuable. The narrative that gets put out by CNN and the End the Backlog initiatives is that the sexual assault exam is a traumatic, horrible experience, and so they go through all this trauma to get this kit, and therefore this kit is very valuable. We'd like to switch the narrative around that it's not a traumatic experience, first of all, and we don't want to discourage people from having the kits, because I don't think that will be the result anybody wants. But I do agree there needs to be something to kind of dial back this. Every kit is important, and if it does come down to consent, do we really need to test for DNA if there's no disagreement that sex was had? And how you make those decisions is going to be a conversation. So I appreciate that they want to have those conversations.
There would be an appointee from this commission on that commission if the bill passes. And
is that in addition to the same seat, or is that the same?
It's in addition.
Right. But we won't always have the same.
Right.
So The other thing that's happened is that the Senate bill, budget bill, fully funded all of DPS's requests, including for 100 new examiners, which I almost passed out when I saw it. The House side, they didn't fare as well, but that's a lot of new manpower, woman power potentially. So that's
what type of
Every one of them needed.
Yes,
Are these analysts?
Analysts, all analysts.
Oh, well,
Plus
yeah.
other money that they ask, not just DNA, but.
More competition and trying to hire a very few.
Exactly.
Yeah.
But they're getting what they're asking for in terms of support, which is
Yeah.
a miracle, I think.
So to get the colleges to be able to produce people who are
Qualified to do the
interested,
work.
qualified.
The other thing is that I think Senator Hinojosa is gonna file like a cleanup bill for the statute, but that has not yet been filed, so that'll be in front of you next time. I was thinking we should probably reactivate the legislative committee to handle things that come in. Last time that was Pat, Dr. Bernard, and Mark Daniel. Do you guys want to participate again this time?
All systems go.
Okay.
I didn't do anything last time, but yes.
So he's happy to do the same thing?
Just double up this time.
You can sit at the table and have you.
Let me ask, was somebody tracking the file?
We have an app.
That was like.
So if there's a hearing scheduled, you usually attend?
Yes.
I can attend, or if they, sometimes they'll want a commissioner. Sometimes Dr. Bernard will drive down, but if we can in those circumstances, I would ask you to come, Pat.
But you would tell Mark or me?
All of you guys, and it may be at the last minute, we may be calling you and saying they want us there tomorrow, can you come? That's the thing, it's more like, you know how it is during the session.
Hurry up and wait.
Yeah, hurry up, a lot of hurry up and wait. I think you were there till after midnight last time, weren't you?
Yeah.
It was some crazy. But that's the way it goes, you know how it is.
I was as cranky as they were.
You were cranky by the time your turn to talk came, that's true. Okay, so we will reactivate the group. Does either Dr. Downing or Drake want to talk about the governor's training? How that went?
Scintillating. Go ahead,
We had a good time. Nancy brought her notes. She took lots of notes. So we pretty much learned to do the right thing. Don't do anything wrong. Don't do anything stupid.
That was the message?
Yeah, that was
Be
the
ethical.
Yeah.
Follow the law, be ethical. Good.
Don't take any bribes.
You and all of you are a reflection of the governor,
We are.
right? So we must
Don't
behave.
forget it.
And we got 15% off of the gift shop.
And we got 15% off.
I bought a little Peaches, right? Like the little dog. The governor's
Oh, for the dog.
Oh, yeah.
That's right.
Little stuffed animal for Sydney.
Oh,
We attended the Public Safety and Criminal Justice Breakout. So that's where we heard about some of this kit backlog stuff, and from the Human Trafficking Committee person, that was interesting. And then we heard a lot about, when they did talk about legislative stuff, they talked a lot about school safety initiatives and education, which, as everybody's probably heard by now, is going to be a big topic in the legislature this time. Good briefing.
We
Good
have information in your materials from Lori Charles about efforts in quit standardization, and I thought it was really interesting because she included the agenda from the town hall meetings that they've had, which is pretty impressive, all the people that have come to talk about these issues. And there's a nice tracking plan that's included there. You see this? So we got some really good information from her. I think they're still working on things. She has some upcoming deadlines, but this newsletter is nice too. So, well, it looks like a newsletter. It's a one-pager, but it's a good update for where they are at on that effort. Did you want to add anything to that?
We finished the protocol, so that is just sitting, waiting for the legislative session to be finished in case we have to change it. Thought, why publish it now, wait another 20 years? To update it, so.
In terms of recent and upcoming conferences, I am on the ABA Forensic Ethics Task Force. We had our first meeting in DC on Martin Luther King Jr.'s birthday, celebration day, and that should be interesting. They want to do a combined professional responsibility document for everyone in the system, analysts, lawyers, both defense and prosecutors, and judges. And they want to have it basically take a piece of evidence from when it gets started in the process through all the way to the appellate part of a criminal case and basically break it out. These are the roles and responsibilities of these parties at different points in that process, so that there was a perception among the participants that a lot of focus has been put on the responsibilities of forensic scientists, but really we need to talk about everybody's responsibilities at different points in that process, because the scientists can be doing what they're supposed to be doing, and if the lawyers aren't, it doesn't much matter, and vice versa. And so that's the idea, and the people on that are Matt Riedel, who's a retired prosecutor from Wyoming, Suzanne Bell, who's on the National Commission, Jules Epstein, who's on the National Commission, Barry Scheck, myself, God, who else is on there? A judge from New York, whose name escapes me, and a couple of other people. I can't remember everyone, but it's, the usual cast of characters. So we will work on that, and they want to issue as an ABA document, and I said, well, we might want to reconsider that for Texas. I'm not sure that the ABA being the source is the best idea, so we'll go talk to TDCAA, and we'll talk to the Texas bar and see whether they would be willing to embrace something like that, and we'll depending on the substance, and so they seem to appreciate that. And I think all states will need to do that. But I like the idea of putting roles and responsibilities into proper context for everyone who's involved at the different critical points. So that's where we're at on that. Lee's going to the Academy meeting. And I think those are the main things. I'll be giving a talk to the judges in a conference in Georgetown through the Center for the Judiciary. And we're going to start talking about plans for the bench book, the forensic bench book for judges, which is really important. We need to start working on that. So Pat's already helping with that, but I'll be reaching out to a lot of you to talk about how to do that, and do it well. And those are the main things. Am I missing any conferences? I don't think so. Upcoming? I don't think so. So that's where we're at.
All right. Number 20, any particular proposed agenda items we need to include, not just carryovers from this?
We'll build the agenda the same way we always do. If anyone thinks of something that they want to add, just let us know.
I think the next meeting is May 5th.
May 3rd.
Yeah.
What about the July meeting? Do we have a date for first tonight? Do we have a date for July?
We have it, and I cannot remember what it is. I'll email everybody with the results of the doodle polls.
Hopefully by the next meeting, we'll have an appointee from Sam Houston to replace Dr. Houston. Who's enjoying the summer?
Any further public comment? Okay. Meeting is adjourned.
Take a motion.
Do I have to take a motion? I didn't get it.